Open this hearing of the Education and Employment Legislation Committee into the 2024-25 supplementary budget estimates. I'll begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islanders peoples here today. The committee has resolved that written questions on notice should be received from senators by close of business on Thursday, the 14th of November 2024. The committee has fixed Thursday, the 19th of December 2024, as the date for the return of answers to questions taken on notice. The committee's proceedings today will begin with corporate enabling services, cross-portfolio and general matters of employment and workplace relations portfolio. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The Senate has endorsed the following test of relevance of questions to estimates committees. Any questions going to the operations and financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind all officers that the Senate has resolved that there are no areas in connection with expenditure of public funds where any person has the discretion to withhold details or explanations from this Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. I incorporate the public immunity statement into the Hansard. I remind all senators that we continue with our work implementing the standard report. As Chair, I'll ensure that proceedings are conducted in an orderly, respectful and courteous way. An officer called to answer a question for the first time should state their full name and the capacity in which they appear. Mobile phones should be turned off or switched to silent. I now welcome Senator Honourable Murray Watt, Minister for Employment and Workplace Relations. I also welcome representatives for the Department of Employment and Workplace Relations, including Secretary Natalie James. Minister Watt, do you wish to make an opening statement?
I do, Chair. Good to see you all. Thanks for the opportunity to appear here today. First time as the Minister in this portfolio, so I'm looking forward to a very engaging discussion, as we always have in this committee. Under the Albanese government, I'm very pleased to say that more Australians are working, they're earning more and they're keeping more of what they earn. We very much recognise that many Australians are doing it tough at the moment and there's a lot more work to do. But it is excellent to see that as a result of our policies, including in the workplace relations space, more Australians are working, they're earning more and keeping more of what they earn. Our government has overseen the largest increase in employment in a single parliamentary term in Australia's history, 1 million new jobs under Labor, and I congratulate all Australian employers, unions and workers for their collective efforts to achieve this record. Importantly, nearly 2/3 of those new jobs are full-time. The rate of job creation since the election is faster than any major advanced economy on the planet. There's nothing more important than having a well-paid job to deal with cost of living pressures, and delivering those well-paid jobs is what the Albanese government is doing. And under the Albanese government, more Australian women are getting into work than ever before. Since forming government, around half of all growth in full-time jobs have been for women. Female workforce participation stands at a record high and the gender pay gap is at its lowest level on record at 11.5%. More than 347,000 more women are now in full-time work than when our predecessors were in government. Now, claims made by the opposition that Labor's jobs growth represents a surge in bureaucracy are baseless. Private sector jobs represented 75% of the growth in jobs filled over the 2 years from June 2022 to 2024. Labor has created more jobs in what is known as the market sector than any first-term government in recorded history, at 309,000 in just 2 years. That's 89,000 more market sector jobs than the first term of the Abbott government and 125,000 more than the first term of the Howard government, while also creating thousands of valuable, good quality jobs in the care, education, health and other sectors. And I have noted some commentators and some coalition figures making light of the growth of jobs in those important sectors, and I challenge any of them to say whether they prefer to see fewer aged care workers and fewer early childhood care workers among other sectors. We're also delivering a range of workplace relations changes, including increased bargaining, rights for casuals and gig workers, and safer workplaces. We're standing alongside workers to deliver the better pay, more secure and safer workplaces they deserve. Our workplace reforms are getting wages moving again, just like we said they would. We've dramatically increased the minimum wage. 2.6 million low-paid workers saw their pay packets increase because the Albanese government advocated for them in the Fair Work Commission 3 years in a row. We've closed loopholes, ensuring that labour hire can't be used as a wage-cutting exercise and that gig workers and truckies can seek minimum standards of pay. We made gender equality an objective of the Fair Work Act and banned pay secrecy clauses. We've delivered significant pay rises to specific occupations that have been shamefully undervalued for far too long, like up to a 28.5% increase for aged care workers and 15% for early childhood education and care workers. And we've also legislated a fair, objective definition of casual work, streamlined the process for casuals to convert to permanent work, limited the use of unending fixed-term contracts and protected workers from disciplinary action if they exercise their right to disconnect. Our historic Respect at Work legislation significantly progresses gender equality by ensuring women are able to earn a living in safe, respectful, sexual harassment-free workplaces. We introduced paid family and domestic violence leave so no one has to choose between their safety and their pay. We took further action to prevent workers from silicosis by banning the importation of engineered stone benchtops and introduced industrial manslaughter laws after the Coalition refused to act on workplace deaths. And world-leading minimum standards for gig workers and truckies have now been introduced, delivering better pay and conditions and keeping Australian gig workers safe. Now, we need to understand that all of this is at risk at the next election. Under the previous coalition government, unemployment was higher, employment lower, wage growth and jobs growth weaker, and the gender pay gap was bigger. It took them double the time to reach the jobs growth we achieved in our first 2 years and 4 months, and now, at a time that many Australians are doing it tough, Mr Dutton has promised to make things worse by cutting wages and conditions and making it easier to get the sack. I'm sure we'll have a good discussion about all of these issues over the course of the day. Thanks again for their chance to appear.
Good, thank you very much. Ms James, would you like to make an opening statement?
Yes, Chair. Natalie James, Secretary of the Department of Employment and Workplace Relations. There are two matters I'd like to deal with from the outset. The first is to note that Senators Cash and O'Sullivan wrote to me on the 28th of October requesting certain information. You did request it by the 4th of November and we did provide you information. On the 4th of November, I'd like to table both your incoming correspondence and our response so that all of the committee has an opportunity to review that information.
Thank you.
The second issue that I'd like to touch on is slightly more substantial. So I'm sure you will recall that on the 20th of August, the Parliament passed the Fair Work Registered Organisations Amendment Administration Bill 2004. And that bill became an act. It received royal assent on the 22nd of August. On the 23rd of August, the Attorney-General, having been authorised by the Minister for Workplace Relations, made a determination to place the construction division of the CFMEU and its branches into administration. This involved making a scheme of administration. On the 23rd of August, under that legislation, the General Manager of the Fair Work Commission appointed Mark Irving Casey as the administrator of the union. And then on the 3rd of September, Mr Ravbar and Mr Louth filed an application in the High Court challenging the constitutional validity of that legislation and the scheme. This means that the Administration Act in its entirety and the scheme of administration are currently the subject of proceedings before the High Court. Various comments by senators and members of Parliament before and after the introduction of the legislation, including while it was debated in the Parliament and after its passage, are now the subject of those proceedings. I acknowledge the committee may well be interested in these proceedings and a number of issues relating to the events around the introduction of the legislation and the operation of the legislation and the scheme. But noting the challenge, I do anticipate some questions we and indeed some of our agency colleagues may be asked today are likely to directly engage in issues that are in dispute and will be considered by the High Court. And to just give you an example of what those issues might be that are in dispute, the intention behind the introduction of the bill that became the Act and alternatives to that legislation, the Attorney-General's reasons for deciding that making a scheme of administration was in the public interest, any impact the Administration Act and the scheme may or may not have had on political communications, including donations, and the effect of the Administration Act and the scheme on the control of property and assets of the CFMEU. If, when questions are asked by your good selves about these matters or any other matters that touch on issues relevant to the legislation, officials at the table and the Minister will need to consider what we should and shouldn't cover. So we will be a little constrained when we're traversing this subject matter today. The sorts of information we should not disclose include information that may prejudice the impartial adjudication of the proceedings, may prejudice an investigation or possible breach of the law underway, or relate to the deliberative processes involved in the functions of the government. This may require us to take some questions on notice or consider and seek legal advice. We will do our best to engage with you on what you'd like to ask us about here in the room today. But I ask that you just note that we are somewhat constrained and balancing a number of important imperatives here. That is all, Chair.
Thank you. Do you want to hand, is that a statement for us that you could hand up as well?
I apologise, but I haven't quite used the exact words that were given to me, so I don't have it written.
Well, that is actually a problem, Chair. Can we have it transcribed as quickly as possible, please? Normally you would come with an opening statement that you are prepared to table, Chair.
Well, I'm sure it can be transcribed. And just to reinforce what the Secretary said, we will obviously do what we can today to answer questions that any senator has. We realise it's an issue of great public interest, but I think you would understand that there may be some topics that we can't answer because of the fact that this litigation is impending.
Thank you.
Perfectly reasonable.
It's a matter for you, but even the statement you've used to speak from, that may be of some assistance in the meantime. Yeah, if that's yeah.
I think I can probably give you the. So some of what I covered was factual. The elements of what is subject to the scheme. I think,
and therefore not really able to be commented on.
And that might make it easy for people to home in on what you agreed or disagree about on that sort of question. Yep.
Would that
would be helpful. Yeah, would be helpful. At least. Yeah.
Yes. Yep.
Absolutely.
Question on this issue. So, Secretary.
Yes, Senator.
What is the difference between you making a PII claim on the basis of it's going to affect a matter before the court versus what you have just read out?
I would say that I'm just foreshadowing that we're constrained. As you ask us questions, if we need to venture into that territory of a PII claim, we will. So I'm simply foreshadowing that and wanting to give some guidance about the territory that we can and can't go into. The nature of the challenge is very broad. It is a challenge to the constitutional validity of the Act and the scheme.
Senator Brockman, I think what we're doing is actually foreshadowing. It's likely that there will be some PII claims when we get to that topic, depending on the nature of the question.
I think it's a matter of trying to be assistance to the committee, and once we get at least the interim document, that'll be people again focus about what they see as they agree with or don't agree with the questions come up, and then we'll make a decision.
The other option,
if we have to go into committee on occasion, we'll do that too as well.
The other option, frankly, was to wait for questions to arise and then take a series of PII claims. We thought it would be better to be upfront at the beginning of the day about this issue so that people can take that into account in framing their questions. But as I say, we will obviously answer any question we possibly can, but there will need to be some areas that we take PII claims because of the fact this litigation is impending.
And of course that's not uncommon, you know, in situations where matters are before the courts.
Yep.
As everyone, all the senators I'm sure are aware.
That's right. Well, happy to proceed and then we'll deal with it as it comes up.
Yep.
Thank you, Chair. And just confirming, Minister, you have given a commitment to the Senate committee, amplifying obviously the Secretary's opening commitments, to the effect that you will answer whatever questions you can. So to be clear, I'm not going to be asking about legal matters, the subject of the constitutional debate. I will be asking about government policy and operational matters, and I would expect an answer to the question. So my first question is to you, Minister. Why was the CFMEU placed into administration?
Well, I think that's exactly the type of question we can't answer because it goes to the points that are in discussion in
you
the High Court litigation.
You put a bill into the Parliament. There was a reason you put the bill into the Parliament. I'm asking about the policy position behind that bill. That is my question. It is not about the legal issues. It is not about the case at hand. It is about the government policy in relation to this piece of legislation. Well,
I guess I just seek some direction from you, Chair, as to whether this is a cross-portfolio matter. I had expected that we would probably get into these issues when we get to workplace relations, so happy to take your guidance on that.
Look, I think we're prepared to. Let's make a decision now about what we're doing with this particular matter. And if you put a proposition to us regarding the capacity to answer that question or not, which you sort of have already indicated to the question that's being asked, and then we might try to deal with it now if that's convenient.
Well, I guess the issue is, I imagine that the issues regarding the CFMEU will be a fairly extensive topic for discussion and questions today, including from senators who are not currently here. I'm expecting, for example, questions from the crossbench. I would suggest that matters to do with the CFMEU, whether it be the litigation or otherwise, are better dealt with in workplace relations, and that we deal with cross-portfolio matters here, as we have done in previous committee hearings.
Can I? If there's a different view, we might just have a brief suspension, so that way we can just sort of deal with it.
I think, like, if it was going to be one or two questions, fine, but I think this is likely to be a lengthy session from both the opposition's perspective, possibly the government's and the crossbench.
Chair.
Yes, to Deputy Chair,
meeting,
Senator O'Sullivan.
If we need to, but before we do, I think the point of this, to the point that Senator Watt is raising, this is a question of the Minister and the Minister's knowledge of why we went into administration with this. So it's not for the Department, it's for the Minister.
But these are questions specifically for the Minister.
But you'll be asking...
Can I sorry, just, I might just ask Senator Cash just to add the additional to Senator O'Sullivan, then I'll ask the Minister to respond.
Sure.
As I said, we're exploring this in detail, in particular with the Department in Outcome 3. However, these matters are squiggly cross-portfolio matters specifically to the Minister and in particular in relation to his opening statement. They are not to the Department. They are squarely to the Minister.
Well, if I can reply, I don't think the fact that a question is being put to a minister makes something cross-portfolio. I answer questions as the minister or representing minister over the course of the day and night in estimates, but we tend to answer them in the relevant outcome. And I would argue that I'm happy if we spend many hours on this topic if that's what the committee wants to do, but I think we're better off following the program, and now is about cross-portfolio matters, which tend to be usually matters involving the running of the department.
Chair.
Can I? Yeah, sorry, yes, Ms. Jones.
So, in order for us to support the Minister field questions, particularly about the scope of what is and isn't, where the boundaries of our constraints are, he does need to be supported by the department. You might have observed that as Senator Cash began answering her question, we did change the bench. These are the representatives of Outcome 3, and they are ready to answer questions, but they are scheduled to be on at 10 for workplace relations for a number of hours, and I would prefer that we deal with this in the outcome. It's not a cross-portfolio issue.
We might just suspend for a moment just to have a conversation, so we'll go outside.
Thank you, Chair. Thank you all for being here today. Here we go again. My questions are very short. They're involving Coal LSL or your interaction with Coal LSL. Is it true that the Coal LSL annual report for the financial year 2022-2023 states that no compliance issues were reported to the Minister?
I know Coal LSL will be appearing later tonight. Yeah. I'll just check whether we're in a position to answer those questions now, or whether we might need to deal with them later.
Senator Greg Manning, Deputy Secretary of Workplace Relations Group in the Department. We're just waiting for one of our colleagues to come from the waiting room downstairs, Senator. But
Chair, could I just clarify? Has the committee dismissed our cross-portfolio?
No. We've just got these questions down that are in cross-portfolio, and then we're going to get to that after Senator Roberts. But I'm indicating that is what is likely to happen, but I just want to go through the steps first.
Okay. And so this is the Outcome 3 Workplace Relations Group who have joined us at the table.
We continue?
We're just trying to be efficient with time, regardless, because of the conversations with Senator Roberts, rather than having a long, drawn-out conversation about it. So thank you for being understanding.
Do you need the question repeated?
No. Okay. Just while our colleagues join us from downstairs, Senator, I don't know the answer in relation to the annual report completely in relation to any qualifications, but as I understand it, Senator, there was none in relation to Section 83 of the Constitution.
Okay, thank you. I'd now like to take you to page 101 of the Department of Education and Workplace Relations Annual Report 22-23, and I quote the following. Coal LSL has identified it may have mistakenly received levy payments from entities that do not meet the definition of employer for the purposes of the Coal Mining Industry Long Service Leave Administration Act 1992. If so, payments... So I think that should be the end of the quote. If so, that means payment of amounts equivalent to the levy by the Department to Coal LSL in relation to those entities would likely have been made in contravention of Section 83 of the Constitution.
Yeah, and that was the point I was getting to, Senator, in the sense that because of the way the money is collected under that scheme, that a levy that's collected is done by Coal LSL acting as an agent of the Commonwealth, because only the Commonwealth can levy taxation, and then goes into consolidated revenue, and then the same amounts go back out to allow Coal LSL, no longer acting as an agent of the Commonwealth, to pay money for the purposes for which it exists. So in the circumstances of Section 83, it would technically be the Commonwealth, as represented by the Department of Employment and Workplace Relations, who, if there is a breach, has committed that breach. So that's why it's in our annual report.
Thank you. And I guess I'm concerned because they collected... what you've said in your report is accurate, I presume. Coal LSL has identified it may have mistakenly received levy payments from entities that did not meet the definition of employer. So they shouldn't have taken that money.
My understanding, Senator, is there is a small small number of employers who are not national system employers, and so for whom the levy shouldn't have been collected from.
Yeah, thank you. Coal LSL has assured the Department that it is conducting further investigations to confirm how many entities may have incorrectly paid the levy and quantify any corresponding amounts that have been paid by the Commonwealth without a valid appropriation. That's a quote from your report, apparently. So it looks like the money has been collected from individual entities by Coal LSL, sent to you, and then it's gone back as a lump sum. Is it true that the information relating to the coal, you have confirmed that the information relating to Coal LSL and the due annual report is correct? So
that's our understanding, Senator. But I might just see my colleagues who have now been able to join us have anything to add to that, because as I understand it, the issues are still being worked through between the Department and Coal LSL.
Senator, I'm Stuart Kerr. I'm the Assistant Secretary from the Bargaining and Coverage Branch in our Workplace Relations Legal area. So what my colleague Mr Manning has said is correct. So our understanding is that Cole LSL may have mistakenly received levy payments from employers that do not meet the definition of employer under the scheme. Flows, so essentially the amounts collected by Cole LSL flow in and out of the Consolidated Revenue Fund through the department. And that's a very, that's the standard approach for taxation revenues that all go into CRF. And as a result, that's led to a Section 83 breach that we have disclosed in our annual report. So all of that's correct.
Thank you. I find Mr Manning's usually pretty correct. So.
Indeed.
Thanks. And I'm always appreciative of the confirmation I got it right today. So it's good to know.
And you weren't even nervous while he was saying it. You weren't waiting on the edge of your seat. How did the department become aware of these serious issues when it was not identified in Cole LSL's annual report?
I believe we became aware of it in the context of considering some legislative amendments to the scheme.
Thank you. When was the breach first detected?
I believe it was in April 2023, Senator.
Who identified the likely breach of Section 83 of the Constitution, and was it Cole LSL or DUA?
No, it was the department.
What is the outcome so far of the investigation into this matter?
So, Senator, the department's been working with Cole LSL to seek to clarify the scope of the problem. I understand that Cole LSL has undertaken some assurance activities to review the current active registered employers to identify affected entities, which is not an entirely straightforward
No, nothing much is straightforward in Cole LSL.
No, indeed. But as part of that review, Cole LSL has updated its records and introduced some new procedures to mitigate the risk of new ineligible employers being onboarded. From the department, and probably Cole LSL is best placed to speak to that later.
We will be tonight.
Indeed.
Yeah, thank you.
But from the department's point of view, we're working closely with Cole LSL and other relevant Commonwealth agencies to try and clarify the scope of the issue and settle a way forward to resolve it.
So you're still clarifying the scope?
That's correct.
Thank you. How was it detected? You said while doing some legislative enhancements?
Yeah, so the department was considering some potential legislative amendments to the scheme.
To the Cole LSL legislation?
Yes, correct.
What year? 23?
2023, yeah.
Okay.
And in the course of that, we were considering the operation of the scheme and uncovered this issue.
Well, thank you for your diligence. What checks and balances does the department have in place to confirm that the payroll levy taxes collected are true and correct?
So the department has obtained legal advice in relation to this matter, but to a large degree we rely on the information provided by Cole LSL with respect to the amounts of levy collected. The Commonwealth role here is really, as we're required to do under, I think, Section 36 of the Cole Administration Act, to withdraw amounts equivalent to the levy collected by Cole LSL out of CRF and to pay it back to them, with the effect being that the amount collected ultimately ends up in the Cole LSL fund. So from the department's point of view, we rely quite heavily on the information provided by Cole about those amounts.
So what is DUA doing to remedy this breach? I know you've said you rely a lot on Cole LSL, yeah. I understand that.
In terms of the consequences of a Section 83 breach, Senator, this is dealt with in some guidance put out by the Department of Finance. And essentially, what an entity is required to do if concerned that an appropriation may have been spent in breach of Section 83, is to conduct an appropriate risk assessment, which may include legal advice, which we have done, and also to undertake a Section 83 breach disclosure, which we've also done in the annual report that you just referred to.
But there's not much you can do in regard to preventing it happening again.
I think I'd say, Senator, we're working closely with Cole LSL and other Commonwealth agencies, including the Department of Finance, to confirm which employers and employees have been affected, and the options for addressing these.
Okay. Perhaps, Minister, was this, I'm asking for an opinion now, was this disaster another example of Cole LSL's incompetent at best, or an indication of the loose way that Cole LSL uses other people's entitlements? And that has not started since Labor came into office. That's preceding Labor's coming into office.
Well,
I'm heartened by what Mr Manning and Mr Kerr said.
Yep. I think technically we can't give opinions, but...
Ministers can, that's why I asked the Minister.
Me have opinions? No, look, we support the work of the Cole LSL agency. Obviously, the department's taken you through a range of issues that are being considered, and we're supportive of that work as well.
Well, it seems to be due has done its due diligence and done the job. So I'm just very concerned because Cole LSL, at its core, the key issue in Cole LSL, we exposed that in 2019, took a long time for the government to say, OK, we finally agree with you. Took a lot of things to come out, but Cole LSL, I'm not sure that it's been fixed yet. Thank you, Chair.
Good, thanks. Thanks very much. Just if we'll go to outcome 3 in one moment, but if we can, when we go to outcome 3, I'll still need the department to be here to answer some questions on wage underpayments, and we might deal with that first when we go to outcome 3.
It's done, and then we can move to.
Yep. Good, thanks. So now go to outcome 3 with that proviso. Thank you. And I'll go to Senator Cash.
Thank you very much. And Secretary, in terms of the underpayment matter that we have been pursuing at varying estimates, I note in the department's answer to QON SQ 24000775, it says that 201 staff were underpaid. Is this figure correct as at today?
I'll just wait till I have that question on notice in front of me, Senator.
Well, tell me, how many of your staff were underpaid?
I'm just referencing, I just want to make sure that the date of that, I'm referencing the right and most recent information. Thank you. From 3rd June. Yeah.
Good morning, Senator Bridie Cosgrove, Assistant Secretary, People Branch. I can confirm that that figure is correct, 201 employees.
201 employees. And is that the final figure? I note that in the letter from the Secretary to Senator O'Sullivan and myself, it says the matter was finalised on the 11th of September of this year.
That's correct.
And when we say finalised, what does that mean?
We received a notification from the Fair Work Ombudsman's office that they consider the matter finalised.
And did the Fair Work Ombudsman provide a written report?
They provided a written letter.
Are you able to table that letter for the committee, please?
I don't have a copy of that with
Are
me.
you able to table it? Take it on notice to table it?
We can take that on notice, Senator. I'm just noting that it's the Fair Work Ombudsman's letter to us.
Yes. So in
I
other words,
want to
you
make
can
sure
table it as it is your letter.
Yes, but
Yes.
I would normally, prior to tabling a piece of correspondence, want to check that the author of the correspondence was comfortable with that.
What were the Fair Work Ombudsman's findings in the relation to the department?
The Fair Work Ombudsman advised that there would be no further action taken at this time. They did, however, note that we need to do 3 things. Broadly, we need to ensure we have current appropriate processes and systems and controls in place, that we regularly review those systems and make sure they remain up to date, of course, with changes to any employee entitlements that may arise. And they note that we need to ensure that we have the appropriate risk oversight, controls and expertise internal to the department to prevent and detect any issues as they may occur.
So, Secretary, can I confirm what the Fair Work Ombudsman is saying in relation to the 201 individuals that were underpaid by the department? Effectively, despite everything that occurred, the department did nothing wrong, no one is being held responsible and no action is being taken against anyone. Is that correct?
No, Senator.
Why is that statement not correct?
It doesn't correspond with Ms Cosgriff's evidence.
So what did the department do wrong?
So the department underpaid 201 of its staff, and as we've traversed in these hearings before, that's something that we should have got right, and we apologise for. The matter, we have now fully remediated the people impacted by the misinterpretation of entitlements under the determination made under the Public Service Act to cover the entitlements of people in the new department that was created. That's now been rectified. And so the Fair Work Ombudsman has resolved the matter.
Just in terms of fully remediated, what was the final underpayment figure?
Senator, that's consistent. The final figure is consistent with our response to our letter dated 4th of November.
Could you just read that for the Hansard record?
Yes, I will. The final underpayment total was $243,064.31.
And can I ask, in terms of the total legal fees expended in relation to this matter, what was that?
$116,000, $426.17.
And that was in relation to the two legal firms? There were two legal firms, I understand?
There was three.
Three legal firms?
Which we traversed at the previous estimates.
But the total expenditure in relation to all three was the $116,000?
That's correct.
Was there also an actuary involved at one stage?
Not to my knowledge, no.
Okay. How many staff members in the department were interviewed by the Fair Work Ombudsman?
I don't believe anyone was interviewed. We had some meetings with the Fair Work Ombudsman, but none would be characterised as formal interviews.
As far as we are aware.
As far as we're aware.
So, Secretary, were you interviewed by the Fair Work Ombudsman in your role as Secretary of the Department that underpaid 201 employees?
No, Senator.
You were not? So despite an underpayment of 201 employees to the value of $243,064 and some cents, the Fair Work Ombudsman did not take it upon themselves to interview you. Is that your evidence?
Yes, Senator, it is, as I've just answered.
Is that standard practice if it were a business who had underpaid 201 employees?
That would be a question for the Fair Work Ombudsman.
And I will be absolutely pursuing that with the Fair Work Ombudsman. Are you aware if anyone in your department was interviewed in relation to the underpayment of the 201 employees?
Ms Cosgriff's already answered that question, Senator.
So the answer is no.
We are
no
not
one
aware.
was interviewed in relation to the underpayment. In fact, I calculated it out. If you look at the calculation, it's around 4.7% of the department's workforce were underpaid, and the Fair Work Ombudsman has chosen not to interview. I find that personally quite extraordinary that that did not occur. Can you guarantee that all affected staff members have been reimbursed and that there is no chance that any further staff members have been underpaid?
I'm satisfied that this matter was concluded as of the last time we spoke about this in June, and yes, I am satisfied that the matter is resolved and impacted staff have been back paid appropriately, including with interest, as per the figure that Ms Cosgriff referenced before.
What was the date of the letter from the Fair Work Ombudsman to the department?
Just to clarify, the letter finalising.
The letter that you referred to in relation to the Fair Work Ombudsman, I said it was a report. You said you received a letter from them.
11 September 2024.
11th of September 2024, so approximately 2 months ago. In relation to the 3 issues identified by the Fair Work Ombudsman Secretary, what steps have been taken to enact the further action?
Thank you for your question, Senator. We did traverse at last estimates that we had already conducted. Our internal audit team had worked to frame up an audit, and I think, might have tabled that in a question on notice to you. That was one part of the ongoing work that we'll be doing to ensure we're compliant with our obligations when it comes to employee entitlements, and I'll ask Ms Jenkins to elaborate.
Senator Deborah Jenkins, Deputy Secretary from the Corporate Enabling Services Group. So in addition to the internal audit that was undertaken specifically to look at this matter, we also, as part of our rolling internal audit program, and our Chief Internal Auditor is available today if we want to discuss, we have a rolling series of audits that we put on. We have one that is to, I think, finish in March 2025, which is to look at reasonable working hours. We've also engaged with the Service Delivery Office. So our payroll is processed by the Service Delivery Office. They have other internal audits and other audit procedures, which we then get copies of. We've also, Senator, undertaken discussions with managers, because very important to this is managers understanding obligations and making sure staff have recorded that. So this is something we've taken very seriously. So there's an element of education for the managers, internal audit programs, and a continuous program of improvement around our processes and procedures for our payroll for our staff.
Can I just ask, when do the new laws about criminalising wage underpayments come in?
Senator, that's a question for outcome 3, but I think we can probably...
Is that a joke? Seriously, you're the Secretary of the Department. When do the laws commence?
She was about to give you some more information.
We don't need to make excuses in terms of...
I'm just going to check to make sure that I get it right, because the commencement of those provisions, I think it's different for small business, and so Mr Manning will ensure that our evidence with respect to this is correct.
It's the latter of 1 January 2025, or when the Small Business Compliance Code's in force, Senator.
So at this point in time, the department is also subject to the wage criminalisation laws when they commence on the 1st of January 2025?
When they commence, all employers will be subject.
And that includes
to
the
those
public
laws.
service?
It does.
That includes the public service. Minister, in relation to the evidence that the Fair Work Ombudsman didn't interview anyone in the department, despite the evidence over several estimates now, 201 of your employees were underpaid, in excess of $243,000. Do you agree that this undermines the government's message on wage underpayments when you have an agency exonerate your own department without even interviewing the Secretary?
Well, I think it's really for the Fair Work Ombudsman to explain in detail the nature of their investigation and what contact they had with the department. I'm not in the habit, Senator, of using my megaphone to attack independent agencies of government.
You're the Minister in charge of the Fair Work Ombudsman. You're the Minister in charge of this department. You have sat through several estimates now in which you have heard about an underpayment issue. This is a government that has made a big song and dance about the criminalisation of wage theft laws. You have the perfect example of where an underpayment has occurred. I would have thought you would want the Fair Work Ombudsman, quite frankly, to lead by example. If a large company had underpaid its workforce, 201 employees, and the CEO wasn't interviewed, I'm sure that you would have an opinion on that.
Yeah, I think if you go back to what I've seen in previous estimates hearings on this matter, you'll see that I've said words to the effect that our government expects all employers, whether it be public sector or private sector employers, to pay their employees the rates they're entitled to. So it is disappointing when you see public sector agencies not do that. Our laws that we've passed, that I think you voted against, criminalise intentional wage theft. My understanding is that this is not a case of intentional wage theft. And the Fair Work Ombudsman have obviously undertaken an investigation that they can explain to you later. But absolutely, we want to see all public sector agencies pay employees what they're entitled to.
An agency that you are in charge of has exonerated the department you are in charge of, and you're not concerned that the Secretary was not interviewed in relation to the underpayment of 201 employees, 4.7% of your workforce.
Well, exonerated is your word. My understanding is what has happened here is that the Fair Work Ombudsman has finalised its investigation. The department has explained its understanding of why they've finalised that investigation, and the Fair Work Ombudsman will be able to explain that when they appear later tonight.
In terms of the department's history with underpaying the 201 employees, since becoming minister, can you take me through the discussions you've had with the Secretary to ensure that underpayments do not happen again?
We've certainly discussed that matter, and in fact, I think quite recently I received a written brief from the department advising me of the finalisation of this matter as well. It is something that I've checked in on both directly with the Secretary and with my office, who then communicated with officials in the department. You know, I'm obviously familiar with this issue, having attended these estimates in the past, and I was keen to see it resolved as quickly as possible, and I'm pleased that it has now been finalised and that people have been paid back what they deserve to be paid.
Did you apologise to the staff for the underpayment as the minister?
No.
No, you did not?
No.
Is there a reason that you didn't apologise to the staff?
Well, the matter has been fixed.
But they were underpaid?
They were.
They were underpaid?
The departmental secretary has managed this issue, as is her responsibility. I'm satisfied that the departmental secretary and the department as a whole has now addressed this. But again, I've made comments today, I've made comments before that say that all employers should pay employees what they're entitled to.
And in this case, that unfortunately did not occur.
Correct.
How many industrial relations experts are there in your department, Minister?
I'm not sure the exact number, but I'd say quite a few.
Oh, well, I'll ask the Secretary then. How many industrial relations experts are there in your department?
Senator, we have a number of people who work in the workplace relations group, many of whom you would describe as industrial relations experts, but I can tell you the people in the group, but the expertise would be a slight subset of that. Would you like us to give you the figure of...
On notice you can, that would be appreciated. Mr Manning, you stated that the wage criminalisation laws or the wage theft laws come into place on the 1st of January 2025.
If the voluntary small business wage compliance code has been, is operative at that time.
Yes. So, is it operative?
No, it's in the final stages of consultation, so it's on schedule to be operative by that time. So when do you expect? So you expect it to be operative as of the 1st of January 2025? As we sit here today, I do, Senator. Yes.
Sorry, what was that?
Yes, that's my understanding as of today, Senator. I said as I sit here today, I do.
So what would be a delay in that?
Well, it's got, the proposal is to go through one final stage of consultation. It might throw up views about how it could be done differently, although there has been quite a bit of consultation by the Fair Work Ombudsman already, so I wouldn't expect that. And then the instrument is made by the Minister.
In the event that it does not commence or it is not ready for the 1st of January 2025, what happens?
The provisions don't commence, but Ms Yanchenko can take us through that further if you like.
Workplace exploitation. So Mr Manning is correct. If the wage underpayment compliance code is not declared by the Minister, the wage theft offence cannot commence.
Minister, can you guarantee that this will commence on the 1st of January 2025?
That is 100% my intention.
Your intention. So there's no guarantee. It is merely an intention.
Mr Manning has indicated that, you know, something could come completely out of left field on this, but there has been extensive consultation with stakeholders today, and it is 100% my intention to have it start on the 1st of January.
well, as I said, that is an intention. Businesses, as you know, need certainty. They continue to ask when this is going to be
1st of January 25.
And so we will wait and see whether or not the intention becomes the reality. Minister, would you expect a private sector employer who fixed an underpayment, in other words, there was an underpayment of 201 employees, to apologise to the employees who were underpaid?
Yes, and my understanding is that the department, as the employer, has issued an apology to the staff.
Can we go back to that apology then? When was that apology issued, Secretary?
Senator, I'll need to check because we have traversed.
Is that the video message that you gave to staff?
There was a video message, and when you queried me at the table in one of our encounters on this issue, I apologised at the table, and I think I might have just apologised again. But I think that I consider that I have made it very clear to all parties that this underpayment shouldn't have happened, and that we made sure that we prioritised the way in which we went about fixing both the underpayment retrospectively and also getting a new determination in place to remove the challenges we were encountering with the interaction with the Public Service Award.
But ultimately, no one in the department has been held responsible for this matter. Is that correct?
Well, I'm responsible.
But you have not been held responsible for the underpayment of 201 employees in the amount of $243,064.
I consider I have, that I am responsible and that I have taken responsibility.
Have you faced any consequences as a result of that? Have you faced any penalty or adverse action?
I have faced consequences, as I should.
Please take us through those consequences.
As a secretary, encountering this situation is not an easy one, and so I would say the consequences of the fact that the department didn't get this right is something the whole department has had consequences from, in terms of the work that we've done and, you know, potentially the trust that we might have eroded with our people, which is something that I'm very conscious of. If you're asking, has there been... So you consider that
a consequence of an underpayment?
Well, you asked about consequences. If you're asking about regulatory consequences...
Yes, regulatory consequences.
There have been no regulatory consequences as yet, as far as I'm aware.
Okay. And any penalties?
No regulatory action has been taken against us.
Any regulatory adverse action taken against you?
Senator, I think we've outlined the response of the regulator already. They noted the work we did. They investigated and interrogated it, I assume to their satisfaction, and the matter is resolved without a regulatory outcome.
So the consequences were that you and the department were potentially embarrassed, but there were no regulatory consequences, there were no regulatory penalties, but potentially the consequence is the staff now don't trust you. Is that it?
Well, can I make the point, if this had been a private sector agency or a public sector agency after our laws come into effect on the 1st of January, there would have been no regulatory consequences either, because it's an unintentional underpayment. Our laws, because I know what you're trying to do, you're trying to conflate what's happened here with what would happen under our laws.
Please don't put words into my mouth, Minister.
Well, our laws
that is not what I am doing.
Our laws are directed towards intentional underpayments and criminalising that. If that were, I would be horrified if that ever occurred in a public sector agency, intentional wage theft. But if it did occur, then of course the same regulatory consequences would apply to a public sector employer as they would to a private sector.
We're exposing the double standards here. You lecture small businesses about paying their staff correctly.
I lecture them. Well, I don't lecture people. I don't lecture people.
Your attitude into your own department is to give it a free pass.
Well, now who's putting words into people's mouths? I haven't lectured people. I have made the point that it should be a crime for employers to deliberately underpay their workers. Again, my recollection is that you voted against that law, so that's obviously not a view you share. You must think that it's okay for employers to deliberately underpay their workers. That is not the Labor Party's position. It is not this government's position. And if a public sector employer were to do that, there would be drastic consequences, just as there should be for a private sector employer.
And so despite the Department of Employment and Workplace Relations, which has multiple members skilled in industrial relations, they are still able to get it wrong.
Yeah, we recognise.
Exactly.
We recognise. Hang on. We recognise that employers from private sector, public sector, from time to time, unintentionally underpay their staff, and our laws are not directed to that issue. And in fact, the code for small business, which we're happy to talk about, is designed to deal with exactly that issue, to ensure that small businesses who accidentally underpay their staff don't face those kind of consequences, and that assistance is provided to small businesses to avoid them running foul of the law. So we recognise that there are employers who accidentally underpay their staff. We're not talking about criminalising that kind of behaviour. What we're talking about, and you didn't vote for, was criminalising employers who deliberately underpay their staff.
It's 10 o'clock, Chair.
Good, thanks very much.
Yep, for the
Good,
next.
thank you. Good, thanks. So just to be clear, we're fine to let the department across portfolio go, and we'll go to outcome 3 formally, which we're formally doing anyway. Thank you. We might just suspend for just a couple of minutes, just while waiting for people to move out of the room. Good, thanks. Senator Cash.
Okay. If I could now turn to questions in relation to the CFMEU. Minister, why was the CFMEU placed into administration? And again, I'm asking the policy intention of the government.
Yeah, well, we're just being joined at the table by some of the department's in-house lawyers who are obviously intimately involved in the High Court litigation. I'm sure they'd be happy to elaborate on this, but that question goes directly to the heart of the issues that are being considered by the High Court in a couple of weeks' time. I'll take a, if you'd like me to take a PII or take it on notice with a view to a PII, I'm happy to do that.
Let's be very clear. Are we talking...
Just to assist...
Yep.
Sorry, Senator Cash, so I just do it once and try to avoid doing it more than once. Just to, for those listening, on the 19th of May 2005, the Senate has a grounds for public interest immunity claims. And I just draw people's attention to accepted grounds on the committee, item 1, regarding prejudice to legal proceedings. The second sentence in that particular statement says that production of information to a committee could create material which, by reason that is unexaminable in court proceedings because of parliamentary privilege, could create difficulties in pending court proceedings. So I just want to remind everybody of the sensitivity of the matters that we're about to discuss, and they could be mindful of, when asking questions, to take that into consideration.
So again, Minister, I ask you, why was the CFMEU placed into administration?
Well, I think procedurally the best way for me to deal with that is to take that on notice.
And on what basis would you possibly take that on notice? This is a government that has made a huge song and dance about placing its biggest financial donor into administration, and you are unable to answer a very simple question as to why.
Well, I'm not sure, Senator Cash, whether your desire is to see the Commonwealth lose the High Court case that has been brought by former officials of the CFMEU, but thank you for recognising that this government has taken the strongest possible action against the former leadership of the CFMEU, something that you never did while you were in office. But having done that, we have no intention of jeopardising that case by making statements which could affect its adjudication. That's the advice from our lawyers, and I intend to follow that advice. If it helps, we'd be happy to get Ms Godden, the Chief Counsel of the Department, to explain in more detail what we can answer, what we can't answer. But the approach I'm intending to take today is to be helpful to the committee, but not reckless. I'm not going to be reckless about a High Court case that is about to be heard.
Well, let us be very clear. Under the Sub Judice Convention, the Senate will avoid debating an issue if it could involve a substantial danger of prejudice to proceedings before a court, unless there is a public interest to the contrary. I would argue, Chair, that there is definitely a public interest to the contrary. The practice is very clear that prejudice to proceedings means either that there will be a substantial danger that the court will be influenced, or that there will be a substantial danger the question could undermine public confidence in the court's rulings. And I will submit, Chair, that there is no reasonable basis to conclude that this question, which is about government policy, could influence the High Court or undermine public confidence in the ruling. And in fact, it is the opposite. A decision to block the Minister from answering this question would, quite frankly, significantly hinder this committee's ability to perform its scrutiny functions. It would be an inappropriate and improper restriction on the powers of the Senate. Chair, I'm going to ask for a clear ruling as to whether or not this question is in order, and if not, the reasons why asking this question would influence the High Court, or how it would undermine public confidence in a ruling the High Court could ultimately make, given that this is the policy intent of the government's legislation that I am asking about. And can I be clear, a policy intent that the Minister himself has made many public statements about whilst the case has been on foot?
Chair, could I just say something before you rule on that? I mean, if it is the case that Senator Cash thinks that I've made many statements about the policy intention, then that begs the question why she needs to ask about it here. But just park that. Maybe it would assist you in making your ruling on this if I get Ms Godden to explain in a bit more detail why our concern is that answering those types of questions could influence the High Court. So maybe Ms Godden could give you some more information on that.
Thank you. That would be of assistance to the committee. Ms Godden.
Sarah Godden, Chief Counsel, Workplace Relations Legal Division. Thank you, Minister. Thank you, Committee. Broadly, the proceedings challenge the constitutional validity of the Amendment Act and the scheme of administration on 4 grounds. The first is that both are unsupported by any constitutional head of power. The second is that both are inconsistent with the implied freedom of political communication. Third, that they are contrary to Chapter 3 of the Constitution, which I could broadly summarise as a separation of powers argument. And fourth, that certain of the provisions inserted by the Administration Act authorise the acquisition of property other than on just terms within the meaning of Section 51, paragraph 31 of the Constitution. This means that the proceedings will cover not only the constitutional basis for the legislation as enacted, but alternatives to the legislation and the scheme of administration determined, including the proportionality of the measures that were put in place. The intention of the government in enacting the scheme and the intention of Parliament has been squarely put by the plaintiffs as at issue in the case before the High Court. The protections afforded by the Parliamentary Privileges Act are also squarely in contention before the High Court. Discussion at the Senate Estimates Committee today, I understand, is protected by the Parliamentary Privileges Act. However, this is likely to be determined by the High Court. Already within the litigation, we have seen that particularly comments made by members of Parliament have been put at issue in the proceedings, and those comments are directed at the intention behind of the Parliament in passing that legislation. Discussion before the committee today in a way that, subject to a determination of the High Court, may not be able to be examined by the High Court could prejudice public confidence in the administration of justice. If the High Court rules that parliamentary privilege does not attend to certain debates before Parliament, or potentially even the debate today, it could also go to the arguments that are put by the Commonwealth in those proceedings. We are very concerned to ensure that the Commonwealth defends those proceedings appropriately and consistently with the legal services directions. I would draw the committee's attention to also in those proceedings, once we stray into the constitutional arguments before the High Court under the legal services directions, we would be very careful not to disclose any legal advice without getting the consent of the Office of Constitutional Law as provided by those directions. That is also something that may go to the public interest, as successive governments have maintained that legal professional privilege is the product of a balancing act in the public interest and is maintained due to the overwhelming or outweighing of the public interest in the confidence of the administration of justice. I will say that in relation to comments made today, there are perhaps particular concerns about discussion around the intention behind the introduction of the bill that became the Administration Act, the alternatives to the passage of that bill, or alternatives to the scheme of administration that was made. These also go to the Attorney-General's reasons for deciding that making the scheme of administration for the division was in the public interest. They go to any impact that the Administration Act and the scheme may or may not have had on political communications, including but not limited to donations and campaigns. They also go to the effect of the Administration Act and the scheme on the control of the property and assets of the CFMEU, as this is put squarely in the Chapter 3 separation of powers argument and argued to be punitive measures only able to be imposed by a Chapter 3 court. I trust that going over these in a little bit more detail, explaining what is at issue in the case, will assist the committee. The Minister is correct. The government has recorded its intention in a number of public documents, and I would also, to the extent that is helpful and may assist, could draw the committee's attention to the explanatory memorandum for the Administration Act, and in particular paragraph 11 of that revised explanatory memorandum, which records the government's view that the legislative amendments proposed by the bill are urgently required to ensure a decision can be made as swiftly as possible about whether to put a scheme of administration into place. Goes on to say that the legislative amendments in the bill seek to protect the interests of members of the division, and if a scheme of administration is determined, would seek to help return the division to a position where it is democratically controlled by those who promote and act in accordance with Australian laws, including workplace laws. The proposed legislation is necessary to end ongoing dysfunction within the division and to ensure it is able to operate effectively in the interests of its members. Trust that's of assistance to the committee.
That's of assistance. Senator Cash, did you?
Yeah, Chair, this is now an incredibly serious issue that is now going to the ability of the Australian Senate as a House of Review exercising its functions. So in the first instance, I want to make some comments in relation to what Ms Godden has placed on the record. Ms Godden, were you reading from a document?
I was reading from a variety of notes and documents, Senator. Obviously, the revised explanatory memorandum.
So there's no one document in front of you, so we can get the transcript right. So in the first instance, Chair, I do want this now placed on the record. What Ms Godden has now outlined is a series of technical challenges to the scope of the Commonwealth's constitutional power. The government's policy position and intent are not determinative of any of those grounds. It is the scope of the Parliament's power and the structure of our constitution that is in issue, not what the government of the day intended. Ms Godden has also asserted that discussion could prejudice the administration of justice. However, she has not offered any evidence or justification. The Senate has never, to my knowledge, refused to exercise its constitutional functions as a House of Review, because that is what we are. We are, under the Constitution, a House of Review on the basis that a future High Court may make a ruling. This is, and I want this on the Hansard record, a hugely significant issue. Any restriction here would massively impact the power of the Senate to exercise its functions. Not just today, we are about to set a precedent going forward. If these questions are ruled out of order, it does effectively set a precedent, meaning that any contested matter could not be the subject of committee questioning merely because it may be considered in a court. And, Chair, I would ask you to seriously consider the impact on the ability of the Australian Senate to undertake its constitutional function in making any ruling.
Could I just, Minister Watt, and I just indicate that we'll just be having a committee meeting as soon as we finish this.
Just very briefly, Chair, the only thing I'd say in response to Senator Cash is that I can certainly remember being in opposition asking questions that ministers and departments didn't answer on the basis they may influence legal proceedings that were on foot. So for Senator Cash to portray this as unprecedented is not correct. And you yourself have read from the standing orders, which make very clear that it's completely legitimate to claim a public interest immunity for this very reason.
Good, thank
Chair,
you.
can I just be clear on that, though? Everything we say in the Senate chamber is privileged, as you would know, Senator Watt, and cannot be put in evidence before a court.
Well,
Chair, I would just like to add.
Can I just suggest that rather than us having a toing and froing, which we could do for quite a considerable amount of time, the committee has a meeting, separate meeting, and then I'll come back and make a ruling.
Sorry, Chair. You're going to do that committee meeting now?
We're going to suspend
Okay.
this now. And
No,
then,
right.
yeah.
Okay.
Just in light of what's been put to us in the conversations that, the matters that have been put to the different parties by the committee, and in response from the department and from the minister, I'm very mindful of what I had spoken about before and regarding the 19th of May 2005 grounds for public interest immunity claims. Regarding the question that's asked, I might just ask Senator Cash just to ask the question so everyone's clear about whether there's been a change of view about the question or not. And then I'll ask the Minister to see whether there's going to be a public interest immunity application made, and then the committee will consider that.
Sure.
Okay. Minister, this is a question to you. Minister, why did you place the CFMEU into administration?
So, Chair, procedurally, you would like me, if I think I should,
yes,
to make a PII claim now, or should I take it on notice with a view to making a PII claim? I don't really mind. I just want to get it right.
Well, I think if we do it now, it's probably...
It's going to be easy now because we're going to go through... This is going to take us now through to all day. We're going to go through every single question, and this, I assume, will arise in relation to questions going forward.
Sure.
Well, I might add, I hope that's not the case, but it may well be the case.
Yeah, it's a matter for you if you want to spend the entire day talking about PII claims. That's for you to choose how you approach the day. I will take a PII claim on that question. I probably don't need to explain why, but as I've already indicated, that question goes to the heart of the issues that are being considered by the High Court now. And just briefly, Chair, in support of that approach, I was reminded over that break that Senator Cash is very familiar with taking PII claims in exactly these types of circumstances. I'm sure Senator Cash remembers the estimates hearings and inquiries into the leak of the AFP raid on AWU officers, the leak that came from her office when she was the Minister. In fact, I think we had the estimates hearing in this very room. And when Labor senators were seeking answers from Senator Cash, the Registered Organisations Commission and the Fair Work Ombudsman, Labor senators including myself, we were told by Senator Cash that the Registered Organisations Commission's investigation of the AWU was the subject of court proceedings and was therefore sub judice, so ROC officials could not answer questions either. And then this is a direct quote from Senator Cash in 2017. To avoid the significant risk of prejudicing or prejudging matters that are before the court, I and the officers at the table will not answer questions about matters before the court, or if necessary, we will take on notice any questions that go to the Registered Organisation Commission's investigation into the AWU or that litigation and take legal advice before responding to them. She then goes on to say, obviously neither I nor the officers at the table will be answering questions that could prejudice investigations carried out by these agencies pursuant to their statutes or prejudice legal proceedings that might arise from those investigations. So the approach we're taking today in light of the High Court litigation is exactly the same as the approach that Senator Cash took in 2017, and in fact the reasons that she gave were almost word for word what Ms Godden explained just before as the basis for our position. But as I say, it's up to Senator Cash. If she wants to spend an entire day and night talking about PII claims, that's her choice.
Do you wish to...
I'm happy to respond to the Minister. I mean, let's call this...
Well, no. Can I there's going to be opportunity on various matters to counter any of the arguments. I really want to just deal, rather than this broader question, because we've decided that we're doing question by question. The Minister's indicated that there's a PIA claim that will be made. Is that accepted? If it's not accepted by the committee, I can have a committee meeting separately, or I can just have an indication.
So from my position, Chair, I don't think the Minister's actually justified the PII claim.
Now he's got... sorry, there's a procedure that we now need to go through.
I'll go through the procedure then. So is the Minister going to make a PIA claim?
Or you're going to take it on notice, you said, too.
You're going to take it on notice to do that?
Well, my recollection is that ordinarily what happens is that people take on notice matters that they then want to consider
Yes.
whether they make a PII claim. So I guess I was intending to go down that path.
Yes.
So if you're comfortable with that, then I would take it on notice.
Yes, thank you, Minister.
Yeah.
So we're going to go through each question now in this format.
Well, it depends what your questions are. Like, there may well be some questions. The point of Ms James in her opening statement indicating to you the approach we would be taking was to give you some guidance about the types of questions that we would not be in a position to answer because of the High Court litigation. But that doesn't cover the field in terms of, I mean, I don't know what questions you and others want to ask, but there may well be questions regarding the CFMEU administration that aren't captured by that. And if you go back to the opening statement, what Ms James said, she gave you some examples of issues that are in dispute in the High Court and therefore sub judice. One, the intention behind the introduction of the bill that became the Act. That was the very first question you asked, despite us saying that we wouldn't be able to answer that question. Two, alternatives to that legislation. Three, the Attorney-General's reasons for deciding that making a scheme of administration was in the public interest. Four, any impact the Administration Act and the scheme may or may not have had on political communications, including donations. And five, the effect of the Administration Act and the scheme on the control of property and assets of the CFMEU. Now, as we've said, if anyone, opposition, government, crossbench, asks questions over the course of the day that relate to those 5 points or similar things, then we will be taking them on notice because of the sub judice, the fact that the High Court's considering it. But I imagine there may be other things that you want to ask about to do with the CFMEU administration, and we will attempt to answer those questions.
So I would like a very clear explanation, either from yourself, Minister, or from your Chief Counsel, as to how you answering Senator Cash's first question
in any way
would in any way prejudice the case in front of the High Court.
Ms Godden might be best placed to answer that.
Hold on. Well, Minister, you're the one making the PII claim, so it is for you to justify why you say it should be subject to public interest immunity.
The Minister has a right to ask Ms.
Well, and I think I've already said 5 times, including at the very beginning of the day, that question goes to the heart of the issues being considered by the High Court. But if you'd like a more detailed explanation, Ms Godden is able to provide that to you.
What we would like to hear is how damage to the public interest arises, because all we have now, Chair, with all due respect, is a statement to the effect that public confidence might be undermined, or that somehow the answer to this question would influence the High Court's case.
The Minister has indicated quite clearly that there is concerns about, and that there'd be intent, and to take it on notice, that there'd be intent to look at a PIA claim, regards this, to go through the detail of that. In fairness to when PIA claims are normally taken, that is a normal procedure, whether we've been in government or others have been in opposition, that are now in opposition, that have been in government. So that would be a normal process for them to take in detailed responses. What the Minister has offered to do is to be of some assistance, is get some indication of the more general nature that Ms Godden could assist with, so that there would be some further clarity to the questions that were raised by Senator Brockman. Whether he's satisfied with that or not, it's up to Senator Brockman. But there was an offer to be of assistance, whilst the normal process that the Minister was taking, that has been taken by many other ministers over many, many years when taking PIA claims.
Chair, well then could I specifically ask Ms Goddard to address how the damage to the public interest arises, but also how the answer that the Minister may or may not give would influence the High Court in its deliberations of the case?
Well, I just want to make this clear. Ms Godden can go to as much to some degree of sort of a broad. Ms Godden can answer the way that she wishes to answer it, and appropriately. But I'm also mindful that the matter's also been taken on notice to go through some more detail. So, Ms Godden.
I might take the public interest question first, Senator, unless you'd prefer me to address why it's at the heart of the proceedings first. Because the because the question is squarely at the heart of the High Court proceeding, we're concerned that disclosing the information would or could reasonably be expected to cause prejudice to the proceedings by raising contested issues which the High Court will be called to determine, subject to the comments that I made before about the High Court being actively likely called on to determine the application of the Parliamentary Privileges Act, potentially creating material which might not be able to be considered in the proceedings due to parliamentary privilege, prejudicing the Commonwealth in the preparation of its defence. The Commonwealth has not yet filed its submissions in the case, which is due to be heard on the 10th and 11th of December of this year. It could involve, that debate in the Senate about issues at the heart of the trial really could involve a substantial danger of prejudice to the proceedings before the court, and that is the public interest in not disclosing the information. As to why it's at the heart of the proceedings, this question is squarely at issue in the second ground of constitutional challenge that I outlined. The implied freedom of political communication argument, at its heart are questions of, one, whether there was a burden to the implied freedom of political communication, and two, if the High Court finds that there was a burden to the implied freedom of political communication, whether that burden was reasonable and proportionate, and that involves questions of what the impact of it was and also what the alternatives were, and the government's intention in, the Parliament's intention, I should say, in passing that legislation has been squarely put by the plaintiffs, including quoting from senators present in this room during parliamentary debate, and that issue has been squarely put by the plaintiffs in these proceedings.
Chair, could I ask a question?
You may.
Thank you very much, Chair. Minister, I referred earlier to comments that you have made publicly in relation to this matter, and on the 16th of October, after the High Court proceedings were filed, so in other words, they were on foot, you said this, and you said this to David Spears. So the comments were not subject to parliamentary privilege at all. So you said this: there's no doubt that there is a fear of retribution in this industry for people, whether they be workers, union officials or employers, to come forward with complaints about behaviour that they experience in the workplace. And that is actually one of the reasons why we've taken this action. That is the antithesis of union values, to see that kind of behaviour, the violence, the thuggery, the corruption going on. As I say, it goes beyond the union into the employer ranks as well. We did, in the legislation that was passed by the Parliament to put the CFMEU into administration, there were changes made to whistleblower protections, but it does seem that there are still some issues there. So can I confirm that that was the comment you made to David Spears?
Well, it sounds familiar to me. You've got the
right.
transcript.
And can I confirm that you made that comment on the 16th of October this year after the proceedings commenced?
I don't know the date. You're the one quoting from the transcript.
Well, it was. I will, and I'm happy to have it brought down and tabled. So it was. So let me put it to you. So you are happy to make comments about this matter going directly to why you placed the union into administration on an interview with David Spears that is not subject by privilege, and yet you are not prepared to answer questions that the Senate committee put to you. You directly commented on, in the David Spears interview after the proceedings were commenced, the reasons for the action. So I would like your response to that, because I see double standards, quite frankly.
Well, a couple of things, Senator Cash. A number of public comments have been made by members of Parliament about these issues, some by me, some by you. The applicants in this case, the former CFMEU leaders who brought this case, have used a range of public comments that have been made by you, by me, by others in support of their case. I do not propose to assist their case or influence the High Court's decision by making any further comments. And For all your mock outrage about this, I remind you that the approach that I'm taking is exactly the approach that you took in 2017 when your office leaked a police raid on union officers. Almost word for word was your reason for refusing to answer questions. So I'm a little bit puzzled about why you need this explained when you've actually said almost exactly the same words in this very room.
Let us be very clear. On the 16th of October, when you made public statements to David Spears that are not covered by privilege, that directly commented on the reasons for the High Court action, did these comments assist the union's case or in any way influence the High Court decision, given that they were outside the cover of parliamentary privilege?
Well, that'll be a matter for the High Court to determine.
Can you just appreciate that we're now having a debate about the claims. The question...
Well, these are questions to the Minister in relation to why he's not answering this question, albeit he's happy to make comments in public forums that relate directly to why... Well, the same issue, to sum it up.
Well, I think the Minister, and the Minister has responded to those assertions and those comments that you've made.
I mean, why did you refuse to answer questions in this very room
Senator
about
Watt,
your
this
office
is not
leaking
about
information
me.
to the media?
This is about
Your reason
and a
was that you were
$6.2 million cover-up, quite frankly. So let's look. How much money has the Australian Labor Party accepted from the CFMEU since Mr Albanese became the Leader of the Opposition and Prime Minister?
That's a question I can partially answer.
Yeah, it's $6.2 million, unless, of course,
why
you
do
know
you ask
that it's
questions
more.
that you know the answers to?
Do you know that it's more?
I don't know. What I was going to... That is a question that I can partially answer.
Can I just for a moment... There's a question being asked, Minister.
I think the question was how much money has the Australian Labor Party received from the CFMEU since Mr Albanese became the Prime Minister. Sounds like Ms Cash, Senator Cash, has the answer. My answer is I don't know. That matters about donations received by political parties are best put to political parties, just as really it's the National Party who should talk about the donations they take from tobacco companies. But thirdly, what I do know is that in recent times, as a result of the allegations and various other things, the Labor Party, in most cases across Australia, has ceased taking donations from the CFMEU. But I don't know the dollar figure, and that's really something you'd have to ask the Australian Labor Party.
Well, in relation to the $6.2 million that the Australian Labor Party has taken from the CFMEU, given the CFMEU's links to organised crime, are you satisfied that the money which the Labor Party has received has not come from organised crime?
Well, I'm not here as a representative of the Australian Labor Party. I'm here as the Minister for Employment and Workplace Relations, and I'm happy to answer questions like that. But those kind of questions...
So you're not prepared to answer whether or not, despite putting the CFMEU into administration, the $6.2 million that the Labor Party has taken from them has or has not come from organised crime?
You really should be putting those questions to the Australian Labor Party. They manage those donations.
So you've got no answer for the Senate in relation to whether or not $6.2 million taken by the Australian Labor Party is potentially from organised crime. I would have thought a pretty clear answer would be no.
Well, then you know more about the donations taken by the Labor Party than I do.
So, in other words, you're unable to rule out whether any of that money is actually linked to organised crime.
I can't shed any light on donations received by the Australian Labor Party because I'm not in charge of managing them. What I'm in charge of is being the Minister for Employment and Workplace Relations.
Senator Watt, again, you've made several comments in relation to why the government put the CFMEU into administration. And in fact, I'm going to read you out another comment that you made. Of course, a safe workplace is one that is also free of corruption, criminality, bullying and violence. And sadly, recent allegations strongly suggest that that kind of culture has seriously infiltrated the construction division of the CFMEU and the wider construction industry. That was a comment made. In fact, you also say the actions of some individuals and apparent infiltration by organised crime is in no way a reflection of union values. That was actually an address to the Press Club on the 18th of September 2024. And again, you directly commented on the reasons that the government put the CFMEU into administration. So I just want to confirm, for the record, you are claiming that you can answer questions about the reasons for this legislation when asked by journalists on television, but you cannot answer the same questions when asked by a Senate committee, in particular noting that the evidence you give is covered by privilege. Can I say, why are you now all of a sudden deciding to run a cover-up for the CFMEU?
Well, I reject that proposition absolutely. I think any objective observer would see that this government, including while I've been the Minister for this portfolio, has taken stronger action against the CFMEU leadership than any government in Australia's history. I invite you to speak to some of the, I think, a dozen former CFMEU leaders who've been terminated as a result of this or following this administration. I don't think they think that I'm running a protection racket for the CFMEU.
Can you just go? Yes, thanks very much. Now we're just rotating the question. Just want to continue on the subject of the CFMEU administration. Can you just go to the department? Can the department, this is regarding whistleblower protections, can the department just provide an overview of the current whistleblower protections available for reports made to the administrator?
Can we? I think that would be fine to answer because it doesn't go to those points. But can we just? I think that's a factual question, and that's exactly the kind of thing we're able to answer.
Correct, Minister. So we are able to provide factual information about what is contained in the Registered Organisations Act, including as amended by the Administration Act, and the scheme, factual information about what is in the scheme of administration for the Construction and General Division of the CFMEU.
Thank you.
Senator, I can take that question. Daniel Tracy, Assistant Secretary and Senior Executive Lawyer of the Workplace Relations Legal Division. Section 323 H of the Administration Act, as imported into the Registered Organisations Act, is the relevant provision with respect to complaints procedures and whistleblower protections for people who engage with the administrator. In summary, what that provision does is require the administrator to establish a complaints procedure that applies in relation to the administration that's been put in place, and complaints to the administrator under that procedure can be made in relation to a number of things. Those things include conduct that is or is alleged to be improper, unlawful or criminal, and that is alleged or has been engaged in by a person who has been an officer or an employee of the CFMEU or any of its branches, divisions or parts that work in the Construction and General Division or any of its branches. Those allegations and complaints may also be made in relation to a workplace delegate within the meaning of the Fair Work Act, for members of the Construction and General Division and its branches, or indeed any member of the Construction and General Division. If a complaint is made to the administrator under this complaints process, the Registered Organisations Act in effect deems the complaint to attract the protections of the existing whistleblower scheme within the Registered Organisations Act, which is set out at Part 4A of Chapter 11 of that statute. In short, those protections provide that a person who makes a disclosure is not liable to any civil or criminal proceedings in relation to the disclosure and is protected in effect from reprisal action being taken against them.
Thanks. I just want to just on, there's an anonymous reporting link as well. Are you able just to describe what that process is on that?
Indeed, Senator. So part of the requirement for the complaints procedure is that the administrator is required to establish the procedure and make that publicly available. And the legislation requires, and this is at section 323 H A subsection 4, that a complaint recipient, that being the administrator or someone authorised by him, must not disclose the identity of a complainant to any person who is not a complaint recipient, so that being the administrator and his team, including if that complaint is then referred on to a law enforcement agency, unless the complainant provides their consent or unless it is already public knowledge that that person has made a complaint. And with reference to the link that you mentioned, Senator, the administrator has made publicly available a link for those protected complaints to be made to.
Minister, just a question directed towards you. I note the recent reporting that some people are not coming forward to report allegations to the independent administrator, as recently as today. Will the government consider taking action to strengthen protections for whistleblowers?
Thanks, Senator Sherwin. Yeah, I heard some news reporting of that today as well. I guess the first point I'd make is that we strongly encourage anyone, whether it be a union member, a contractor, an employer, who has allegations around the issues being considered involving the CFMEU and the construction industry more generally, to make those allegations to the administrator. There is an anonymous tip line or tip website. No one knows and will ever know who has made those allegations. So I strongly encourage people to make complaints if they have them. And I've made the point that this is not just about the activities of union officials. We know that there are people in the construction industry outside the union who have engaged in bad behaviour as well. So I encourage people to make those complaints. But as I've said publicly, if there are improvements that we can make to whistleblower protections to give people greater confidence, then of course we will consider that.
Just again regarding the administrator, obviously one of the critical issues, and we've had many debates, discussions over sorts of pressures that industry, the workforce is under. And I say that industry because when people get underpaid, that means companies are legitimately operating are being unfairly competed with. Can the department just update the committee on the work the administrator is doing to recover union members' funds as part of the work it's doing? Maybe it might be better placed later on, but if you're able to do it now.
It's probably an issue that the Fair Work Commission will be able to assist you with later on, Chair.
Is there maybe you've taken on notice about what the work the administrators actually done themselves? So obviously the Fair Work Ombudsman is doing work in that space, but if they might be able to give us more information on that question, then I'm happy to.
So it's going to. I understand that the administrator has recovered an amount of funds. I think it's around $3.5 million, but I think it's the Fair Work Commission will have details on that.
Thank you, Mr. Manning. That'll be
Fair Work
helpful.
Ombudsman?
Fair Work Commission.
Commission, okay.
Fair Work Commission. I know we were due for a break. We'll come back. I haven't got further lines of questions at this point on this subject matter. We're going to another subject matter when we come back. Once we complete our round, I'll go to Senator Payment and then I'll come back to the coalition. Yep. Thank you. So we'll now suspend until 11:20.
Thanks.
Thank you. I might just finish off my questions in relationship to the CFMEU, then I'll go to Senator Grogan briefly before going to Senator Payman. Minister, I understand that on estimates last night, the Australian Federal Police gave evidence about the establishment of a new police investigation to allegations involving the CFMEU. There was serious matters raised last night in that estimates hearing. Can you provide us with a update or a quick update on that matter?
Sure, Chair. Just before I address that, we just had a look during the break. Your question around the amount of money that the administrator had recovered of CFMEU members' funds. I understand to date the administrator has recovered about $3.5 million of members' funds. I understand most or all of that are the legal fees that I think it was the New South Wales branch of the CFMEU authorised would be paid to a lawyer on behalf of the Darren and Michael Greenfield. I think that's right, but as Mr Manning indicated, the Fair Work Commission might be able to provide a bit more detailed information about that when they appear tonight. That's obviously separate to the work that the Fair Work Ombudsman does in recovering unpaid wages of construction workers. On the AFP point, yes, last night the AFP, while appearing at estimates, was asked some questions about their investigations in relation to the CFMEU and the construction industry. You might recall Minister Burke, when he was in this role, when the recent media allegations surfaced, Minister Burke referred them to the AFP, to the Fair Work Ombudsman, I think a couple of other authorities. So the AFP advised estimates last night that they had now established a new police operation called Operation RYE, R-Y-E, which is investigating a number of things, including the allegations that Minister Burke referred to them. For people who want to know the detail, they could obviously go back and have a look at what the AFP said last night in estimates, but I was there, so I took a few little notes. They said that they have, I think they said they have one investigation now underway into numerous individuals. There was a historical investigation that started in 2018 that had now been absorbed into Operation RYE. They pointed out that they already have a number of joint federal-state police operations investigating organised crime matters and outlaw motorcycle gangs that may end up being involved in investigations here. So, as I say, it's probably, for people who want to know the detail, they could look back at what the AFP said, but I guess the point is that they have now established a specific operation to investigate a range of these allegations.
Yeah, good. Thank you very much, Minister. Senator Grogan.
Thank you, Chair. Ms James, I wonder, can you give us a bit of an overview on what the Closing the Loopholes legislation does? Just for a change of pace.
Are you going to kick off, or
Is she getting that?
Sure. Hi, Senator.
Good, thanks.
I take it your question encompasses both of the Act's Closing Loopholes 1 and Closing Loopholes 2, noting they were introduced as one. I mean, I might start at a high level, then get my colleagues to explain any points in particular you want. So if we look at the original Closing Loopholes Act of 2023, essentially that was designed to address what was seen as loopholes in the system to undermine principles around fairness and better pay. And so we spoke earlier about wage theft. That offence was introduced in that legislation. One that's got some media recently is what's called a labour hire loophole, or regulated labour hire agreements, whereby orders can be made in relation to the payment of equivalent payment of enterprise agreements for directly employed employers. There were provisions in relation to a framework around delegates' rights, also introducing a new offence around industrial manslaughter. If we look at the Closing Loopholes No. 2 Act, which was enacted this year, it introduced the framework to set minimum standards for employee-like workers and road transport contractors that the Minister mentioned in his opening statement. Changed the definition of casual employees and the process whereby casual employees can seek to convert to permanent employee where they believe they've got ongoing employment. Also introduced provisions to give workers the right to challenge unfair contractual terms, and also introduced the right to disconnect, as well as making some changes to the bargaining regime.
I'm particularly interested in the right to disconnect. There's been a lot of commentary about that, and we've heard Senator Hume refer to it as adding more rights for workers as being unreasonable. It seems like it's being interpreted in a very black and white fashion as opposed to the more balanced and reasonable way in which I potentially see it. I wonder if I would ask the Minister on this one, what's the intention, Minister, behind the right to disconnect, and why does it need to be enshrined in legislation?
Thanks, Senator Grogan. I guess there's a couple of reasons for introducing laws around the right to disconnect. I think all of us have experienced that with the growth in technology, mobile phones, emails, whatever, there has been an increasing intrusion of work on people's private lives after hours. I'm sure you've experienced some of that. Really, one of the motivations for the right to disconnect is to ensure that workers aren't having to spend unreasonable amounts of time when they're not being paid after hours responding to emails, phone calls, text messages from their boss. And one way to think about it is trying to stop unpaid overtime. So, as I think I've said in this committee before, it's not about saying that no employer can contact an employee after hours ever. I know there are some people who have been portraying it that way, but it's more about giving employees rights to resist disciplinary action that their employer might bring if they don't respond, immediately. There are probably lawyers at the table who can explain it more articulately than me in terms of the legal consequences, but in general terms, that's what it's aimed at.
But I suppose in terms of the legal to one side, in terms of how that sort of operates, I'll use myself as an example. If I said to my staff, which I do frequently, if you're not working and I'm sending you emails, it's because of my convenience and I don't expect you to look at them. But if I need you because of an emergency, I would pick up the phone and call you and make that arrangement with them. Does that kind of cover off on it? Because you're not saying that people, in the case of an absolute need, that an employer wouldn't be able to reach out like in an emergency or a situation.
That's right. In fact, the legislation, my recollection, gives examples of the types of conduct that would, or factors that the Fair Work Commission would take into account in deciding whether an employer's contact was reasonable or not. And my memory, again, the legal officials can give you the details, but my memory is, the Commission would take into account the seniority of someone's role, so it would be probably more reasonable for an employer to contact a very senior person than a very junior person. The nature of the contact or the issue that's causing the contact, an emergency situation versus an email or a text message that is pretty mundane and could be responded to on Monday rather than Saturday afternoon. But again, if you'd like more detail, the officials can give you that.
Well, maybe I'd be keen to understand like how I don't know, the secretary or whoever's relevant, how you see this as stopping that unpaid overtime and further protecting workers.
Senator, I might start on that one. I think that the mechanisms in the Act, I won't go into detail on, the other officers can talk in detail about that, but the core of it really is that if a person feels that they're getting unreasonable out-of-hours contact for which they're not being compensated, that there's a framework for raising concerns about that with your workplace in the first instance, and then there's, in the event that it's not resolved through those sorts of normal discussions we have in our workplaces about hours of work and what have you, there's a mechanism to formally resolve disputes with the Fair Work Commission. So I would hope that with these provisions, and noting the Fair Work Ombudsman's provided some guidance around these provisions, that what it will do is it will, if people haven't already had these sorts of conversations in the workplace, it will cause people to have those conversations about their situation and their preferences. The Minister did a pretty good job of outlining the factors about reasonableness. One he didn't mention, which is relevant, is an employee's personal circumstances and whether or not the extent to which they're compensated. So these are all relevant when considering whether a particular contact is appropriate and reasonable. And so to my mind what this does is it means that people will focus in on having those conversations, noting the technological developments and the way work has changed, particularly since 2020, about how many workers are operating from their homes when they previously would have been in a workplace. And it's only in the event that these issues aren't discussed and agreed reasonably that we would expect to see proceedings around this. And I think the feedback we've had indeed as an employer is it's been a good basis on which to review how do we talk about hours of work? How do we ensure we're all having these conversations, noting that there are times, particularly for the people you see at the table, who are the more senior officials in this department, there are times where people are working at not particularly hospitable hours. They are well remunerated. I say that objectively based on comparisons with wage levels and average wages and what have you. They are well remunerated, but that is not a basis for people working 24/7. We all need to be reasonable, and I think that's at the heart of these provisions, and it's at the heart of how people should be venturing into discussions around them. Thank you.
Thanks. Senator Grogan, could I just quickly add, I think you raised one of the issues you raised was how this has been received, and I think it is worth pointing out that the right to disconnect is one of several new rights or workplace conditions that have been provided by this government that the coalition has said they will remove if they come to office. Mr Dutton has explicitly been asked in August this year, do you still plan to repeal the right to disconnect? Mr Dutton, yes we do. And Senator Hume described the right to disconnect as unreasonable and unnecessary. I think that is a pretty unfortunate state of play, that we have a party aspiring to become the government that actually is comfortable with the idea of people working unpaid overtime. But there we are.
That's the kind of modus operandi. We've seen that in the past, Minister, have we not?
It is, because as Senator Cash well knows, her government was all about low wages as a deliberate design feature of economic policy. We saw stagnant wages for 10 years. We saw more insecure work, and as I say, this is one of only, this is only one of several rights and conditions that the coalition has said they will take away if they win the next election.
quite disgraceful.
It's time to rotate. Senator Payman.
Thank you, Chair. Yesterday wasn't the right place to ask these questions, so let's hope today is. My questions relate to the amendments to the Fair Work Registered Organisations Act 2009 this year, which enabled the construction and general division of the CFMEU to be put into administration on 23rd of August. Under section 323HA of the Act, I'll put the questions to the Minister, but Department can help. How many complaints has the Administrator received regarding the actions of members of the CFMEU?
Senator, I don't think we would have awareness of that. The Administrator is the custodian of that information, and as the Minister noted earlier, it is very important that, although numbers doesn't compromise anyone's protections or anonymity, but it is very important that other parties, such as the Department or the Minister, isn't aware of details. So I think we'd say we're not familiar, we don't have that information about how many complaints have been provided. It might be that the Fair Work Commission is in a position tonight.
I'm not sure if they'll have it. The only other thing I'd add, Senator, is that under the Act, I think it's section 323T, uppercase T, the Administrator is required to provide a report no later than 6 months after the commencement of the Act, and the legislation requires the Minister to table that report in Parliament. So that's the type of information at a non-identified level, as the Secretary said, I would imagine would be in that, but we don't know that the answer to that question.
No, I appreciate that.
So the Fair Work Commission is on it for
in the afternoon.
So, yeah.
No, I'm aware.
Senator, I might also say that noting that the Administrator is distinct from the Fair Work Commission as well, the Fair Work Commission and the Fair Work Ombudsman did, prior to the administration being established, they also set up dedicated channels for people to provide information and make complaints about conduct in relation to this matter. So while they may not be able to go to your question about what the Administrator is a custodian of, they may well be able to go to the subject matter of prior to that point, and indeed their own channels I think are still open, because of course the person may well wish to make a formal complaint about provisions of the Act that the Fair Work Ombudsman and or the Fair Work Commission are responsible for enforcing.
Yep, no, I understand.
The officials are right. I don't think we have that detail. What I do know is that around 12 former officials of the CFMEU Construction Division had their employment terminated. I think technically that was by the Administrator, the termination. And several more have been suspended as a result of allegations made against them.
We'll come to that, but in terms of the complaints made, I understand that the 6-month report is going to be released, but if the Minister or the Department can take it on notice to provide how many complaints the Administrator has received thus far. How many investigations have been initiated by the Administrator based on these complaints? I guess that would also be taken on notice.
We the Department don't know, so.
But for the Minister to look into?
Happy to take it on notice. There will be some information that we simply don't have, because remember, the Administrator is completely independent of government. They're not a government body. But the other thing I was going to say, when the Fair Work Ombudsman appears today, I think they've already put it in the public domain that they have around low 40s, 41, 42 investigations now underway involving the CFMEU, but they'd be able to provide you some more detail about that. Because depending on the nature of the complaint, some might need to be referred to the police, some to the Fair Work Ombudsman, some to other authorities.
So I can ask the Fair Work Ombudsman later?
You could certainly ask
questions?
them about what investigations they have underway.
Sure.
So, Senator, section 323(H)A, which sets out the complaints procedure, also envisages that complaints received by the Administrator may be more properly investigated by other agencies. As the Minister indicated, that could be the Federal Police or State or Territory Police, that could also be the Fair Work Ombudsman, could also be the General Manager of the Fair Work Commission in his role as regulator of registered organisations. There may be other bodies as well, the ACCC, for example. The process set up in there broadly allows for the referral of those complaints and for a report back to be provided to the administrator. However, as the Minister and the Secretary have averted to, the Administrator is independent of government, the Administrator is running the union and is regulated as such by the General Manager of the Fair Work Commission in his capacity as regulator of registered organisations. Also, the Fair Work Ombudsman has a role as regulator in that space, but the Department's role and oversight is limited to the Minister receiving that report from the Administrator and then assisting the Minister to table that in Parliament.
Okay. Because earlier we made the decision to just ask questions, and again, that will be decided by the committee and the Minister taking, the PII claim on notice. How many findings of corruption or criminality have been found since the administration began months ago? Again, you can take that on notice.
Yeah, I think we would, simply because we don't have that information.
That's
and we'll
fine.
obviously consider whether it's appropriate to answer that or not.
Well, I think it would be in the public interest, Minister, for us to find out. So much money has been spent to set up this administration. We need to see that results have come out of it. Can you remind us how much of members' hard-earned money is being spent to run this administration?
Again, we don't have that information. Happy to take that on notice.
Surely it would be in the millions, right?
I'm not sure why you'd be saying that, and I don't know that. I'd also, so happy to take it on notice. I'd make the point that I made before that already the administrator has recovered around $3.5 million of members' hard-earned funds, most of which was...
But we're talking about how much is being spent to set up the administration.
Sure.
And I am poor on time, Minister, so we'll have to go to the other questions.
I just thought you might like to hear about the funds, the members' hard-earned funds that has been recovered by the administrator, which was inappropriately paid to lawyers to defend a couple of those officials. But if you don't want to know that, that's okay.
We're totally across that one. I'm only asking questions I don't know the answers to.
The only thing I'd add to that, noting Ms Godden's earlier comments that whether or not the scheme amounts to an acquisition of property of the CFMEU is something at issue in the litigation, is that the legislative framework empowers the General Manager of the Fair Work Commission, who will be here later, to set the remuneration of the administrator.
Yep.
That's true.
Thank you. Yep, definitely we'll ask these questions and put it to the FWO. Minister, are you aware of the circumstances around the Deputy Administrator in Victoria, Graham McCulloch's removal 3 weeks after commencing in his role?
I'm aware that he was removed or resigned. I can't remember which it was.
I've got a copy of an article in The Australian on the 13th of September, and it was reported that there were, and I quote, allegations of staff complaints surrounding the Deputy Administrator's removal. Are you aware of this in particular?
I'm aware of that report, yeah.
Are there any ongoing investigations regarding any complaints made about the Deputy Administrator's conduct?
I'd have to take that on notice. And
I've also got another article from The Age that reported, and I quote, McCulloch had used inappropriate language to women in work contexts since his appointment, end quote. And further to this, I've heard reports that McCulloch was touching female staff inappropriately, as well as inviting his female staff to drinks late at night. Are you aware of this?
I'm aware those allegations have been made, yeah. And as you've pointed out, the administrator, it's been reported that the administrator, on learning of these allegations, took immediate action, and Mr McCulloch resigned hours later.
So, to use your words, Minister, the purpose of this administration was to deal with alleged intimidation, bullying and inappropriate behaviour, yet this administration has caused more of this behaviour through their hand-picked candidate for Deputy Administrator. Am I mistaken, or has this administration failed to achieve its goals?
Well, I'm not going to comment on the purpose of the administration for the reasons we went into earlier. But my view generally is the administrator and his team are doing an excellent job under very trying circumstances.
Well, it doesn't look like he is
Well,
when there's
that might be your view,
inappropriate
but
conduct.
that might
It's what's out there, Minister, and there's a reason why this person has resigned. We just need to make sure measures are put in place so this doesn't happen again.
Sure. And I mean, I don't know if those allegations are true, then I'd point again to the fact that the administrator dealt with them promptly, as he should.
Well, again, making sure it doesn't happen again. In August, the Attorney-General sacked 270 unpaid officials and 11 paid office holders of the CFMEU. Minister, on what basis did the AG make the decision to sack these officials in August?
I'll take that on notice again because it's relevant to the issues before the court.
No worries. Was the sacking of these officials in accordance with the natural justice hearing rule, including fair process and a right of reply?
Again, I'll take that on notice.
It was reported in August that John Setka claimed to have been betrayed by the government after striking a deal to step down in return for the government not putting the CFMEU under administration. Are you aware of any discussions or consultation that occurred between Minister Burke or his office and representatives of the CFMEU?
Not only am I not aware of that, but it is an absurd proposition. There was no deal. I know Mr Setka has made that claim. I'll leave it for other people to decide whether they believe Mr Setka. And Minister Burke made clear at the time that Mr Setka is talking about is that his resignation was welcome, but that much more needed to be done to clean up the union.
So there were no undertakings made to the union?
No.
If so, are you saying that Minister Burke has given you assurances that no discussions have taken place?
Yes, and I'd also say that John Setka says many things.
Because Minister Burke has repeatedly refused requests for comment on this matter. So surely if there was no consultation, he would come out and deny it as you have.
Well, Mr Burke's a busy man and he can decide for himself what he says.
Again,
he's no longer the minister.
I understand.
I'm the minister who's responding to all of these issues.
But this happened while he was minister, and so I would assume that those conversations or any consultation that he had would have been conveyed to you as now the current minister.
And I've already answered your question.
And Senator, if we go too much further down this line, we're going to have concerns about getting to issues which are really at the heart of the litigation, including why the scheme was put into place and any alternatives to that.
Minister...
So I guess you've gone a bit over the time allocated, but if you've got much longer...
I'll stay, because I've got heaps more questions.
That's right.
So how much more time do I have before I start a new set of questions?
Well, probably better off just explain to me how long... Have you just got a couple of minutes to finish off on this
yeah, and
questions?
then we can rotate
and
the
then
call.
I'll rotate, yeah.
Fantastic. Minister, some have characterised that... And I put to you as the question, is this an act of revenge against the CFMEU for their positions against the government on matters like silica dust, housing affordability and Palestine?
I'd like to answer that question. I'll just check whether I can.
Senator, unfortunately the reasons for placing the CFMEU into administration are really at the heart of what is before the High Court. I think the Minister could probably point to legislation that's been enacted in this term of government, given that that is squarely on the public record and is a matter of fact.
Thank you for your guidance, Mr.
Well,
Godden.
okay, so thank you. I would point to the fact that this government is the first government in Australia, and I think we may even be world leading in some respects when it comes to silica protections. I'd also point to the incredible investment from this government in housing affordability, which we really appreciate support from the crossbench on.
That wasn't my question, Minister.
No, but we should be honest about where we're voting on things, shouldn't we? And what we're prepared to vote for and what we're not prepared to vote for.
Yeah, no, I understand.
So I'll leave it.
Not about.
I'll leave it for others to decide whether they believe the people who are providing information to you.
Is this an act of revenge?
Well, given the advice from the lawyers, I will leave it to others to decide whether they believe...
So as Minister, you can't comment on that?
Well, I can't comment on the reasons for the administration.
There was a lengthy question that was asked, and the Minister should be allowed to answer the question.
Yeah.
Minister.
I can't comment on the reasons for the administration, for reasons that have been explained, but for what those people are telling you to be true, would fly in the face of this government's action on things like silica, housing affordability and the other issues you mentioned.
I think there are many working men and women out there who want answers. So looking forward to the questions. You've taken on notice and we can share the call. Thanks, Chair.
Good, thanks. Senator Cash.
Thank you. And I just want to follow on from a line of questioning from Senator Payman. Minister, Mr Zack Smith, can you just confirm his role in the CFMEU before I put the line of questioning?
His current role?
His current role.
I believe he is the Executive Officer of the Victorian branch of the CFMEU Construction and General Division. Have I got that title right?
Of the Victorian branch.
Victoria, Tasmania.
Sorry, Victoria, Tasmania. He's the Executive Officer of that.
What was he previously?
National Secretary.
And ACT.
And
ACT.
Well, I don't think
Ms. Godden, and I believe, I'll double check this, but I believe he's also the current National Secretary of the CFMEU Construction and General Division.
Right, the current National Secretary.
If that's wrong, we'll come back to you.
Thank you very much. Mr Smith, Mr Zack Smith, similar to the line of questioning from Senator Payman.
Sorry, I think he's the interim.
Yep, thank you. Has also accused your predecessor, Minister Burke, of lying to him. He said that Mr Burke told him on the 13th of July he would give the CFMEU a chance to address its issues, but Mr Burke later reneged on this deal. Is Mr Smith telling the truth?
No.
And that is, how do you know Mr Smith is not telling the truth?
Well, as I say, you've only got to look at the timeline to see that at the time that this alleged deal occurred, Minister Burke, I think on insiders, but certainly publicly, was making the point that while Mr Secker's resignation was welcome, a lot more needed to be done to clean up the union, so that wasn't the end of the matter. Well,
that in no way goes to whether or not the statement made by Mr Smith that Minister Burke told him or gave him an undertaking that they would have a chance to address the issues, that goes in no way to that. Are you aware of this conversation?
No.
No, you are not. Have you spoken to Mr Burke about this conversation?
Yes.
Okay. What did Mr Burke say to... What did you ask Mr Burke?
Oh, look, I can't remember the exact details, but he... and I'm not sure what Mr Smith's version of events is, but from Minister Burke's point of view, there was no deal. And again, I point to what Mr Burke said at the time, which flagged the need to do more to clean up the union.
So do you know on or about the date in which this alleged conversation, did they speak at that time, Minister Burke and Mr Zack Smith as head of the CFMEU?
No, because I'm not sure that it even occurred.
Okay, but you have spoken... why did you speak to the former minister about this particular issue?
Well, I think from memory it was because I was doing media shortly after those allegations had been made.
By Mr Smith? So you were aware...
No, actually, I think initially it was straight after the interview that Mr Setka did on Spotlight.
Okay. So your evidence is to the committee that you have spoken to Mr Burke in relation to the claims made by Mr Smith?
Yep.
And
well, I'm just trying to... It may have been... I think it was more about Mr Setka. It was Mr Setka was the original person who made this claim. And I spoke to Mr Burke about it at the time because I was doing media shortly after that, and he rejected what Mr Setka was saying.
In relation to Mr Setka?
Yeah, because the allegation, you might remember, Mr Setka made an allegation that Mr Smith had said something to him.
Correct.
And so I checked that with Mr Burke.
So did you check with Mr Burke whether or not Mr Smith's allegation so nothing to do with Mr Smith, that Mr Smith's allegation that, well, his accusation that Minister Burke lied to him in terms of saying that Mr Burke told him on the 13th of July that he would give the CFMEU a chance to address its issues, but Minister Burke later reneged on this deal.
Well, my recollection, noting it's a little while ago, my recollection was that I asked Minister Burke about the allegation that Mr Setka had made, and Mr Burke rejected that allegation and pointed me to the comments that he made at the very time, I think on Insiders, where he flagged the need for a lot more to be done to clean up the union.
Okay. But going to my question then, you can't give that evidence in relation to the allegations made by Mr Zack Smith.
Well, they're one and the same thing. What Mr Setka, my recollection of the interview with Mr Setka was that he was referring to something that he said Zack Smith had told him.
Okay.
That's my recollection.
So just in terms of the article, just so it's on the Hansard, this is a direct quote from the article. Mr Smith on Thursday said he spoke to Mr Burke on July the 13th, the day after John Setka quit as the union's Victorian secretary, and he believed the then Workplace Relations Minister had committed to giving the union an opportunity to internally address the issues without the need for an external administration. This is a quote. I think his exact words were, "You've got a chance to address these issues," close quote. Mr Smith alleged Mr Burke said during their Saturday conversation. That undertaking wasn't honoured. We weren't given a chance. That is a direct quote from Mr Smith. He then says, I think history will show that, and we should have been given a chance as a democratic organisation, we should have been given that chance. Are you aware if Mr Smith and Mr Burke spoke on the 13th of July of this year, as Mr Smith states occurred?
No, I'm not aware of that.
No, you're not. Are you able to take on notice whether or not the former minister spoke to Mr Smith that day?
I'll take it on notice. I don't know what the rules are around whether ministers can provide evidence about conversations that other ministers may or may not have had, but I'll find out. I'll get some guidance on that and take it on notice. Could I just make one point as well in terms of one of the things Mr Smith said? He made the point, in his view, the union should have been given a chance to clean up its own act, or whatever the words were. I would remind all that before legislation was introduced to the Parliament, both Mr Burke as the former minister and I called on the union to consent to the application that had been lodged by the Fair Work Commission General Manager seeking to put the union into administration. The union did not consent to that, and events followed from there.
Is anyone in the department aware of the conversation or the alleged conversation between Mr Burke and Mr Smith, Mr Zack Smith?
Senator, I'm aware of the allegation because I read about it in the articles that you're referencing.
But you have no direct knowledge in relation to whether former Minister Burke and Mr Zack Smith did have a conversation on that day?
I do not.
Okay, thank you. Could I now go to, it was a press conference given by former Minister Burke on the 17th of July, and during the press conference he made a number of commitments that I just want to go through to understand the status of those commitments. The first one is in relation to amending government procurement rules. And Minister Burke stated the government will also use its procurement powers to ensure that enterprise agreements used on government-funded projects are genuinely agreed and that workplaces are free from coercion and intimidation. Has the government implemented that commitment?
Well, officials could add to this. One of the pieces of work the government has commenced in response to these recent allegations is actually being led by Minister Catherine King through the infrastructure portfolio, and that goes to the issues you're talking about. That's obviously where we play a pretty big role as a customer and a procurer, but the officials can maybe add to that.
If I could get the officials to add to that, please.
Hello, Senator.
Thank you, Ms Anderson.
First Assistant Secretary, Safety Industry Policy Division. Senator, in relation to Minister Burke's comments around procurement, I would also refer you to evidence put forward by Department of Infrastructure during the course of this week as well around the work that they had done looking at their own procurement with state and territories in relation to ensuring that the sort of the contracts there were being reviewed and reconsidered. So that was one sort of side of that sits in the Department of Infrastructure. In terms of our portfolio, we have been working with the Department of Finance.
Yep, Department of Finance, yep. We've
been working on the development of a discussion paper on the Secure Jobs Code. The Secure Jobs Code was an election commitment by the government, and it's designed to be a procurement policy that effectively sort of leans in, I suppose, in terms of workplace relations practices. I might just... Sorry, I can add to that. The commitment is basically designed, or the Secure Jobs Code, once established, is designed to look at the fair treatment of workers, including job security, fair and reasonable wages and conditions, amongst other things. And basically that discussion paper is in development at the moment with the Department of
Just
Finance.
in terms of consultation, has the department engaged with or consulted with industry about how to implement the commitment that Minister Burke made?
In terms of the National Construction Industry Forum?
No, in terms of Minister Burke's statement, the government will also use its procurement powers to ensure that enterprise agreements used on government-funded projects, so specifically in relation to this commitment, are genuinely agreed and that workplaces are free from coercion and intimidation.
So that goes to the discussion paper Ms Anderson referenced in her last answer, that's being developed and that would be at the forefront of that consultation.
So have you consulted already?
Not yet, no.
Okay. So can I just get confirmation that the Commonwealth procurement principles can be amended by the stroke of the ministerial pen? That's how you amend Commonwealth procurement rules?
I actually don't know, because I guess that's more a finance thing, is it not?
That's correct.
Yeah.
Well, my question is, given that it was the former industrial or former workplace relations minister who made this commitment, why haven't you, Minister, taken steps to just merely ask the finance minister to amend these principles to give effect to Mr Burke's commitment? It was a pretty definitive press conference and commitment that he gave, and that was in July, and it's now November.
No, we are progressing that via the Secure Jobs Code, which we are developing jointly with the Department of Finance. And as you've heard, that is well underway, and I think the intention is for it to be released for consultation before the end of the year.
The other document that's probably relevant, Senator, that was issued at around the same time as the Commonwealth Supplier Code, which sort of outlines the Commonwealth's minimum expectations around ethical behaviour of suppliers and subcontractors while they're under contract. And then the aim is that the Secure Jobs Code will flesh out those obligations more specifically.
Again, though, this is specifically in relation to a commitment made by the former minister that could actually be implemented with a stroke of a pen, and it was specifically in relation to procurement powers to ensure that enterprise agreements used on government-funded projects are genuinely agreed to and that workplaces are free from coercion and imitation.
I think one factual matter I'd comment on, Senator, is I don't think the practice of the Commonwealth would be to change its entire procurement policy at the stroke of a pen as you describe it. There would be a process. It has recently been changed. There would be a process. As the Minister said, it's responsible to the Finance Minister. I'd be surprised it wouldn't go through even Cabinet processes for approval given the breadth of the change.
So, Minister, does the government stand by the statements made by Minister Burke?
Yes.
Okay. At the same...
While I'm at it, can I just... I've been given a bit of an update on the roles that Mr Smith holds. I was a little unclear on that earlier. So, for clarity, he is the interim Executive Officer of the Victorian Tasmanian branch of the CFMEU Construction and General Division. He is also the National Secretary, but I understand that's a part-time role. And all CFMEU staff and officials, including Mr Smith, are under the direction and under the direction of and report to the Administrator.
Okay. And have you ever spoken to Mr Zack Smith?
I have.
You have. When was the last time you spoke to him?
I think I've mentioned previously, prior to taking on this role, I can only recall ever having one conversation with him very briefly in the Mural Hall in passing. And since taking on this role, I've spoken to Mr Smith, I think it's only once, where I outlined the government's views on these matters and he outlined his.
Going back to the press conference, one of the journalists at the press conference asked Minister Burke, what about the flow? Do you think this saga demonstrates that the Fair Work Ombudsman needs sharper teeth or more resources devoted to it? And Minister Burke's response was, the Fair Work Ombudsman will always evolve and will always need to evolve. There will never be enough resources in the Fair Work Ombudsman to deal with every challenge in workplaces around Australia, but we always need to be reviewing the capacity and the powers of the Fair Work Ombudsman. So, Secretary, what steps have now been taken to implement Mr Burke's commitment to review the powers and the resources available to the Fair Work Ombudsman since he made that statement on the 17th of July?
Senator, I don't think I would read... Actually, I might just try and find the comments. Sorry, I've got a version of the press conference transcript that doesn't have page numbers on it. So if someone can...
The specific quote is, but we always need to be reviewing the capacity and the powers of the Fair Work Ombudsman.
So I would interpret that as this is something that we're always doing to ensure that all of our regulators have the powers and funding they need to do their job. I would not have interpreted that as a formal commitment to formally review the Fair Work Ombudsman's powers. I will say that we regularly engage with the Fair Work Ombudsman and the Fair Work Commission about their work and appropriately do test whether they have resources and functions and powers that are appropriate. But there hasn't, I don't believe it was the intention to instigate a formal review. I think that if you wanted to ask the Fair Work Ombudsman about their position with respect to these issues, they can tell you themselves about their view about their existing powers and resources.
Has the department itself or even the Minister asked the Fair Work Ombudsman to make any recommendations regarding additional powers that it may well need?
I don't think we have invited that specifically beyond the ongoing discussions that we have that I've just referenced.
Has the department or indeed the Minister received any recommendations from the Fair Work Ombudsman to increase its powers?
I'll need to double check or take that on notice as to whether we have. I can remember having 2 meetings with the Fair Work Ombudsman and her team. I don't think it's more than 2, but I can remember having 2 since taking on this role, and the vast majority of the discussion were about the CFMEU issues and the referrals that had been made. It's possible, I'd need to go back and check notes as to whether the need for additional powers was raised in that. It's possible, but I'd want to double check that.
Senator, can I ask, is there a time limit in which noting the question's been taken on notice, in the sense that at some time in the past, I'm sure the Fair Work Ombudsman has been consulted on legislative change where it's expressed a view about...
given by former Minister Burke on the 17th of July.
That's what I was checking, Senator. Confirm.
And I'm assuming that, Minister, what your discussion with the Fair Work Ombudsman was post the 17th of July?
Correct.
Yes.
It was after taking on this role.
Yeah. So, Secretary, are you aware if the Fair Work Ombudsman has made any recommendations regarding additional powers that it now requires?
I'm not aware that recommendations of the nature you've described have been made.
So have any recommendations been made?
I'll just refer back to what I said before. We have ongoing discussion with the regulators about issues to do with their enforcement and their resourcing. No formal requests have been made. We might have touched on the extent, the operation of their current provisions and where and how they apply, but no such recommendation has been made to me by the Fair Work Ombudsman.
Same press conference. Minister Burke also made the commitment to improve protections for businesses who speak up, and he said there is further work that will always have to be done. I don't doubt the examples that have been given, because I met with a business yesterday with almost an identical story to what you described. Can I ask again, since the 17th of July, what actions has the government taken to increase protections for businesses and persons speaking up about the CFMEU?
Senator, as a matter of my Chief, I will look at my Chief Counsel as I start to answer this question to make sure I'm not straying into the ground that we've traversed we're constrained from discussing. Since the 17th of July, sorry, Senator, I've forgotten your question.
It's the greater protections for businesses who speak up.
The regulators, the Fair Work Ombudsman and the Fair Work Commission, have done a number of things operationally since that date to, and I think I referenced this with Senator Payman before, to open up very specific channels to encourage people to bring forward information or make complaints relevant to this matter, either anonymously or not. And you can ask them later about the nature of what opening those channels has attracted in terms of information. And I do believe that we did make some amendments to some of the relevant provisions, including the ones that Mr Tracy and Chief Counsel Godden referenced before. So there were amendments made in the legislation passed in August that went to ensuring appropriate protections. I think that Ms Godden and Mr Tracy have referenced this already, but I think we probably should draw a line there in terms of anything other than describing the legislation.
Have there been any requests from employers, businesses, industry to increase protections available so that more people can come forward?
Certainly, Senator, it was a concern to ensure that impacted people could bring forward information. That has been continuous throughout the government's response to this issue. And so the nature of what has been asked for, I think, would have evolved as the situation evolved, noting that at a certain point legislation was passed and an administration put in place.
But at this point of time, there's been no legislative change in relation to the protections available other than the initial legislation that's gone through.
I think, well, I don't believe the government's passed any legislation in this area since.
No, that's what I'm asking.
Since that
there's been no legislative change. So if industry was to come forward and say, we need additional protections and we need them by way of this amendment to the administration scheme, Minister, is this something that you would consider doing?
Of course I'd consider it. There have been employer groups who've raised with me their concerns about whistleblower protections, and we've agreed that that's a matter for ongoing discussion with them, while noting the efforts that have been put in place to allow people to make complaints and bring forward allegations without fearing for their safety.
So one of the issues when people are talking to me is the fact that there are many employers out there who are still being threatened, are still in fear of reprisals and will not come forward because they do not believe that the protections are adequate. So if business was able to put forward to you the appropriate legislative amendment, is that something that the government could bring forward as quickly as possible so that more people can come forward?
Well, we would obviously consider that. I'm not going to agree to something today that I haven't seen, but we would obviously consider that.
Minister, are you aware of examples of businesses that have suffered reprisal and repercussions as a result of coming forward?
No, I don't believe I've heard anything like that. I've certainly heard the concern that people are worried that might happen, but again, I'll check my records, but I don't believe I've heard of any reprisals being taken.
And this is the irony, they're not coming forward because they are worried about the reprisals, which really then casts a shadow over the effectiveness of the administration scheme.
Well, can I pick you up there? I mean, a couple of things. There are people who have brought forward allegations or made complaints to the administrator and to some of the other regulatory bodies that are being dealt with. And as I say, I'm not aware of any reprisals having been taken on those people. So I think that others should take some confidence from that there is a system where people can make complaints and not have reprisals taken from them. But more broadly, I would also point you to some very recent comments from employer groups in the construction sector along the lines that they're satisfied with how the administrator is doing his job.
Satisfaction with the administrator doing their job, though, is separate to people in the industry who are in absolute fear of coming forward, even though they want to, because they don't believe that the protections are there for them. So again, if industry was able to bring forward the requisite legislative amendment, this is something that the government would consider.
Well, I think I've answered that a couple of times.
We might just go now, rotate over to Senator Payment.
Thank you, Chair. Minister, back to the CFMEU administration. We know that they're being paid out of the funds of CFMEU members. How much of members' funds will the administrator be paid for his time in the role for at least the next 3 years?
Well, I think Mr Manning has already indicated that under the legislation or the scheme of administration, the remuneration of the administrator is a matter for the Fair Work Commission General Manager. So I'm sure he'd be happy to talk to you about that when he appears today.
Okay, well, there was a leaked document that outlined the salaries of a few people. I understand that Michael Flynn, the former head of special projects at the ACTU, is involved in the administration. Minister, do you know what his role is?
My understanding is his title is Deputy Chief of Staff.
And do you know what his salary is?
No.
Well, according to the leaked document, which I can share for tabling, it's estimated that his annual salary is $330,874, which has increased from $110,000, so that's quite the jump. I understand Alison Curry, the former Chief of Staff to Bill Shorten, is involved in the administration. Do you know her role?
I believe she's the Chief of Staff to the Administrator.
Do you know what her remuneration package is? The estimated annual salary for her is $321,240. I understand Clancy Dobbin, the former advisor to Victorian Labor Minister Lisa Neville, is involved in the administration. Do you know what his role is?
I understand it's some type of communications role, but I'm not exactly sure. I don't keep track of every employee of the administration.
Well, we're getting there, but his remuneration package is $194,796. Now, do you know how many fee-paying members it takes to cover the salaries of these three officials? Just these three officials?
No, but I dare say it's probably pretty similar to the members' contributions that were needed to pay the salaries of two former officials who are facing corruption charges in New South Wales right now.
Well, I'm talking about these three particular officials, and on my calculations, it would be almost 2,000 members' hard-earned fees that they're paying their dues just to employ your hand-picked bureaucrats. How can the government justify this program of jobs for mates at the expense of workers?
Well, I'm not sure who's supplying these questions to you, Senator Payman, but...
Don't insult my intelligence and being able to put questions to the government, Minister. That's really not fair.
Well,
so can I just interrupt?
This isn't about an agenda. It's
excuse me. Can I just interrupt for a moment, please? Sorry.
Sorry, Chair.
Sorry, I didn't want to raise
not appropriate.
Didn't want. No, I'm not. questioning your questioning. I'm just wanting to say something. They haven't got a copy of the document. We've only just approved it, so I've just handed the document up. So that goes to the issue that you were raising.
No worries.
Yep.
If I could refer the Minister back to answering the question, or you can just take it on notice.
What was the question, sorry?
How the government can justify this program at the expense of workers.
Again, we're probably getting towards the reason for the administration, which I can't go into because of the High Court case, but I refer you to the previous public statements I've made about protecting the interests of members of the union going forward.
As the Minister, have you met the administrator yet?
Yep.
How often do you meet with them?
My recollection is I've met him twice and spoken to him on the phone once. That would be...
NCIF meeting.
Yeah, that's one of them.
And what matters of public interest were perhaps discussed that you are able to share with us?
Again, I probably can't say too much about that. One matter I discussed, there have been general conversations about the progress of the administration, impediments to the administration, and I also called Mr Irving when it was publicly reported that he had received a significant death threat, because I thought that was the right thing to do.
Minister, in August of this year, the ABC reported that Comanchero bikie gang members were alleged to have threatened a CFMEU delegate on a BMD building site while claiming to be the directors of Host Group, which is a security provider. This matter was referred to the Fair Work Ombudsman rather than the police. Shouldn't allegations of criminal conduct be referred to the police rather than the Fair Work Ombudsman?
Well, I'm trying to remember exactly what the allegation was, but my recollection is that the allegation... I was certainly concerned, very concerned, to read that report, and it was the first I'd heard of that. There have been allegations swirling around about the use of bikies by building employers and by parts of the CFMEU. There have been lots of those sorts of allegations swirling around, including in Queensland. But I'm pretty sure that report was the first time I'd seen anything publicly written up about the use of bikies in Queensland. My recollection is that the particular allegations that were made in that report were more of the type that the Fair Work Ombudsman would investigate rather than police. Of course, if there's criminal conduct being alleged, then the police should be involved in that. And I can't remember if you were in the room, Senator, when earlier I talked about the evidence given by the AFP last night. But I think it's pretty clear from what they said that they are investigating the involvement of bikies in this industry.
Yeah, but it'd be interesting to see if Operation Rye looks into this matter. But has any particular action been taken since this referral in August?
You'd probably need to ask the Fair Work Ombudsman that.
No worries. Okay, we will leave the rest for the Fair Work Ombudsman. Happy to share the call. Thank you, Chair.
No worries, thank you. Just got some questions regarding labour hire loophole and the priority of labour hire being labour hire agreements. So, of course, I know that under the previous Liberal and National governments that Qantas infamously split its workforce across 38 different companies using the labour hire loophole to rip off thousands of Qantas workers. Of course, the Albanese government's closed that loophole earlier this year. Now, that's despite those opposites in Parliament opposing us, the Liberals and Nationals, and voting against closing it. So can the department just go to what sort of agreements have already been reached by Qantas workers thanks to these laws?
Senator, I can start that. From reports that we are aware of, Qantas has confirmed that it will support the Flight Attendants Association of Australia's 3 applications for regulated labour hire arrangement orders to cover short-haul cabin crew. As of 8th of October, the parties were conferring on the protected rate of pay for those 800 labour hire employees, and it's expected that on average they'll get a 26% increase across the 3 labour hire employers that one relates to. In October 2024, it was also reported that Qantas long-haul cabin crew voted to an agreement to increase the pay of 2,500 labour hire crew by up to 30%. The result of that has also been that Qantas will bring those crew into direct employment, is our understanding.
Thank you. Minister, we're talking now about 30% paying underpayments, and I sort of note that at a hearing of this committee back in November on the closing the loopholes legislation, that Senator McKenzie took exception to a comment I made forecasting that she should vote against closing the Qantas labour hire loophole. And she said, I quote, "I ask you to withdraw those accusations because I am not on a unity ticket with Qantas when it comes to ripping off Qantas workers through labour hire. I am not. I never have been." Minister, do you remember how Senator McKenzie voted on closing the Loopholes Act? And did she vote with the Act?
My recollection is that Senator McKenzie, along with Senator O'Sullivan, Senator Cash, Senator Brockman and all other coalition senators voted against the government's closing loopholes legislation, which has now enabled Qantas workers to get significant pay rises.
And do you know that what the coalition's position is regards to the underpayment of workers in this space, what that holds in the future in Qantas?
Well, I think I also remember Mr Dutton as the opposition leader complimenting the former CEO of Qantas, Mr Joyce, on his position on industrial relations. So I think it's always been pretty clear where the coalition stand on Qantas issues, and that is that they always take Qantas's side, even when they were illegally sacking their workers and underpaying their workers, and it's always been Labor who've stood up for those workers against Qantas management.
So we've got workers receiving a 30% wage increase in parity for doing the same job, the same pay. We've got a clear position from the opposition that they plan on ripping those workers off again, taking 30% off them by repealing that legislation.
Chair, just for the record, I'm happy for you to embellish. I'm happy for you to put words in the coalition's mouth, but let's just be clear, that's all this is.
Well, except for the fact that Senator Hume has had that put to her in an interview, and I can try and dig out the exact quote, but she has said that a Peter Dutton coalition government would review Labor's same job, same pay laws. And in fact, Senator Cash in September 2023 said that the same job, same pay measures amount to an attack on the labour hire industry. So I think it's pretty clear what the coalition would do if they won office, just as they'd repeal the right to disconnect,
Senator Watt.
repeal the
So we've got workers getting a 30%, we're getting the same pay, and yet we've got the shadow finance minister saying that they're going to repeal those workers' wages.
Well, again, Chair, that's not what she said. And again, happy for you to embellish, but so far the proceedings are actually going quite well.
Beyond the purpose of estimates.
Well, it's now just making stuff up.
So, Senator Hume on the 15th of September on Insiders, after confirming that the coalition will get rid of the right to disconnect and confirming that they will get rid of the casuals' rights, and after confirming that they're going to look at multi-employer bargaining, and we all know they don't look at it positively. Senator Hume was asked, but the question was the same job, same pay laws. Will you scrap those? Senator Hume, well, there will be elements of that we will certainly have to consider. So I guess Senator Hume could tell us exactly what she means by that.
Well, maybe there's an opportunity to say that they're not going to interfere with same job, same pay, and those workers are
She was given an opportunity to say that they're going to stick with those laws that have seen pay rises of $30,000, $40,000 to people, and she hasn't done that.
I'm happy to rotate the call to the coalition.
Thank you. And just how much longer do we have just in terms of...
9 minutes.
9 minutes. Okay. I just want to finish off the line of questioning in relation to Minister Burke's press conference. In relation to the termination of workplace delegates, he also stated, I should add an administrator as well as having the capacity to terminate people either as employees or delegates in different roles. Can I just ask, does the scheme of administration give the administrator capacity to terminate elected workplace delegates?
Why don't we pass that to Ms Godden to determine what can be said on that?
Certainly, Senator. I might ask Mr Tracy to respond. We're both just trying to get to that particular page.
Senator, can I just ask you to repeat the question? The question is whether the administrator has the power.
Does the scheme of administration as made, so the one that's currently in place, give the administrator capacity to terminate elected workplace delegates?
So, Senator, I can take you to what is clause 6, paragraph 1F of the scheme of administration as made.
Could you read it out?
Certainly, Senator. So, clause 6 relates to the powers, functions and duties of the administrator, and it provides at F specifically, the administrator has the power, without limiting anything else in this scheme, to suspend officers or delegates, including persons whose offices were not vacated as a result...
Sorry, could you I can't quite hear you.
Apologies,
could you start
Senator.
again and just, sorry, speak up a little bit?
No, of course. So clause 6 of the scheme of administration sets out the powers, functions and duties of the administrator. In relation to paragraph F, so that's 1F, Senator, it provides that the administrator has the power, without limiting anything else in the scheme, to suspend officers or delegates, including persons whose offices were not vacated as a result of subclause 3 brackets 1 brackets A of the administered division and any administered divisional branch from office or positions respectively in accordance with clause 12.
So where was the word terminate?
So terminate in relation to delegates, Senator, is not in that paragraph. Terminate as in language-wise, the word terminate is ascribed to employment of employees.
So so as well as having the capacity to terminate people as either as employees or delegates. So does my question is, does the current scheme of administration, the one we're referring to, as made, give the administrator capacity, and this is specifically what I want to know, to terminate elected workplace delegates, as Minister Burke said it would?
So the language of that paragraph, Senator, is suspension in relation to officers or delegates? And that's what I want to get to.
Does it allow termination?
Termination is not the word used in that provision, Senator.
Thank you. And tell me, what's the difference between termination and suspension?
So termination, as it's reflected in this provision of the scheme, appears subsequently at paragraph G, and that's in relation to the termination of the employment of employees.
Yes, I want to know delegates, the workplace delegates.
Indeed. So, Senator, the delegates that would be, delegates of the division or indeed attached to particular branches are not employees of the union, so termination in that sense is not directed at that relationship.
Thank you. That's what I wanted to get to. Sorry, the answer is no. So can I then ask, Minister, are you aware if the administrator acted to terminate the role of any of the CFMEU workplace delegates?
I'm not aware, so I couldn't say one way or the other.
So, Secretary, can I just establish, Minister, how are you kept up to date by the administrator of what's occurring?
Well, there's regular discussions between my office and the administrator's staff and occasionally I think the administrator directly. But as you know, there's a requirement, I think, in the legislation for the administrator to provide a report to me every 6 months, which will be tabled in Parliament.
Okay. Secretary, are you aware if the administrator has acted to terminate the role of CFMEU workplace delegates?
Senator, I'm not aware. I'm not aware.
That's okay. That's okay. It's the answer was yes or no.
There's been a lot of material in the newspapers.
Yep, and that's why I'm trying to work through.
Much of which I'm aware of, but I'm not specifically aware of that to my recollection.
But more specifically to the point made by Minister Burke, the scheme of administration as made does not give the administrator capacity to terminate elected workplace delegates. Just in terms of other statements that Minister Burke made, he also made it clear in the press conference, in terms of wanting to give industry the confidence to speak out. Cleaning out who's in the organisation and getting rid of some of these elements is a very significant part of that, and we should not underestimate the change that would make. So again, and I think, Mr Tracy, you've got the scheme in front of you. Does the scheme of administration as currently is enacted or as made give the administrator capacity to terminate paid employees and officials of the union?
Indeed it does, Senator.
It does. And can I get you, what clause is that at?
Certainly. So that's also at clause 6.
The 6F or the 6G?
That would be 6G, Senator.
Okay. Are you aware of how many officials and employees exist within the construction and general division of the CFMEU?
I'm not, Senator. I don't have that data.
No. I've got a series of questions. So, Secretary, just in terms of you being kept up to date by the administrator, what's that process that's in place?
Senator, it's important that firstly, the administrator is independent. The administrator has been appointed under this frame. So I don't have a requirement to be kept up to date by the administrator, and given the unusual nature of his role, so he effectively is the CFMEU, and so it wouldn't, prior to this administration, be the role of the CFM or my department to be keeping up to date with the CFMEU. So it is, in terms of the formal roles with respect to the administrator, the ministers noted the reporting obligations. The General Manager has some formal roles. The administrator is operating independently and in accordance with the scheme that has been put in place by the Attorney General. And so my view is that it hasn't been necessary for me to engage directly with the administrator. I consider that appropriate channels are in place for the Minister to remain up to date as appropriate, which he's referenced. And also you can, of course, ask the Fair Work Ombudsman and the Fair Work Commission about how they've gone about engaging with the administration as is appropriate for their roles as well.
Yeah. Could I just now turn to just the appointment of Mark Irving as the administrator? Minister, why was Mr Mark Irving, KC, chosen as the administrator of the CFMEU?
Is that...
Senator, first I would note that the appointment was made by the General Manager of the Fair Work Commission. So the Minister did not make that appointment.
So what role then, Minister, did you have in the appointment of Mark Irving, KC, as the administrator?
I don't think I had any role because the decision to put the administration, the division into administration was made by the Attorney General.
So when were you advised then that Mr Irving would be the administrator?
When was I advised? I'd have to take that on notice, yeah. But as Ms James has said, under the legislation or the scheme of administration, one or the other, it was a decision for the Fair Work Commission General Manager to appoint the administrator and to determine his or her remuneration.
Just add, Senator, the Fair Work General Manager had gone through a process of inquiry himself in relation to his own application, which proposed to appoint Mr Irving as well.
Can I just confirm, did the Attorney-General sign off on the appointment of Mr Mark Irving?
We'll just check that.
Sorry, Senator, I just missed that question.
Was the Attorney-General the person who signed off on the appointment of Mr Mark Irving?
Certainly the scheme made by the Attorney-General specified that Mr Mark Irving KC was to be the Administrator, Senator.
Minister, was it a decision of the government to appoint Mr Mark Irving?
No, it was a decision of the Fair Work Commission General Manager.
So in terms of the selection process, what was the selection process for choosing Mr Irving?
You need to ask the Fair Work Commission General Manager.
So, Secretary, do you have any understanding of what the selection process was for choosing Mr Irving?
Senator, I think when we start talking about the role of the administrator and the characteristics...
This is merely the process for determining who the administrator would be.
Oh, I see. So I might ask Ms Godden to handle the questions around describing the legislation and the scheme, because there are a number of...
This is just in relation to the appointment of the administrator.
Yeah, look,
how was he chosen?
Understood. Things that go to the character and qualifications of the person might be in territory that the PII might cover. Things that go to explaining the mechanics I don't believe are, and Ms Godden is probably best placed.
So was the department involved in the selection of Mr Irving? Perhaps start there.
Certainly the department was involved in drafting the scheme of administration which specified...
I'm happy to go a little bit longer, but we're just over the lunch break. But how much more time do you need?
Quite a bit.
Do you want to come? What's?
Yep, I'll come back up. Yeah, because you're going to. I'm going to be cut off regardless.
I'm trying not to break. Sorry, I'm trying not to
understood.
break your,
I'm going to be cut off regardless.
Line of questioning.
Excuse me, Chair. Could we just correct some evidence given earlier, please?
If you could, thanks. Yeah.
Thank you, Chair. Senator, apologies. Your questions earlier in relation to sort of the termination of delegates.
Yes.
I referred to Clause 6, which in and of itself also refers to Clause 12 of the scheme. And paragraph B at Clause 12 provides that notwithstanding anything in the national or divisional rules of the Union, the Administrator has the power to suspend or terminate the employment of any employee or suspend or remove any delegate of the administered division or an administered divisional branch.
So 12B?
That's right, Senator.
Which is referred to by 6?
That's right.
Yep. Thank you very much for that.
Thank you, Chair.
Good, thank you. We'll now suspend until, is it 1:30? 1:30, yeah. Thanks, everybody. Thanks, everybody. We're broadcasting. Now back to outcome 3. Senator Cash.
If I could just finish off the line of questioning in relation to Mr Irving, because I know we do need to move on. So just to summarise, did the department have any involvement in the appointment or the choosing in the choosing of Mr Irving as the administrator for the CFMEU?
No, Senator.
No. So nothing in the selection process. When were you advised that Mr Irving would be the administrator of the CFMEU?
Well, I suppose when the attorney made the decision and then the general manager appointed him on, I think, the same day.
And prior to that, there was no involvement by the department in whatever selection process there was?
No, as I said earlier, the general manager had undertaken a bit work in relation to that as part of his own application.
No, and I just want to confirm that so we can move on. Minister, the same questions then to you. Was either your office or the previous minister's office involved in any way in the selection process for choosing Mr Irving as the administrator?
No, because as Mr Manning has said, that decision was made by the Fair Work Commission.
I understand the decision was made by the
and
Fair Work Commission.
We had no input into that.
Right, and that's what I want to know. So no input at all into choosing Mr Mark Irving as the administrator?
No, but, and remember, as Mr Manning said earlier, I think I'll express this correctly, Mr Irving was proposed to be the administrator under the scheme of administration that was attached to the Fair Work Commission General Manager's original application.
Yep.
So I'm assuming that he had settled on Mr Irving for that, and then I don't know.
So in terms of your knowledge that Mr Irving would be chosen as the administrator for the CFMEU as to be signed off by the Attorney-General, when did you become aware of that?
I'd have to go back and check, but, you know, I think it was pretty clear to everyone that the Fair Work Commission General Manager, having decided to appoint Mr Irving as the administrator for his federal court application, that it was pretty clear that he would end up doing the same thing, but I'd have to check when I actually knew.
If you could, and also the previous minister
Sure.
as well. If I could just turn very briefly to the CFMEU reporting portal.
This is the administrators portal?
Yes, sorry, yeah, I was going to say, yeah. There's an online portal that was created for people to submit reports on corrupt, menacing, improper, unlawful or criminal conduct by industry or union participants to the administrator of the CFMEU. Secretary, is this something that the department is briefed on, is aware of, has had involvement in?
I'm personally aware that it's been done, I think, because I've read about it in the media.
Yeah.
I'm not sure we had any formal role in supporting
So just in terms of understanding who receives a report, stepping out the process of what happens when a report is received, what is the time frame for a response, does the department have any information in that regard?
No. Sorry, Senator, I was just going to say there is some guidance that will be given in section 323 capital H capital A of the Fair Work Registered Organisations Act. Not completely answering your question, but there are some timeframes in that. For example, if a complaint is referred to a regulator, that is the Fair Work Ombudsman or the General Manager, that regulator, if they accept and investigate the complaint, they must report progress and results of the investigation to the administrator or other complaint recipient at 90-day intervals until the investigation is completed. That's just an example for some of the framework that is set out in the Act. But other than that, I completely agree with the
questions then
Secretary.
go to the Fair Work Commission. And Minister, in terms of the CFMEU reporting portal as well, you are aware of the portal?
Yep.
In terms of how it operates, who receives the reports, etc., do you have any knowledge of that?
No.
No.
I have personally never gone and looked at it,
That's fine.
for example.
And has the administrator ever briefed you on, or have you asked the administrator for a report on how this is operating, how many reports have been received, etc.?
I've certainly talked with the Administrator about the fact that he has the portal, about the very strong security that he placed around it to keep complaints anonymous, but I don't believe I've had a report about the number of complaints received or anything like that. If that's incorrect, I'll come back to you.
That's fine. Can I now just go to, and I'm going to table an article by Ewan Hannon, October the 10th, 2024. It is in the Australian newspaper, and my office should have it, and if they don't, they will be on their way. Murray Watt seeks urgent explanation for CFMEU organisers' reprieve. So just in terms of that particular organiser was Joel Shackleton. Minister, Mr Shackleton, as you know, was caught on video yelling at the owner of an Indigenous labour hire firm, yelling, "I'll effing take your soul and I'll rip off your effing head off." Are you aware that he's been arrested and charged for those actions?
I'm certainly aware that he's been charged, and I think it was about those particular actions.
Okay, thank you. And who made you aware that Mr Shackleton had been arrested and charged?
I think it was reported in the media.
Oh, okay, so no one's formally told you. You read that in the media.
Again, I'm happy to check records, but I don't recall receiving a report of that. I'm pretty sure that I first learned about it when I saw it in the media. Okay. But again, I'll check the reports. I'll check that if that's wrong.
And do you condemn the behaviour of Mr Shackleton?
I think I've already done that.
Well, can you?
Well, yeah,
that's fine.
What I saw, and what we all saw on video, I think is very far from good behaviour.
Right. I would actually condemn the behaviour and say I just condemn it outright. I wouldn't qualify it by saying it is very far from good behaviour.
Well, it's bad behaviour.
Yes. So you condemn the behaviour is what I'm saying.
Choose whatever words you want to use, but yeah, and I've also made the more general statement that we don't condone, as a government, we don't condone violence, bullying, thuggery, criminality, corruption in any workplace.
My understanding is Mr Irving has continued to keep Mr Shackleton employed at the CFMEU. Is that correct?
My understanding, and I think I can answer these questions okay, my understanding is that Mr Irving initially suspended Mr Shackleton's employment, and obviously there's a procedural fairness process there, that the Administrator received a response from Mr Shackleton or his lawyers, and on the basis of that response, Mr Irving permitted Mr Shackleton to return to work at the CFMEU under very strict conditions, including that he would be office-bound and not visit workplace sites. And I think we may have had a discussion previously around his right of entry rights, and my understanding, which the Fair Work Ombudsman could comment on later, is that that application for a right of entry permit, I think, has been discontinued. So that he has returned to work on very strict conditions, including that he's office bound, and there may well be other conditions that I'm unaware of.
And I'll pursue them. Are you concerned, though, that someone who is charged with making death threats and has been caught on video doing so is effectively, in your own words, still employed by the CFMEU?
Well, I think when this first surfaced, I said that I was surprised. As you know, I sought an urgent briefing from the Administrator, which I received. There are certain facts in that I'm not at liberty to discuss, but I'm confident that the Administrator weighed up a range of factors, and I'm not going to publicly criticise his decision.
Well, I will publicly criticise the decision because I don't believe that a person who makes death threats, I'll effing take your soul and I'll rip your effing head off, should actually be someone who continues to be employed by the CFMEU. But that's obviously my opinion. So can I just ask you again, are you concerned that someone who is charged with making death threats and has been caught on video doing so is still employed by the CFMEU?
Well, I think I've already answered that.
Well, you did not express the same concern that I have. I've said outright no.
Sure, but I've answered your question already.
Do you know if Mr Shackleton has kept to the conditions that you have stated were imposed on them or have been imposed on him by the administrator?
I am not aware of that, but I have confidence that the administrator, as the employer of Mr Shackleton, will be ensuring that those conditions are complied with.
And how do you have confidence?
Because I have a lot of respect for the administrator and the way he's conducting the administration.
Even though he has allowed someone to be employed that has made death threats to an Indigenous labour hire firm, the owner of an Indigenous labour hire firm?
Well, he as the employer has made a decision to employ Mr Shackleton on very strict conditions, and he made that decision based on a range of factors, some of which I'm not able to go into and that you aren't aware of.
And on what basis are you not able to go into them?
Well, there are a range of legal proceedings going on, not just the High Court litigation, but Mr Shackleton, as you say, is charged, and I'm not intending to say anything that could interfere with that criminal proceeding.
Do you know,
Senator?
or does
Senator Cash.
Oh, sorry.
Ms. Gordon.
I'm sorry to interrupt, Senator. I just wanted to say that I think we're starting to move into territory about the impacts of the administration. We'll just pay attention to the questions very closely. And sorry, I know that you need to finish that in order for us to do that. I just wanted to raise that for the attention of the committee.
Thank you for your assistance.
Minister, do you know, or does the department know, if Mr Shackleton is the only individual who has been initially terminated by the administrator, but then, for lack of a better term, reinstated?
I think, just to correct you there, I'm pretty sure that Mr Shackleton was originally suspended.
I said, so that's my, So do we know if Mr Shackleton is the only individual who's been initially suspended by the administrator, but then reinstated, for want of a better term?
I think the Fair Work Commission General Manager may have some more information on that.
Do you have any?
I understand that there have been multiple, so I think I said earlier, to my knowledge, there's been around 12 officials who had their employment terminated. There are multiple other officials and organisers, I think, as well, who have been suspended. I understand some of them have returned to work, but not all, but I don't have the detail on numbers.
Have you raised any concerns with the administrator about the fact that people are being suspended but then returning to work at the CFMEU?
No, I mean, as I say, I've got confidence in the administrator's ability to make those judgments, and the fact that that several people have been terminated, had their employment terminated, which has been opposed by a lot of other people. And the fact that there have been a range of other people suspended, that gives me some confidence that the administrator is making good judgments about the type of people who should be there and the type of people who shouldn't.
Are you or the government aware of the allegations about these 12 SAC CFMEU leaders, that they remain active and influential in the construction industry?
I've certainly seen some reports that some of those people fit that description.
And what action are you taking in relation to this?
Can I just... No issues?
Sorry, Senator. Yes, I think I was just trying to think that through. We don't want to stray into territory that might be alternatives to the scheme of administration.
How is this an alternative to the scheme of administration? There are 12 SACT officials whom it doesn't matter who you speak to in the industry, they make it very, very clear these officials or leaders are literally actively remaining active and influential in the construction industry. You have now given evidence that, yes, you are aware, not maybe in relation to all 12, but certainly in relation to some. I would have thought that the government was doing something about that.
What I think I can safely say is that it is a fact that the legislation that was passed by the Parliament empowers the Fair Work Commission, and possibly the Ombudsman as well, but certainly the Commission, to take action against people who are frustrating the administration, whatever the exact terminology is, under the anti-avoidance provisions that are in that legislation.
And I'm going to get to that exactly, yes.
And again, I think I'm right in saying it's the Fair Work Commission, but if it's the Ombudsman, they will be able to talk to you about what they are doing in that regard.
And that's fine. Have you had any discussions with the administrator about the concerns that have been raised? It's in every single state that these concerns are being raised on the ground by, in particular, people who would like to come forward but are too afraid to, and we've discussed before, they do not believe the protections are adequate for them. They fear reprisal, they fear repercussions both personally, for their family and for their business in relation to what the administrator is actually doing.
My office, I don't believe that I have personally raised that with the administrator or his team, but my office has.
Your office has. And when did they raise that with him?
I think it'd be, I think it, on more than one occasion, my office has talked with the administrator's team about these reports and certainly not directed anyone to do anything, but it's been noted in those discussions that there are anti-avoidance provisions that could be used by those authorities, and I think I'd be reasonably confident that when those authorities appear tonight, they can probably tell you a little bit about what they're doing in that regard.
Okay. And just in terms of these 12 SAC CFMEU leaders remaining active and influential in the construction industry, are you or the government aware of reports that large parts of the CFMEU membership, including hundreds of delegates, are still taking directions from these 12 removed persons?
I've seen those reports.
Okay. And just in terms, just for the benefit of just the Hansard, just to confirm, I think Mr Tracy or Ms Godden, actions such as that, if proven, could potentially be a breach of the Administration Act and or are considered breaches of the anti-avoidance provisions?
So certainly, Senator, the anti-avoidance provision in section 323 capital P of the Fair Work Registered Organisations Act provides that it is a contravention for a person to engage in conduct or a course of conduct, and as a result, another person or body is prevented from taking action under the scheme, or the administrator is prevented from effectively administering the scheme. There are also in the Act set out certain obligations for persons to assist the administrator.
Okay. Minister, do you accept that the influence of these 12 leaders in exile are causing consternation and scepticism to industry employers on the ground and people who do want to come forward?
Any issues there? I mean, I read the same reports that you do. But as I say, what I would point out is that the legislation provides some ways for these issues to be dealt with through the anti-avoidance provisions. As I understand it, the Fair Work Commission and possibly the Ombudsman are giving that consideration, and they can talk to you more about that. But again, I think we need to keep this in perspective. The administration is relatively early in what will inevitably be a long process, and I'd point to the very recent comments from the CEO of Master Builders, Ms Danita Warren, who said, and this is last week, we are seeing positive signs on the ground in terms of the changes being implemented by the administrator. So I think there are a range of views about how things are going.
In terms of enforcement, Senator, I can confirm that both the Administrator and the General Manager have standing to enforce the anti-avoidance provisions in a court in relation to removed persons and those restrictions for someone becoming a candidate for election or being appointed to an office in a registered organisation, being employed in a registered organisation, that is the Administrator again or the General Manager of the Fair Work Commission. The provisions pertaining to removed persons becoming bargaining representatives, that's a little bit broader. So the standing is given to the Administrator, the General Manager of the Fair Work Commission, a Fair Work Inspector, which brings in the Fair Work Ombudsman, an employee or a bargaining representative for the proposed enterprise agreement.
Okay, thank you. If I could just turn to the High Court challenge. Who has actually brought the challenge? Who are the parties?
Senator, the plaintiffs are Mr Ravbar and Mr Louth.
Yep.
And I think another party may have recently joined.
Oh, sorry, we have, yes.
And
so
who's the
you're
party
correct.
who's just joined?
Mr Hiscox has intervened in support of the plaintiffs.
Sorry,
Thank you, Minister.
Intervened, yeah.
Okay. Intervened in support of the
Yes.
plaintiff. Okay. When is the matter listed to be heard before the High Court?
For 2 days, Senator, the 10th and the 11th of December.
Okay. Thank you. Minister, what work has the government done to consider a contingency plan in the event that the High Court challenge succeeds?
That's really going to alternatives.
Yeah, I think, as Ms Godden has mentioned, one of the issues that is in dispute in the High Court litigation is what alternatives were or have been considered to administration. So I need to be careful here. What I think I'm able to say and I'm prepared to say is that the government has certainly given consideration to what might be done if the High Court case was to be successful, as in if the plaintiffs won. Having said that, as I've said publicly, we're confident of our position, and we did everything we could in designing this legislation to ensure that it would be upheld.
Will you be called as a witness to the High Court hearing? Is that why
I haven't been told that yet. I don't know whether I will or not.
Okay. Do you know if the Attorney General will be, just given the signing off of?
We're not expecting there to be witnesses at this stage of the proceedings, Senator.
So who do you expect would be witnesses?
Sorry, I'm saying we're not expecting that evidence will be called from witnesses at this stage of the proceedings.
Oh, sorry.
It's unusual.
Not expect. Oh, sorry, I do apologise.
Sorry,
no, that's no, it's not your fault. It's not
I'll
your
try
fault.
and be closer to the microphone as well.
Okay.
I think I'm slightly off to one side. We're not expecting witnesses to be called before the High Court. Obviously, the High Court doesn't often hear evidence in chief, given its jurisdiction. It would be more usual for the parties to agree a special case in High Court proceedings.
Okay, and is that what is happening at this point in time?
Correct.
So, so how's that going in terms of the special case? Take me through that process.
Senator, the special case is agreed.
So is what?
The special case has been agreed between the plaintiffs and the defendants.
Okay, and what's the basis of the special case?
Senator, I'm sorry, I didn't bring it with me. It is quite lengthy. I wouldn't be confident speaking to it, but it sets out in broad terms the agreed facts that the plaintiffs and the defendants have agreed, and poses the questions of law to be answered by the High Court in the proceedings.
And when was the statement of agreed facts filed with the court?
Oh, Senator, you're testing my memory.
Well, Secretary, do you know when this statement of agreed facts was filed?
Take that on notice,
I don't off the top of my head, Senator. I'm sure that we will have that information. We can probably come back to you quite quickly. It's just not written down on a piece of paper in front of any one of us right now.
Yeah, okay. Sorry, Senator, I just can't recall the date with enough confidence to give it to you.
I mean, it will become public, and we anticipate soon,
yeah.
Senator.
Well, the hearing's in 4 weeks.
Yes.
Yeah, that's right.
Senator, I can assist with this. It was filed with the court on the 18th of October.
Thank you very much. Thank you very much. If I could just turn to, there has been a Facebook post by the administrator, Mr Irving, that states that militancy in accordance with the Fair Work Act is not unlawful. This has now been raised by numerous participants, industry participants in different states with me. If you Google militant, the militant definition, it says militant means favouring confrontational or violent methods in support of a political or social cause. This is now as I said, raised concerns amongst people in the industry that Mr Irving is effectively giving the green light for union militancy. So, Minister, can I ask you, in terms of his Facebook post, militancy in accordance with the Fair Work Act is not unlawful, given the definition of militancy, do you agree that Mr Irving is giving the green light for union militancy?
Well, I think I also remember...
I might describe myself as a militant centralist.
No, this is actually quite serious. People
I am being serious.
They're actually very concerned
I am actually being serious.
That this type of behaviour is going to be confrontational, it is going to be violent if they come forward.
I definitely do not describe myself as being violent as a central...
No, that's what I'm saying. I'm saying the concerns raised with me in this regard because of the post by the administrator himself. The concerns raised are, has Mr Irving now given the green light for union militancy? And I'm asking the Minister, does he agree that in this case it is going to be CFMEU members, because that's the union in administration, that they should be confrontational and violent when advocating their cause?
No, I don't think that is correct. I am aware that some employer groups in the construction industry aren't exactly happy about that choice of words by Mr Irving, but you yourself mentioned that whatever that definition you just quoted, I think it had a number of words to describe militancy and included the word "or" in it. So
favouring confrontational or violent methods.
Or violent. So I think different people will have
favouring, like in favour of.
I think different people will have a different interpretation of what that word means. I absolutely do not believe that Mr Irving is giving a green light to violence, or however it was that you put it. And in fact, in the last couple of weeks, he issued guidelines to...
We're about to go through them.
...organisers and staff. I don't know if it was discouraging or banning, whatever the word would be, menacing behaviour, defined what he considered menacing behaviour to be, and that, again, employer groups have welcomed him issuing those guidelines as a step forward.
And it does go beyond employer groups to mum and dad businesses on the ground who have for years been affected by the behaviour of the militant CFMEU. That is the reason that they have been put into administration. They have been found now. It's been going on for years. We don't have time to go through the years and years and years, the Royal Commission after Royal Commission, in relation to the bullying, the militancy, the intimidation, the thuggery, etc., the threats. But the issue here is, with the administrator stating militancy in accordance with the Fair Work Act is not unlawful, you then have...
Well,
this is a militant union.
That's a fact.
This is a militant union.
I invite you to point me to the section of the Fair Work Act that says it's illegal to be militant.
The point that I'm making is this. You talk about
coercive,
changing the culture of workplaces and in particular the construction industry across Australia. I mean, it is a fact now. It has been infiltrated by organised crime for some time. That's a pretty serious fact. It's not an allegation.
Well, I think
it is a fact.
I think, to be fair, it does appear that elements of the CFMEU have been infiltrated by
organised crime,
and I've made that point before. I think it's also fair to point out that it would seem pretty clear to me that organised crime and bikies have also infiltrated parts of the employer side of the equation in the construction industry as well.
Well, that's not... I'm not going to dispute any of that. What I'm saying is, in relation to a statement by the administrator that is giving very mixed messages on the ground now, and it's one thing for an employer association to come out and say, this is all well and good, when I am talking to individual businesses across Australia who are now very concerned, and this statement, that basically, A, if you talk about changing culture in workplaces, but then at the same time, this statement did not need to be made by the administrator. He appears to be giving the CFMEU to be given the green light to undertake confrontational or violent methods in support of their political or social cause. The whole point of the administration is to try and change the culture. So can I ask you, do you see the inconsistency here and the concern that it is now raising on the ground?
Yeah, I think sorry, I just lost my train of thought. I have said on a number of occasions that the government does not wish to see workers' wages and conditions or safety unwound, undermined through the administration period. And I've also said that the administration is not an invitation to employers to go out and cut wages and conditions, have more unsafe workplaces, any of those types of things. So it is entirely appropriate for a trade union to take strong and effective action in pursuit of its members' interests. That's what unionism is about. Sticking together for your work colleagues, not just yourself, and taking strong and effective action. And I think that is the point that Mr Irving is trying to make, is that there's nothing illegal about taking strong and effective industrial action. Employers do it as well. I don't ever hear you complain about that, but employers do it as well, including in the construction industry. Now, Mr Irving was so concerned about trying to change the culture of the organisation that he's now running that he's issued guidelines to organisers and staff setting out very clearly what he considers menacing behaviour to be and making very clear that it's not on. So, you know, some people might be worried about a word.
Well, no, it's not being worried about a word.
They are.
It's a very serious word within an industry and a union that is renowned as being a militant union, infiltrated by organised crime, and has now been put into administration. You only need to go back to what Mr Shackleton has said. Some are saying that this militant behaviour, the owner of an Indigenous, I'll effing take your soul and I'll effing rip your head off. So you don't have any concerns.
Well, I think that would fall short of Mr Irving's guidelines, that kind of behaviour. He says in his guidelines that have gone to all staff and organisers of the union, menacing behaviour is where a person either does an act to intentionally cause or threaten to cause psychological or physical harm to another person, or does an act that would cause a reasonable person to fear that they may suffer psychological or physical harm, where the act does cause that fear. He goes on to give examples, which include threatening immediate violence in such a way that the other person believes that it may be carried out, e.g., I am going to punch you in the face, or aggressively saying, I am going to effing get you. Like, he's made it pretty crystal clear that that is menacing behaviour. And the document also
states robust behaviour in the construction industry has always been part of the culture of the sector. Aggressive behaviour on either side of the industrial relations environment has been long-standing and historical. I thought the whole point of administration, as stated by you and the Prime Minister, was to clean this industry up. And yet you have a Facebook post saying it's okay to be militant. You have a document that clearly states, despite what you said, in this particular industry, this is the whole point, this is an industry. Bullying, thuggery, intimidation, sexual harassment, death threats, you name it, organised crime, drugs, prostitution. The document states robust behaviour in the construction industry has always been part of the culture of the sector. Aggressive behaviour on either side of the industrial relations environment has been long-standing and historical.
Would you like to read the next paragraph?
Do you agree?
Read us the next paragraph.
I'm asking the questions.
So you're going to cherry pick?
I'm asking the questions, and we will go through the document. Does the government agree with that analysis?
I'll first of all read the next paragraph, which you haven't read out. However, it is alleged, and there is credible evidence, that menacing behaviour has become entrenched and constant as part of doing business in some parts of the industrial relations environment in the construction industry in 2024. And he then goes on to outline his expectations and is very clear about what kind of behaviour is menacing and what is not going to be tolerated.
and the issues have arisen that in the first instance the Facebook post says one thing. The fact that Mr Irving doesn't say aggressive behaviour is not acceptable. I would have thought that there were very, very clear lines in relation to what is and isn't acceptable. Can you at least take me through then what is the difference between aggressive and menacing behaviour?
Well, are we seriously going to use Senate estimates to have a discussion about definitions of terms? Is this a...
Well, there is in this document.
What's the word for study of words? I've forgotten.
No, I'm genuinely asking in terms of what is the difference for people on the ground, mum and dad builders, people in the construction industry. They don't have the benefit of an employer association. They don't have the benefit of talking to someone, but they are monitoring this situation. And they now believe that Mr Irving has given the green light to union militancy, that in the document that we are now referring to, there is now concern about the difference between aggressive behaviour, menacing behaviour. It's actually a really serious issue, and clearly you mustn't be talking to people on the ground that I'm talking to. You say you want to change the CFMEU, but then mum and dad on the ground are getting mixed messages from the administrator.
Well, maybe mum and dad on the ground aren't aware of the guidelines that Mr Irving has issued to CFMEU organisers and staff, which very clearly go through what he considers menacing behaviour to be, and I'm happy to read it back out to you if you want me to. And then he says, being aware of the impact your behaviour has on others is important and critical to working in the union, and you are expected to be conscious of a person feeling threatened or fearful of your behaviour. And he then goes on to say his expectation is robust and strong advocacy on behalf of members is not unlawful or disrespectful. The acceptance of menacing behaviour as a way of doing business is against union values. Acting respectfully and lawfully is expected, particularly during arguments and conflicts. I'm not aware of this union ever issuing guidelines like that to its organisers and staff. And as I say to you, the employer groups who represent mum and dad builders have strongly welcomed Mr Irving issuing those guidelines as a positive step forward.
Mr Irving also in this document states that accidental physical contact will not constitute menacing behaviour. One of the big problems with this union is that lots of things have been done either accidentally or have just happened. They've been done quite deliberately, but no one's ever able to prove that because of the threats, because of the bullying, because of the intimidation. So the feedback I'm now getting on the ground is the administrator has literally just given the green light that if you strike someone, all you need to do is claim it's an accident and you are off the hook. That is why there is mixed messages being sent here. He also states the following are not examples of menacing conduct: talking loudly during an argument or debate, simply swearing about a situation where there is no threat directed at a person, threatening to take lawful industrial action to pursue an ABA or ensure safety on the job or compliance. And again, it goes to, do you really want to see the nature of the industry change? And particular in, when we talk about swearing in the context of the construction industry and shouting in the context of the construction industry, you're not talking about everyday behaviour. I've stood up, as you know, in the Senate time and time again, and I have read out transcripts from proceedings in courts, which I was eventually banned, if you recall, by the then President.
And I reckon that'd be menacing behaviour.
It was so offensive.
Yeah, menacing.
But again, do you not understand that this is sending...
So are you seriously... You know what, can I make a confession?
Message
can I make a confession?
On the ground.
Every now and then, in my office, I swear. No. Shock. Horror.
You're demeaning
I don't swear at people.
Businesses.
I don't do a... No, the point is, what he's saying is that simply swearing about a situation where there is no threat directed at a person. I don't swear at my staff. I don't threaten people with it. But, you know, every now and then I might kick my toe and I might go a word starting with F or S or something like that. That's not menacing. That's the point he's making. But he goes on to say that if you do it in a threatening manner, he's distinguishing between menacing behaviour and not menacing behaviour. For God's sake.
Seriously?
Yes,
you should
seriously.
Come and meet
this is a man who has issued guidelines about menacing behaviour and what is not acceptable in a way that has never happened before and never happened under your government. Because you are happy to see things roll along and make political pay out of it.
By what
and that's not allowed. That's menacing behaviour.
I think it's about time we rotate.
You never swear. You never swear.
Thanks, everybody. I think it's time we rotate.
You never swear.
It's rotate the call.
Sounds like if you ever swear, we should, do something about that because that's not allowed in the Michaelia cash word. I mean, seriously.
You demean yourself.
No, I don't. I'm holding up menacing behaviour.
What has been occurring?
Thanks, everybody. That's enough. That is enough. It is now time for Senator Grogan to ask some questions. Senator Grogan.
Thank you, Chair.
And don't swear.
I shan't, but like Senator Watt, I've been known to accidentally swear here and there when I stub my toe.
Exactly.
Or get frustrated, but no,
not
I don't
allowed.
swear.
Not allowed from Senator Cash.
I think the definition is very useful.
I'm making fun of your ridiculous proposition. I am making fun of your ridiculous proposition.
Very much appreciated.
Thank you, Chair.
So if we can go back on, thank you.
Going back to same job, same pay, just for something a little different. Do you have any information on what other orders have come into effect recently? We talked about Qantas earlier. Other orders that may have come into place?
We do, Senator. We're just changing up the bench.
Thank you.
So I'll give the team a moment to open to the right page. We have been closely monitoring the use of these new provisions.
And just while you're changing up the bench, I'm particularly interested in the kind of workers, or the kind of industries that we're talking about here that you've seen this happen, and also the sort of quantum of impact on pay.
Senator, in terms of the what was called as the closing the labour hire loophole, the department is aware that 50 applications for regulated labour hire arrangement orders have been made. That's as of 4th of November this year.
So just for clarity, in what time frame have we seen those 50?
So the provisions actually commenced on the 15th of December 2023. And, sorry.
Sorry, I was trying not to interrupt, and I did. Could you just put your name tags on the in front, and also we'll just mention their names as they come up? It'd be great. Just help Hansard.
They're quite magician, but...
No, thank you. Sorry, Ms Anderson, I broke your stride.
Apologies, Senator. So the provisions commenced on the 15th of December 2023, so parties could make applications since that date. The actual orders themselves could commence from 1 November this year. We're aware that 7 matters producing 11 regulated labour hire orders have been made.
So sorry, just a point of clarification there. 7 matters since December 2023?
So they've been over various periods of time since that date. I might just get Mr Keynes to go into the details of the dates of those.
So, Senator David Keynes, Assistant Secretary, Bargaining and Industry Policy. So, Senator, we're aware that 50 applications have been made, and so far the Fair Work Commission has determined 7 of those matters, and that's resulted in 11 regulated labour hire arrangement orders so far.
And what about the rest?
So in terms of the further applications, they're still being considered by the Commission.
Okay. And the quantum, probably you just need to give me that for the 7 that have been determined.
Yeah, so in terms of there was a order that was made covering workpack employees at the Batchfire Cowlide mine in Queensland. That particular order reportedly covers 350 workers, and that resulted in an increase of around $10,000 to $20,000 per year for those labour hire employees. There was a sole employee at one business who actually put in an order himself on behalf of himself and other workers, and that was at South 32's Cannington mine in Queensland. Media reports around that particular order is that that individual would receive, and his colleagues, a 60% pay rise after
That's significant.
as a result of the orders. There's also another matter that was finalised, I think, without an order actually being made. It was settled before a formal order was made, but it was basically on the back of these provisions in relation to a number of 27 workers that were working on in the Hunter Valley, and that resulted actually in TEAS offering those 27 workers permanent employment, and they received pay rises of approximately $30,000 a year. And earlier today, Senator, I mentioned the 2 Qantas-related matters.
So you referenced that one matter had been resolved without any further action, in the sense that I assume the employer and the employees had agreed on an outcome there, therefore not requiring any formal orders. Yeah. Are you seeing any indications of that?
So, Senator, yeah, there's certainly, I'm not sure I have the exact numbers, but a lot of the matters are being agreed to by consent by the parties. And then, as I said, for example, those 27 TEAS workers, for example, there was an arrangement that they would become permanent employees.
Well, that's good to see. Like, if we're seeing employers actually choosing to make these agreements to ensure people are getting the same job, same pay.
Yeah, so Senator, in relation to the first 11 orders, they've either been made with the consent of all parties or haven't been opposed. And as Ms Anderson mentioned, the case involving TEAS employees didn't result in an order being made, but a decision by the company to engage the labour hire workers directly. We've also seen, in relation to the Qantas long-haul cabin crew achieving a 30% pay increase that was attributed to the government's reforms on closing the labour hire loophole.
Well, it's good to see them come up to the level of other workers doing the same job in the same industry. Thank you. Thanks, Chair.
Thanks very much. How are we going? Back to Senator O'Sullivan.
Thank you, Chair. Can I ask in relation to right to disconnect? Secretary, in February this year you said that you yourself have a question for you, Secretary.
Apologies.
Earlier this year in February you said that you have the right to disconnect, which you utilise. Now that the legislation is in place, Secretary, can you please outline the parameters of your personal right to disconnect as Secretary?
Senator, I'd rather not personalise it. I am not an employee, and so my situation is actually not covered by those provisions. I can talk to my own approach with respect to work-life balance. I have done that fairly extensively before. So has
anything changed following the passage of the legislation?
Well, not for me personally, no, not for me personally.
Right,
with respect to the department, it has. I will say that that the public service and the department has taken a number of steps to implement the new rules because we've moved on from cross-portfolio. I don't have that, the people who have overseen that process
sure, and I'm not going to go into
But we did provide you with some information.
Yeah, we got that in the letter, and I don't want to go to that.
Yeah.
So you did provide us some guidance. So I just wanted to understand, because obviously this relates across industry, across the economy, not just within your department. So in your scenario, are WA staff restricted from calling East Coast staff after 2 p.m, given it's daylight savings now?
No, Senator.
They're not restricted to be able to do that.
But they can if they so choose. That is what they choose as being the hours that they work, and that's the example that's given. It's a Brisbane example, but it effectively states, even if you are in, for example...
Are you referencing the information in the letter?
Yeah.
Okay.
I think it was the Brisbane example.
Will WA
read the entire
2
example out.
Sorry, I'm just going to get that.
We'll read it out so it's on the Hansard record because it's provided some confusion.
So Liam is a team leader based in Brisbane. Wagen is a APS 5 in Liam's team based in Perth, which is 2 hours behind Queensland. Liam attempts to call Wagen at 8 a.m. Queensland time to discuss a routine matter. The call wakes Wagen at 6 a.m. outside his working hours. He notices Liam is calling but does not answer. Liam calls Wagen half an hour later and wakes up Wagen again. Wagen answers the call. Before Liam starts speaking, Wagen reminds him that it's currently only 6:30 a.m. in Perth. Liam apologises and asks that Wagen calls him when he arrives in the office. Wagen later initiates a discussion with Liam to indicate it is unreasonable for him to be contacting him so early in the morning. Wagen advises that he generally will not respond to contact between 8 p.m. and 8 a.m. Australian Western Standard Time. Liam agrees to only call him during those hours if there is an emergency or the matter is absolutely critical. Wagen agrees to set his work hours in Outlook to Australian Western Standard Time and appear out of office during 8 p.m. and 8 a.m. in Australian Western Standard Time to signal appropriate contact hours to the team. So can you confirm that this policy applies to staff, to all staff in Western Australia, appreciating that we've dismissed cross-portfolio, but obviously there's an application here in trying to understand what it means for across the economy, but that would then mean that they could ignore calls before 9 a.m. Australian Western Standard Time, which is actually midday here on the East Coast.
So that's a Brisbane example with 2 hours. If you translate it to Eastern Daylight Time, it's now 3 hours, and this has caused a lot of confusion in Western Australia.
Yeah, Senator, I do remember the conversations we've had about this.
A lot of confusion
in the past. So firstly, this is an example designed to guide people in my department about having the discussions that I spoke about earlier when Senator Grogan asked me her question, to provide guidance about the sort of conversations we might have about setting preferences and boundaries, taking into account the whole realm of things. So this is an example that is designed for my department.
Sure, but
and it's an example designed to guide the department's implementation.
And previously, in estimates you've said that you've wanted your department to be a model exemplar employer across the public service, but indeed across the wider economy. So what can employers take from this? What do they need to be applying when they've got those East and West Coast and different time zones operating within their businesses?
And so I think what all employers need to be thinking about is just conscious of when and why they're communicating with people when they're not working outside of work hours, and so being conscious of a time zone and agreeing to how different time zones are going to be managed is some distance away from a constraint or a rule against it, so to speak. So in this example, Wasian is an APS 5. That's a relatively junior member of staff. In our enterprise agreement, Wasian is covered by flex time, and he'd be setting ordinary hours, and our enterprise agreement deals with the processes around setting those ordinary hours, and so it is about informing those discussions, noting the level of responsibility of people and understanding their work patterns and preferences.
And all I'd add, Senator, is that the right to disconnect, as Ms James was describing, it doesn't go to the ability of the employer to operationalise their business as they see fit. Indeed, in Western Australia, for example, in our department, we have some people, I'm aware of people who work Eastern hours, you know, as compared to people who work local hours. It more goes to the ability of the individual to not be monitoring and responding when they're not working. And that could occur because they're part-time, it could occur because they're in a different time zone. But, you know, likewise, we have contact centres who are set up to, and because we know they're going to be contacted by people from all over the country, we make sure we design their hours and way of operating around
Sure,
that.
and that's in their contract or in their arrangement that they have.
Large department. We're talking about smaller businesses that are now incredibly confused about when the right to disconnect may actually... It's actually a really serious issue given the department's guidance.
I think one of the reasons they're confused is because certain people have gone out there and misrepresented what was right.
You can say what you like.
Well,
that's
you
not
and others
true.
have said
Now
employers can't contact people after hours, which is not true.
Well, that the Western Australian operating hours are restricted to a very small window. That is actually a problem.
So you've got an out-of-office notification through Outlook that says when people can be contacted. When you take into account the difference in hours across the country with time zone differences, there's a small window then that an East and West Coast connection can happen. Look, we deal with this all the time, just contacting I'm from Western Australia, right? I get the challenge. But you're a model employer, you try to be, and this is an issue that is facing, as Senator Cash was saying, smaller businesses. So we're just trying to glean from the way that you have interpreted you've put out guidelines and interpreted the legislation, what that means for other businesses. Do small businesses need to take on the same standards?
And this kind of example and this approach is absolutely fit for a purpose for a large department. And for this scenario where we're talking about a relatively junior member of staff discussing routine business out of hours, I would not... the purpose of this example is for my department, and I'm very comfortable it's appropriate as an example in my department. I wouldn't be advocating, and it would be wrong to characterise it as if I am advocating that this would be relevant for any other business. It's up to all employers to consider their own circumstances when it comes to compliance with laws, including what is fit for purpose here. And as I said earlier in my evidence, I think in a small business you'd be having the conversation, and the conversation might end differently in a small business. I would expect.
Can I make one really actually important point? There is no right to disconnect in small businesses right now anyway. It has been deferred, the introduction of it. So all of these examples you're giving, the very best thing you could do in terms of informing small businesses is not to go out there and go, ooh. It's actually to say it doesn't come in until, what's the date?
26th
It's not about
26th of August 2025.
It's
so
not
right
about
now,
small businesses.
you've just been talking about small businesses.
You're talking about a particular definition. We are talking about businesses that do not have the resources
You were
that
talking about small
your
businesses.
department has. Well, can I tell you, there'll be small businesses who might have 30 or 40 spread across the country that are now, they're smaller businesses. They are now very confused about when their employees may or may not now be able to speak to them. And when you come from WA, maybe it's not relevant to people on the East Coast.
No,
maybe it's not.
I come
But
from
when you
WA
live
enough to understand the
and
time zone
breathe
issue.
this every single day.
I understand the time zone issue.
Okay.
Every single day.
Secretary, at what level in your department does an individual have the right to disconnect? When does that disappear? At what level? Because you said APS 5.
Yes.
Low level?
So all employees covered by the Fair Work Act have a right to disconnect. And that is implemented, as the Minister pointed out earlier today, with reference to the criteria in the legislation about what is reasonable and what is unreasonable. And that has to be considered taking into account the nature of the work, the seniority and compensation of the individual involved, the reason for the desire to connect. So we see in the example you've just read from, the reason is a matter of routine business, but for Wajan in Western Australia, it's out of his normal agreed working patterns, which managers need to be aware of in the public service. And there's a process for agreeing, recording and revising those working patterns under our enterprise agreement and policies.
Okay.
You are aware, I assume, Senator Sullivan, that the excellent newspaper, The West Australian, has a right to disconnect clause in its enterprise bargaining agreement. So
How does that
a business
How does it,
called
a business, a large
The West
business.
Australian,
How does this
couldn't get
help
more West Australian than
the
that. It's The
conversation?
West Australian has a clause in its enterprise agreement that allows its workers to have a right to disconnect.
That are asking
No,
genuine
the point I'm
questions.
making, the point I'm making is that there are businesses who operate in West Australian.
Western Australia.
Some of them are
You
called
really do.
The West Australian.
Can we just
have been able to?
Can we just
make
have a
this
break
work?
Thanks very much. Can we have a break? Can we have a break? Can we have a break for a moment? Just to assist things, we just go suspend for 2 seconds. Thank you.
So, Secretary, can you advise how many workers in Australia have an effective right to disconnect, meaning that they can happily ignore contact from their boss outside of work hours?
Senator, I don't have a number, but it is all employees covered by the Fair Work Act are covered by the right to disconnect provisions, noting that, as we were just discussing, they apply based on what is reasonable in the particular circumstances with the criteria we've previously referenced in operation.
And noting the earlier comment that it doesn't apply to small business yet. So
that's
I think that's about 42% of employees.
So is the department aware of comments from Morris?
Did you hear that last bit,
I did.
Senator O'Sullivan, about the percentage of businesses it doesn't apply to?
Small businesses.
What was the last part?
I think it's around, it's 40+ % of employees. I think about 92% of employing businesses have fewer than 20 employees. So, as discussed earlier, the right to disconnect becomes relevant to them in August 2025.
And I do want to go to those percentages. So is the department aware of the comments made from Morris Blackburn, which I understand is a firm where, Minister, you once worked.
Yep.
Where employment issues lawyer Jessica Heron has stated that if your employment contract has a clause that says your employer can direct you to work reasonable additional hours, which is effectively overtime, then the employer might have an argument that it is unreasonable for you to refuse any contact out of hours because you have that clause in your contract. Goes on to say, my sense is that it will prevent about 70% of the workforce from accessing these laws. Does the department agree with this assessment that up to 70% of the workforce could effectively not have the so-called right to disconnect?
Apologies, Senator, just before we move on to that question, in relation to the previous question, I'm being a nitpicky lawyer here, but I just wanted to clarify that the right to disconnect applies to national system employees and employers.
Yeah.
Senator, could we please have a copy of what you're reading from?
Yeah,
I'm not familiar with those particular comments.
We'll table that for you. It's a news.com.au article where those quotes are listed. Does the department agree with that assessment that only 70% of the workforce could effectively...
Can I just say, it would be fair for the department actually to have a copy. I'm fine to wait or go to another question whilst we're finding it. I think the Secretariat's trying to find it, so...
Sure.
Yeah, Senator Rockman.
This one has always...
Yeah.
This one has always puzzled me, Secretary. So in your explanatory document on the right to disconnect, you include, and I'll quote, you have the right to refuse to monitor, read or respond to contact. If you have the right to refuse to monitor, how can you possibly know whether the contact is urgent?
Senator, I think that language is very much aligned with the legislation itself.
I don't deny that. I don't doubt that. I just don't understand.
I also think...
Explain to me how it works.
I also think that maybe it's not the full reference of the legislation, so I might ask Tara Williams or Sarah Godden, happy to go either way, to just articulate how the provisions are supposed to work, noting that it is it's a right to not...
It goes on to say, unless the refusal is unreasonable. But unless you monitor, how can you know whether the refusal is unreasonable? How does it actually work?
As a practical matter, Senator, this really highlights the importance of employees and employers having these discussions. So, for example, I might say to Mr Manning, and I wish I could do this, but I'm going for a bushwalk, I'm going to be out of range on Saturday. I'm expecting that I won't be in mobile phone distance between 8 a.m. and 2 p.m.
That's not a refusal to monitor. That's an imposibility.
But that is me not monitoring.
You cannot monitor because you are out of range.
And
that is not a refusal to monitor.
So can we let Ms Godden finish the answer?
So, sorry, that was just an example, Senator. I might say that, I'm attending a very significant family event or a wedding, it's Sunday morning or something like that, that I'm going to be out of contact between, 9 a.m. and midday on a Sunday, for example. And then Mr Manning would have that awareness that I would not be able to be contacted, and we could talk through if that was going to cause any issues or any problems. It might be that I have a regular commitment to a charity or something like that on a particular time after work during the week. And if we can have those discussions, which is what the legislation is really encouraging and what that example is really going to, the importance of having these discussions so that as a manager and as an employee, we both have kind of that understanding. And Mr Manning might say as part of that discussion, Sarah, if I really need to contact you at those times because it is, incredibly urgent, I will send you a text and then I will call you or something like that, if that's possible. And then I will know when that contact needs to be made. Or I might say, look, there is just no possibility that I will be able to do that. So could you please contact one of my other staff members or colleagues instead? And we can put those arrangements in place. But it really goes to the importance of having that discussion. I don't know if Ms Williams wants to add anything.
But the example that Senator O'Sullivan cited earlier envisages a shut-off time and a turn-back-on time during which, according to your guidance, you have the right to refuse to monitor. If you are refusing to monitor, how do you possibly know whether something urgent has come up?
Can I tell you how I would handle that situation, Senator Brockman? If while I try to not disturb my staff after hours, it does happen from time to time. They are paid an allowance in recognition of them working longer hours, but nevertheless, I try not to disturb people terribly much after hours if I can avoid it. Hang on. When I do need to contact them, I might message them. If they didn't respond, I probably wouldn't get really cranky about it. If it was an emergency, you know what I'd do? I'd call them.
But they
rather than rely on them walking around all weekend on their phones, on the off chance I might send them a message. I don't want my staff to do that.
But they can refuse to monitor, Minister.
The guidance gives them that.
Honestly.
And we're not talking about larger...
Every time we have this conversation, I'm just stunned that you people don't get this.
Smaller people. Well, you might be stunned that we don't get it.
I'm getting confused. Wait a moment. I'm getting confused as asking the question. There's three people asking a question which is sort of difficult for anyone to answer, let alone for me to follow. So whoever's asking the question.
Senator,
the confusion is correct.
Senator, could I perhaps attempt to add another example? So just going back to Senator O'Sullivan, I do want to emphasise that the examples that we provided to you are fit for purpose and designed for my department. They are in no way intended to be examples for anyone else. So you asked for a copy of what we do. We've provided that to you. I think that there is a difference, Senators, between the one-off call and the way we talk about how we'd like to manage out-of-hours calls more generally. So take, for a different example, my brother-in-law is a nurse, or a retail example where, and the reason I raise these two examples is a common thing that's been put to us is, what about if there are shifts to offer? What if we're down a person and we want to offer a shift? Now, my brother-in-law might say, I'm happy to pick up any shift, always give me a call if there's a spare shift. Or he may say, this weekend, this week, I'm looking after the kids because my wife's a teacher and I need to do the drop-offs, so I don't want extra shifts, so please don't call me unless it's in an emergency and the ambulances are stacked up. So, I mean, this is about having conversations to set the parameters. Once you've had those conversations, the question of what is and isn't reasonable has been discussed. And so I think if we're talking about a small business being down a person and needing someone for a shift, if a person said, I'm a casual worker, I'm always happy to pick up an extra shift, please call me if one is available, then that is not unreasonable at all. But if a person has said, look, I just can't work weekends because that's when I have caring responsibilities, so please don't call me about shifts on weekends because I'm just not going to be able to take them, then I also think that's fair enough. So I think what's reasonable in the circumstances is about what is guided by what the parties have discussed and agreed. It's not necessarily, or each and every contact is framed within that relationship and the conversations that have been had. And as Mr Manning noted, small businesses are not currently subject to the right to disconnect, so those smaller examples, while of course the law will apply to them come 2025, are not subject to these laws as they are today.
And so why, and that's not far away, why is the, it seems to me though that what you're saying is that the department is different from the rest of the workforce across Australia?
Yes. A public service department of some 4,000 people is different from the hospital in Hervey Bay that my brother-in-law works in, is different from the IGA across the road from my house, is different from the bakery around the corner. They are all different, and the provisions are designed to cater for the circumstances of businesses and individuals.
But the law is consistent across all of those businesses.
The law is consistent, but it applies subject to a range of criteria that take into account the business's circumstances as well as the individuals.
Okay. So
Senator O'Sullivan, could I give you just one practical example of someone who has described what this means to her, because it might just clarify a few things. So this is a quote from Anna, an aged carer in Western Australia, of all places. She says, "The right to disconnect from work will be life-changing for workers in home care like myself. I work in aged care as a domestic assistant for a national company who rely on us to constantly check our rosters, as they can change day to day, hour to hour, even when we aren't on shift. We are expected to take work calls and respond to work-related emails outside of paid time. We don't get an out-of-hours allowance to do any of this work. Our managers expect us to be constantly on, even when we're not rostered. The right to disconnect changes will give us aged carers a chance to rest in between shifts without being called into the boss's office. We already work in a high-paced and stressful environment, and the right to turn off our work phones when we aren't on call will be life-changing. It gives us time to spend with our loved ones so that when we come back to the next shift, we are rested and ready to care for elderly Australians. That's what this is about."
So, you've now got a copy of that article. What takes precedence? The right to disconnect or the employment contract, which says that you have to work reasonable additional hours?
I can see how, yes. So, what I think this quote does is it conflates two things, which is the legislation and then what employment contracts say. So my view would be, and it also talks about reasonable additional hours, which is not about the right to disconnect. This is about your hours of work and your rights with respect to your hours of work. And so I don't know how the journalist framed the question to Ms Heron, but I do see the reasonable additional hours reference. It makes me think perhaps they were talking more broadly. But in answer to your direct question, the right to disconnect, those laws prevail over anything inconsistent in an employment contract. However, the employment contract would inform that question of what is reasonable, because the employment contract represents what two parties have, of course, agreed. And so it's one of the factors, noting also that your employment contract determines your seniority, it determines your pay, but all of which are relevant to the application of the right to disconnect criteria in determining what is and isn't reasonable. I don't know where that 70% figure doesn't ring true to me. I don't know how you would come up with a number like that, because what this seems to be doing is talking about employment contracts. Of course, none of us know what the sum total of employment contracts around the country say about these things. What we do know is that the right to disconnect provisions take into account what's reasonable in the particular circumstances, which means every business and every individual working in them and every employer, all of those circumstances are considered, are taken into account.
So you're saying then that there's the right to disconnect is actually some sort of sliding scale depending on what level the person would be at. At one end you've got workers that can never you can never contact, and the other end you can contact them at any time, but most will fall maybe somewhere in the middle, and depending on what's actually written in their contract, not what's determined by the bill, the Act.
Could I just clarify too, the right to disconnect is about refusing to accept contact or monitor contact. It doesn't prohibit contact by the employer.
Yeah, I understand that.
Yeah.
Well, Senator, I wouldn't use that language, but if we look at section 33M sub 3, so the factors you've just mentioned are factors that 33M3 deals with. So you mentioned, I think, remuneration and seniority. So 333M3C talks about communication and, compensation and the extent to which a person is compensated to remain available to perform work in the period in question or to work additional hours outside of ordinary hours of work. Sub D talks about the nature of the employee's role and their level of responsibility, which are the two factors I went to, noting that the example we provide that you took me to, that is in the department's guidance, both did reference the question of seniority, or it told us the level of the people. It also told us the reason for the contact was a non-routine matter, noting that 33M sub 3A goes to the reason for the contact. So the things that are taken into account involve situational questions, nature of role, nature of business, and also factors that are about the particular contact, the reason and method of it.
Conscious of time, Chair, we can put the rest of our questions for outcome 3 on notice, and then move on if you
can go to outcome 1. That would be wonderful, so we can release everyone who's involved with outcome 3.
Sorry, that's outcome 3 done, is it?
Yeah, done. Yeah. Employment, yes.
No worries, thank you.
Now, employment services. Yep. Just suspend. Broadcasting, and I'll go to Senator O'Sullivan.
Thank you. I'd like to ask about the licence reviews, please.
Senator, sorry, some of our people are still making their way up from the waiting room.
We might just suspend again. Okay, we're ready. Right to go. Yep.
Thank you very much. So I wanted to ask about the
Senator
licensing.
O'Sullivan. Yep.
Thanks, Chair. Just want to ask about the licence reviews. The employment service licence reviews use a scale of 14 different measures. Is that correct?
Tanya Ishnew, Deputy Secretary, Employment and Workforce Group. Senator, the licence review actually looks at a whole range of factors that are connected to a provider's performance, their current licences, which are due to expire at the end of the financial year.
Yeah.
One of the things it takes into account is the performance framework.
Mm-hmm.
The performance framework has 15 different elements, but it's one factor that is taken into account in a broad range of factors that go to the licence review.
So it's 15, not 14. Sorry, my question was, is it, just confirming, is it 15 and not 14?
So, as I mentioned, Senator, if you're speaking about the actual performance framework that applies to all of Workforce Australia, there are different elements within that performance framework. There are 15 different elements within that performance framework.
Okay.
But the licence review takes into account providers' performance, but also what they committed to in their original tender, how they're performing against deed and guidelines, any other material that is relevant to their performance.
So the letter dated the 10th of October that was sent to providers, I believe, said that there were 14, not 15.
So, Senator Alice is the Acting First Assistant Secretary. It is 14. Yeah.
Oh, thank you for that correction.
Thank you.
Sorry.
No, thanks for clarifying.
Yeah, thank you.
That's good. Yes, because I want to make sure I'm talking about the same thing. Okay, so are any of the 14 measures weighted slightly more than others? Is there any weighting on those individual measures?
So, once again, Senator, that goes to the performance framework more broadly, and Mr Campbell can speak to the particular measures, how they're calculated, how they're arrived at. The annual licence review doesn't apply any particular weightings to criteria, and it assesses a whole range of things. And if you're referring to the letter to providers,
yes.
And I'm assuming that you're looking at a letter I had dated on the 11th of October.
That's correct. So, Ms Edwina Spanos, Acting First Assistant Secretary, Workforce Australia Provider Support Division. So I just want to clarify, Senator, you're referring to a letter sent on the 11th of October to all Workforce Australia providers with a licence?
I was told it was the 10th, but what I'm looking at on my screen has got the topic cut off. So if you're telling me it's the 11th, then that's fine.
Yep.
But this is there's a table on there that's got the different measures, and then the second column is the rating.
So the letter that was sent on the 11th did have it started with, I am writing further to correspondence from the department on 1st of October 2024 to provide additional information on the licence review process. Is that the one you have in front of you?
Yeah, so for example, it says the 12-week outcome is moderate rating. For Indigenous, it's high. For all, it's high. But then when you go down, it gets to job search quality, it's low, for example.
So, Senator, it might be helpful if we can have a copy of that
Sure.
letter so
We'll
we know that we're referring to exactly the same letter that you're referring to.
Yeah, we might just need to redact any of the
It might help.
personal.
Do you have who signed the letter?
We'll get that for you. So let's just discuss it then at more of a higher level, and then we'll come back to you with when I get a copy of that letter so that we can go to that specifics. So just so we understand it, if a provider receives a moderate to high rating on all measures but then receives a low rating on the job search quality participant submeasure, what would their overall rating be?
So I will throw to
Ms.
my
Campbell.
colleague to
discuss
sure.
that.
So Senator, the way the framework works is there's 5, as we said, there's 14 measures. There's 5 modules overall, under which those 14 sit. And I think your specific question went to the... sorry, which measure was your specific question to?
Well, the job search quality participant sub-measure.
Sure, yeah. So that sub-measure, if the provider received a low in that, it would not result in a low overall because it sits with another sub-measure. You'd need a low in both to receive a low overall.
Okay, so what percentage of licences received a low rating on the job search quality participant sub-measure?
So I don't have the exact figure in front of me, but it was quite a high proportion. It was, I think, maybe 94% in that sub-measure.
And then, so what percentage of those which is obviously 94% is high, but then also received a moderate to high ratings on other sub-measures?
I'd have to, just give me a second to see. We can certainly take that on notice. I can see what detail I've got here, if that's helpful.
And so would they have then got a low rating overall?
So again, if the provider received a low for the job search quality participant sub-measure, they'd only receive a low overall if they'd also received a low for the what we call the tailoring servicing sub-measure, so the points-based activation system measure.
Okay. Has the department introduced additional processes in your online IT system within recent years? And if so, what are they?
So Senator, we certainly have a range of improvements we've worked through with the IT system. I might go to colleagues who would be able to give a bit more detail around that.
So, Senator, the department is updating a range of IT systems as it goes. So, for example, most recently around things like introducing Parent Pathways program, it updates the IT. We do a review of IT rules and business rules end to end. We might introduce different fixes to those rules, and we've been working through improving the way that the IT functions, particularly for providers and for users, through some of the measures that were introduced in the budget. So we're working through a user group to look at what are the things that are most critical and most difficult to navigate, and trying to improve those over time. So I couldn't give you a list of all of the IT updates that we've done.
Okay. Well, maybe take that part on notice. But what does it mean? Just had feedback that processes then take longer for providers to find information. Have you had that feedback?
So certainly we've had some feedback from providers, and an ongoing conversation that we have with some of the peak bodies has identified that some of the processes are harder for providers to navigate. We will often work with providers to look at where can they do that easier and how do we help them navigate the system. So it's feedback that we've had more broadly.
And what would happen, what's the impact and implication for the provider if the system is impeding them and it's taking them longer? Does that have any bearing on them and their assessment of their performance?
So it shouldn't impact on their performance because the performance measures actually measure how are they servicing users. Like I say, we've had feedback from Nessa as the peak body to say that providers are spending more time on administration than they would like to or should. And like I say, we work with them continuously, but it shouldn't impact on their performance.
So what would happen if it's the department's fault, as in it's, the system itself is cumbersome for someone to find the information? What would happen? Is that then the department's fault, or?
So, as I said, Senator, we work with providers to try and make the system easy to navigate, but we also have measures that actually look at how does the system perform and are providers doing the right thing. And one of the things that we look at more broadly, and as I said, in the context of a licence review, we take into account a whole range of factors that might impact on provider performance. It should be said most providers are actually doing relatively well.
So could providers receive, if they've received a low rating but it's the fault of the department, what would happen in that circumstance?
So, Senator, it's hard to imagine how a low rating for a provider would be the fault of the department. But you know, it's hard to understand how the department's systems or processes would have impacted on their ability under parts of the performance framework to actually not be able to deliver those services. But one of the things in the context of low ratings, we've actually given providers an opportunity to say, are there any extenuating circumstances that might have impacted on your low rating, and given them an opportunity to provide evidence of this.
Okay, so the performance results were released on the 26th of September, as I understand it.
So,
Senator, is that correct?
Senator, they were provided to the providers on the 26th of September, so we have a process where we'll provide them to the providers in the first instance and then release them publicly. We released them publicly yesterday.
Okay. So providers were advised on the 26th. It's now public, that's presumably through your website.
Yep.
So it's now available for everyone to see as of yesterday. But the next period started 4 days after they received notice. Is that correct?
So they were the June results. If they were provided to them in September, if that date's correct, then that would be right.
Provide them a great deal of time to an opportunity to improve, does it?
So Senator, with the performance results, they're released quarterly, and what we aim to do is circulate those to providers as soon as we can. But of course, with a few of the measures, you need to wait for the data to come in, then you need to work through that data, quality assure that data and so on.
Because quarterly, is that right?
It's quarterly, but also with most of the measures, they're provided separately to providers on a monthly basis. So there is an opportunity for providers to sort of regularly check in terms of performance, and indeed that's what we do through our contract management functions as well.
Okay, so the outcome that they received, they were notified of on the 26th of September was for the end of June?
The June quarter. Yep.
And then the next period commences on the beginning of October. So is that right? Someone
October, November, December, yes.
That's correct?
Yeah.
Okay, thank you. So my point is that like they're then going to be assessed again, or when the next reporting period is providing that data, they're then going to receive feedback on a period that they didn't have any feedback on because they've only just got it now. Well, they got it 4 days before that period of reporting ended.
So I think, Senator, a couple of things. Firstly, I think, it is a sort of a backward-looking performance result. I mean, by definition, it looks at how the providers had performed in previous quarters, but then what will complement that with is the monthly data as it becomes available on performance.
Was this the first round? No.
Sorry, in what sense?
This is the first round of reporting?
No. So we've provided results. The first public release.
Why does it take almost the full quarter in the preceding period to get their feedback on the proceeding period?
So again, Senator, in this particular instance, we had 14 measures and we had a number of measures that we had to sort of work through, make sure we were comfortable with before we released that data. So we certainly aim to do it in as timely a way as we can, and as I said, it's supplemented by that monthly data that comes out.
So are you working on trying to get it to them earlier?
If I may, Senator, Anna Ritson, Acting Assistant Secretary, Provider and Program Performance Branch. We do provide providers with a number of data products, a number of information products that are available to them, so they're able to track their own performance. So we do have monthly data, as Mr Beasley said. We have other reports available to them through different channels as well.
But certainly, Senator, I mean, I'm keen to get that information to the providers as soon as we possibly can. Yeah, absolutely.
So then, what advice has the department, and maybe this is a question for you, Secretary, has the department provided to the Minister's office about this round of licence renewals?
Senator, we've had a number of discussions and provided some formal briefing to the Minister. I will ask the Deputy Secretary just to outline the specifics of that.
So, and Senator, once again, can I just clarify, the performance framework and the performance ratings, the performance framework has been in place since Workforce Australia first commenced on the 1st of July 2022.
Yes.
So providers have always known every quarter, like, you know, we're working to basically tell them how they're going against various measures. This is the first annual licence review that's being undertaken under Workforce Australia. It was included in the deed and guidelines, so once again, providers always knew that their licences would be reviewed. It was anticipated to be done annually, but given that we had the white paper, the select committee report and a whole range of changes happening last year, we let providers know that we would delay that annual licence review. So this is the first annual licence review that's being done under Workforce Australia deed and guidelines. We've given providers clear messages and correspondence to really clearly say performance ratings are one factor. There are a range of other factors the department will consider. Let us know if there are extenuating circumstances that impacted on your performance and give us some, evidence of what you've done to fix them and how you're going about it. And this is in the context of all of these licences were due to be considered for renewal before the end of the financial year. So the annual licence review is taking into account some of what Mr Campbell has identified in terms of performance reviews, but actually a broader suite of things, and that includes the requirements of the Workforce Australia Service Deed of Standing Offer, the guidelines, the guarantee, what that organisation said they would do as part of their tender, any other factors with a reasonable connection to the performance. So we're trying to do a holistic review, and that should result in letting providers know whether their licence will be renewed, whether it'll be extended for a year, 2 years, or whether they're up for review because actually we're looking at a whole range of factors which may mean their licence isn't reviewed or there might be conditions placed upon it.
Okay. And what's the time frame involved in that?
So we've said to providers to get us their information by the 1st of November, which most of them have. We will now review all of that information, and as you can imagine, there's quite a bit of information to go through to make sure that we've got a robust, defensible, procedurally fair process to actually review all of the information that we have. And we've told providers that we will get them a result by the early in the new year. So we've said February 2025 to enable them to have time to adjust and look at what their business share is.
Okay. And Minister, what steps is the Minister taking and planning on taking with this round of licence renewals?
Well, the renewal and review process is being undertaken by the department, and I'm not interfering in that. I have recently, as in a few weeks ago, met with at least 2 of the peak bodies in this space and have heard some of their concerns, but we've always been clear that the licence review was going to occur, and I have no intention in interfering in those decisions.
Okay. Thanks, Chair.
Thanks very much. Senator Lambie. Senator Lambie.
Discussing matters of state, Chair. Sorry.
Security. I just have some questions in reference to the. My office has sought the assistance of the department for a particular matter relating to the PALM scheme. We inquired in July and still haven't been resolved. How many outstanding matters relating to the PALM scheme workers' compensation are there at the moment?
Senator, we'll just get the appropriate people to
Thank you.
the table. Can I just clarify? So you're
And I
talking
need
about
so this is about
workers' compensation
claims?
claims?
This is about workers' compensation.
Yeah.
with those people, and also about the housing of them?
Yeah.
If I may. I don't have a lot of questions, just a few. So my question would be, how many PALM workers have outstanding matters relating to the PALM scheme workers' compensation at this present time?
Good afternoon, Senator. Jason Stott, First Assistant Secretary, Pacific Labor Operations Division. The total number of workers that have active compensation claims is something we would need to take on notice. It would be a reportable incident to the department, but it's not data that we have with us today.
Okay, and how many of them, before those workers' compensation matters are resolved, are sent home?
Again, we'd have to take that on notice to be specific, Senator. I would suggest that my experience and the experience in the program is that it would be not common for someone to be sent home, certainly not at all lawful to send someone home purely because of a compensation matter, but my experience is that folks, workers who participate in the program actively manage through recovery in order that they continue to participate in achieving their employment outcome through their deployment on the program.
Okay, because I have had one matter now for 4.5 months with your department, and we're not getting much feedback, if any at all. Okay, so
Senator, if we could assist with that matter,
that'd be wonderful. Yeah. Finally, that would be great. And I'm sure this person that has a terrible back injury that got sent home and left in the lurch would appreciate that.
Sorry, Senator, can I just update there? While we can't discuss the particulars because of privacy of particular individuals, I think the matter that your office has raised with the Minister's office, we have made sure that Work Cover is covering, that we've got clear understanding of them getting medical treatment coming back to Australia, and any PALM worker that is unfortunately injured on a work site would be covered, and their medical expenses would be covered under the scheme.
Supposedly, yes. That's how it's supposed to go. Okay, I just want to ask about housing. We've had a big local, you've probably heard about this, like big local government with Latrobe Council down there had a fight in the AAT over this. They won that. But my questions are this. How is it that a 5-bedroom house in Shearwater in Tasmania, which has outstanding code violations, including planning, building, fire and environmental health codes, can be approved to accommodate up to 77 seasonal workers under the federal government's PALM scheme?
So we are familiar with that.
Are you? So maybe you can explain to us how that is.
That accommodation is not approved to participate in the scheme and has not been since February of 2020, going all the way back to the previous department's DESI administration of the seasonal worker program. We were advised by the council on about the 5th of February 2020, and we ceased the authority for that accommodation to be approved in the program on the 6th of February that same year, 2020. It's not approved, Senator.
So how many organisations have had their approval to participate in the PALM scheme revoked?
I'm tracking 5 terminations in the program in recent times. The majority of those terminations have occurred either through mutual agreement or through actions under the Fair Work Ombudsman.
And has the department completed an audit into the accommodation standards of PALM scheme workers?
We're completing a review, not an audit, now, and we've previously conducted assurance activities to check on compliance.
So maybe if I could just add to that, Sue Saunders, Assistant Secretary, PALM Delivery Branch. All accommodation is assessed as part of a recruitment plan, and we assess whether or not the accommodation plan actually meets the standards set down in the PALM deed and guidelines for approved accommodation under the scheme. There is a regular ongoing cycle of compliance and assurance activity and monitoring visits that are undertaken to ensure that the accommodation that has been approved as falling in line with the standards that are set out in the deed and guidelines remains meeting those guidelines at different instances, so passages of time. So it is a matter of the accommodation arrangement that is proposed by the employer is considered by us, it's approved by us, or it is not approved by us. Oftentimes we find there is a fair amount of going back and forward with an approved employer to get it to the standard where we are prepared to actually approve it as an accommodation site for palm workers. And then once it is approved and it is occupied, then there's a regular kind of ongoing monitoring and oversight of those accommodation arrangements through site visits.
So I guess I want to know this. How is it possible that despite an emergency evacuation of that property that we're speaking about initially by the local council, seasonal workers were again allowed to occupy the property utilising the loophole in the guidelines which allows individual tenancy agreements to bypass any appropriate inspection or assessment process? Can you explain that to me, please?
The house Senator goes to, there's no authority for the department to prevent a person, a worker in the scheme, from electing to select their own accommodation. It's a civil liberty open to those people. The department did not and has not approved the accommodation. This is in the Shearwater site, going all the way back to when its authority was removed in February of 2020. So those workers were able, like any other worker, like any other Australian citizen, able to select their own accommodation. When we became aware that those workers had moved into that accommodation through a referral from the Minister for International Development and Pacific's office to us, that was in 2023. We had people on site within 3 days, and we'd been in contact with the City Council on the same day or within 24 hours of that referral, and worked with the employer of those workers to remove them within days of the referral coming to us.
I have no further questions. Thank you.
Thank you, Senator.
Good, thanks very much. That's very good timing. Now just going to go on the break, but just before we do that, 3:25. Yep. We won't be requiring, so we can excuse Safe Work Australia and the Asbestos and Silica Safety Eradication Agency. So thank you very much for coming, but you won't be required.
That's okay. Thanks for the early notice.
Thank you. We'll now break until for 10 minutes until 3:40. 3:40. We can start. Senator Tyrrell.
Thank you so much. I have questions about the Rebuilding Employment Services report from the Select Committee on Workforce Australia Employment Services, and in particular recommendation 75 for a pilot jobs hub program in Tasmania.
Thanks.
Thank you, Senator. We'll just bring the appropriate people to the table.
So, Senator, as you would be aware, the Select Committee had that recommendation about the government starting conversations early with Victoria and Tasmania. I think at the last estimates I said we've been having some productive conversations with Tasmanian officials at the officials level, and particularly around areas that we might look at better combining effort around services. So discussions are ongoing at officials level, but I don't know that we can actually provide you with any concrete outcome at this point in time. But we are having conversations with the Tasmanian officials.
I've got lots of questions, but how about I roll through a few and you'll just go, oh, it's ongoing. It's ongoing. I hear that.
Yes.
But in June, the Department of Employment and Workplace Relations witness said in June they were discussing the possibility of a pilot's job program with the Tasmanian Victorian governments. The recommendation stated it should be acted on as soon as possible, but that was almost 12 months ago, and estimates were, not that long ago, but a little while ago. So we're still having ongoing conversations. It's not a definite no, and it's not a definite yes yet.
And Senator, I should say we have those ongoing conversations. Obviously, there's a range of things happening at state government level and local government level as well. But certainly with both Tasmania and Victoria, but Tasmania, we've certainly looked at how they've approached some of their economic development work, and particularly both in Hobart and in the northwest in particular, and looked at how do we better share information, how do we better understand the cohort of people that we're servicing, what would better link services for users on the ground. So I can assure you we're having, ongoing discussions, and they are becoming much more kind of granular.
Excellent. In that vein, though, can I get copies of any of the correspondence that you've had that I can have access to?
We'll take that on notice. Some of it will be official meetings, meetings between officials that might have some notes but won't be a kind of official correspondence, but we'll take that on notice.
Thank you so much. Has the department done a costing for a Jobs Hub pilot? I know the committee recommendation was 50% of the cost of the program.
So, Senator, we would not normally kind of talk about costings that might be part of budget processes, for example. And one of the things that we've learnt from things like the local jobs program is often the hub pilots actually look at how do you bring together governance and existing funding and services. So the costing might be actually fairly small in terms of actually how do you improve governance and services with what's already there. But I couldn't reveal any budget costings, obviously.
I know that their ask is not huge in comparison to other things. The Tasmanian government said this partnership would require changes to the Commonwealth Employment Service system, including reducing compliance, focusing on personalised support for clients, and changes to how the employment fund is administered. Is the Commonwealth prepared to make these changes for a pilot partnership?
So, Senator, that really goes to a decision of government, so I couldn't go to those specifics, but they are issues that are part of the conversations that we're having in terms of how do we make sure that, for example, state government funding remains focused on the people and the users that they can best service, and how do we link in with them to make best use of our existing systems.
And this is where I redirect to Senator Watt and say, Senator Watt, what do you reckon?
Senator Tyrrell, always good to have you here. We're obviously in discussion with the Tasmanian government, as you heard, so I can't really go into where that is up to in terms of detail, but you will have heard me and other members of the government already make comments about the general direction we want to go in terms of employment services reform, and some of those issues are the sort of general direction that we want to go. What we can do in this pilot is still yet to be worked out, but that is the general path that we want to go in terms of the overall reform.
So basically, ongoing conversation, there's no necessary hold-up, No barrier that we need to overcome in the state government conversation?
Not from my perspective. There are always issues around funding needing to be secured and things like that, but I'm not aware of any barrier from the Tasmanian government end or anything like that.
I'm not going to get an election promise out of you today.
You are not, I'm afraid.
Shame. The government response to the Select Committee report was around 20 pages long and was pretty vague. We hear over and over again that the employment service system is broken, something I know from working in the sector many, many moons ago now though. So what is the government putting in place right now to redirect its focus to fix it?
So, Senator, you're right, the government response was provided on the 4th of July. And one of the reasons, obviously the Select Committee report went to 76 recommendations, a lot of detail. And so rather than going to each recommendation specifically, the government response looked at 8 key themes and the commitments from the government in terms of the direction of the reform, the commitments in terms of both the Select Committee report and the white paper. And the government also announced at budget some of those immediate and urgent issues that were flagged in the report. And you might recall the Select Committee clearly stated there were some things that the government needed to consider in the first urgent and immediate part, and then look at a longer term reform process, knowing that the reform was going to be complex. So there's a range of budget measures that were announced that we're implementing that really go to some of the direction of the reform. And I can kind of go through all of them, but if I give you a flavour in terms of how we're trying to strengthen integrity in the compliance system and actually give people time to reconnect to employment services if they've had a disconnection. So that's recently been increased from 2 to 5 days. That started on the 28th of October. We've looked at how do we improve some of the IT systems that were raised earlier to make it easier to service people. We've got a commitment to paid employment pathways that looks at both redesigning wage subsidies and working with employers to actually get some of those people who are longer term unemployed people into sustainable work, and also a stream around work foundations that is working with social enterprise, particularly for people who have complex vocational barriers to employment, and looking at how do we better trial, intermediate labour markets. So there's a range of funding we can go through there. Better recognising individual circumstances.
Complex barriers. Is there any work going towards those coming out of prison, out of jail?
There is, and that's one of the kind of most exciting initiatives. There was a commitment to a new prison to work program, particularly for First Nations people who, as we know, are overrepresented in the justice system. We've just finished the first phase of consultations around, it's now called the Reconnecting to Employment and Learning. Thank you.
I was going to say, it's a great title.
And in part, the title is reflective of the consultations and the feedback that we had from people who are currently incarcerated, people who were previously incarcerated, First Nations people and organisations about destigmatising the labels. So we've just finished consultations. Phase 1 of that will start in up to 27 locations from the 1st of July next year. And we're just working through, we're working through with all state and territory governments.
We've only got one prison, so yeah. Put it on the list.
So, Sharon Hundra, Acting First Assistant Secretary, Employment Strategy and Policy. Yes, we have just had some consultations in Hobart last week and an intention to have the program operate from Wisdom, and discussions with the Tasmanian State Government around that.
Okay. Beyond the wire would be an easier one to remember than that label. But so, Senator Watt, I'm going to ask again, can we please have a pilot hub in Tasmania? Because it's in the recommendation. Can we make it a top 5 recommendation, do you think?
We are giving it serious consideration, Senator Tyrrell, and I should note that other Tasmanian senators have been advocating for this as well. I'm thinking people like Senator Urquhart and Senator Polly in particular.
We love a good team, Taz.
Indeed. So there's some good discussions happening, and you'll be one of the first people to know you'll be in the top 5 to know if and when it gets concluded.
Thank you. That's all, Chair. Thank you so much for your time.
Thanks very much. Senator Colbeck.
Thanks, Chair. We have our palm people back to this.
You up there.
Told you not to go too far. At the last estimates, we had a conversation about the situation at La Trobe, and some conversations were had there around particularly accommodation that was not secured through an employer. So it goes to the point that you made before, Mr. Stock, in relation to the right of people to choose their own employment. But this is where the loophole in the system is, and this is where the circumstance at La Trobe became a serious matter of exploitation of people. 18 people in a room in that particular site, an evacuation ordered by the council, which then brought in you to assist with finding accommodation to support them. And at the last estimates, I was asking about what measures might be used to reduce this exploitation, and the conversation came back, and there's a response to my question on notice, which effectively goes to question on notice SQ 24 00797. The last paragraph in that talks about improved employers must advise the department of the address of any accommodation that is privately arranged by workers, so the department is aware of the location of workers in case of an emergency. Right? So we know where they are, is the point that I'm trying to make out of that, because there's a requirement for the employer, an approved employer, to know where they are. I also asked about engagement with local government, and I just want to go to something that was passed at the Local Government Association, and I just wonder what your conversations have been around that, because they were asking for some specific measures to link the knowledge of where people are to some sort of requirement for a range of criteria to be satisfied for an approval for people to stay there. Are you aware of that motion that was passed at the Local Government Association conference recently?
Yes, Senator, we are. Yeah, yes. If it's helpful, can I start with your first point about? Sure. Yeah, I think it's helpful to put in context rather. The most recent occurrence in about February 2023, where the particular accommodation that initiates this conversation that we discussed last estimates, that occurred at a point in time under deed and guidelines conditions that are different. The importance of acknowledging that is, while it's not possible to completely guarantee we can monitor in absolute terms the absolute safety of everyone all the time, the circumstances now are different, so it is less probable those circumstances could emerge again. I can say that with confidence because one of the new requirements of the scheme is that the workers who participate in the PALM scheme have a welfare and wellbeing person or their employer engaging with them quite routinely on welfare and wellbeing plans. So it seems to me sensible that were folks living in that arrangement with a high number of people in inappropriate accommodation, it will be less likely to stand the test of reasonableness when they have those routine engagements with a welfare and wellbeing person. And if those things weren't occurring, it will come to our attention through our assurance, monitoring or compliance activities, and then the employer would experience conversations with us would include our compliance interventions. So where I'm going to in that is that circumstances radically changed between February 23 and late June 23 when the new deed and guidelines commenced.
Okay, so I'll just go to there's a number of dot points in the Local Government Association motion that derived out of La Trobe Council and was passed subsequently at that process. Is there a requirement in the wellbeing element of the system, if we put it in that context, to ensure that provisions of this nature are met? I mean, they're talking about effectively having a process that refers back to check that certain things that are required under the Local Government Act, provision of plumbing certificate compliance authenticated by the local authority, for example, so that they, I mean, those are actually requirements of the welfare element of the program?
So that degree of specificity doesn't sit within the program guidelines. What does?
So what do I go back and say to the council, who's really been agitated about this? We talked about the fact that they've been harassed by the owner of the property. There's been a whole heap of publicity about it. Some of the councillors feel as though they've been threatened. They, the owners of the property think they've done nothing wrong and say they will do it again. Talked about challenging the hearing in the council. How do I go back to the council and say we're confident that the new design rules of the program have taken up the things that you're concerned about and will be, and they are being encapsulated? Because my conversation with the Mayor last week was that nobody's listening. So how do I go back to him and say this is being incorporated into into the program, the way that the program works, the welfare assurance for the workforce, for all the reasons we talked about last time? We don't want bad messages going back to the country of origin of the people. It's an important workforce. They're making a genuine contribution, which flows both ways, but we want the right experience.
Yeah, we absolutely do. I'll make 2 points and I'll hand over to Ms Saunders. We're currently reviewing our accommodation settings as part of the review of our on a natural review of the deed and guidelines. We made a commitment to come back to focus on that, and I've checked with my team who tell me we are reaching out to, in particular, local government association. There are 537 local government areas in Australia, so we need to moderate that, but we are seeking those views. In terms of the new settings, there's an active duty that applies to an improved employer to ensure that when one of their workers, if that worker is electing that to make the choice to move into private accommodation, for want of a better word, that those workers are aware of their rights and obligations. Yes. So both their responsibilities for care of the property and occupation, but also what they should expect in terms of condition and the state and territory's tenancy requirements relevant to the particular way that they undertake that by state and territory, that they know how to execute a requirement for repairs or maintenance of the property to ensure if it does fall into disrepair and it's not their responsibility, not their fault, that they can have that repaired, and that the worker is aware that they can actively seek support from their employer, the worker or welfare, or reach out to the department through our grievance process or even just our 1800 line to seek further support if those circumstances emerge. That's a requirement in about Part 10 of our guidelines. That's just to ensure that we have those additional protections in place. Ms Saunders, did you want to add more?
Yeah, I can add to that. I guess within the deed and guideline requirements, we do actually have a requirement that with any accommodation that is used, that is an approved employer accommodation, and so thinking that we're talking on a broader level and not just the specific, it's broader, that any PALM approved accommodation has an appropriate compliance with local government requirements. There is an obligation that is placed specifically on the employer to ensure that whatever accommodation they provide complies with all local government requirements. We don't specifically...
Look, I get that, and I'm not arguing with what the employer-provided requirements are. I'm not arguing with that at all, because I think that actually, in my conversations with people who operate within the scheme, see that as providing an assurance. The issue comes when an employee, a worker, through whatever channel they're contacted or engaged in respect of accommodation, and this is the way that the councils have put it. Second action is to acknowledge and negate the use of individual tenancy agreements to usurp Australian government responsibilities. So that's acknowledging that the system, if an employer provides the accommodation, covers what needs to be covered. What I'm trying to get away from is these dodgy providers who are using the individual's right to choose their accommodation to exploit them effectively, and that's what's happening, to provide not fit for purpose accommodation. And so how do we build that element into the scheme, respecting people's right to make a choice? I get that, and I think that's an important thing. Their agency is an important element in the overall scheme of things. But there are clearly people out there willing to do it again, said they'll do it again, and we don't want them in the market.
No.
They're in the housing market generally, Senator. We within the scope of our authority, we have agency over contact with the workers and contact with the improved employers. And the strengthening of our deed and guideline is such that we put these duties on employers to ensure that those responsibilities are forefront in the mind of the worker, and also added responsibilities to the employer who push back on us sometimes on these settings. So we've added additional duties responsibilities that ensure that a worker doesn't experience any negative damage or harm for executing that responsibility. So you can see there that what we're trying to do.
And I get this, and there's responsibilities from a different level of government here. So, you know, local government has a level of responsibility, which is largely where this stuff lies, but they're looking for comfort, if you like, and assurance that recognition of that sits within the guidelines and the way the system operates.
I can absolutely empathise with where they're at, and we're seeking to obtain those views through the review that we're conducting now. We're not in a position to be able to give any kinds of assurances at this stage. We're commencing that review. We don't know where precisely that will take us. We've outlined, I think, the areas where we can execute some regulatory oversight. Predominantly sits with the employer and the worker, but we'll work that through as we conduct the review, I think.
I guess I might add that it would be, I think it would be a good idea for us to actually go and have a conversation with some of the local councils and get some further, deeper understanding about exactly where the gaps are that are giving rise to this additional sharp practice that is leading to exploitation, and using that information to either strengthen the settings that we have and or strengthen the information and the guidance that we provide to workers and approved employers in terms of how they have more visibility, but also have a look at what other mechanisms and or approaches we can adopt that try to kind of take the legs out of the sharp practice that is occurring.
Just about finishing. This is the conversation we had last time. Yep. We'll go back and have a look and see what we can do. Here we are again. So certainly you're aware of the motion from the Local Government Association that came from the Trade Council, which is where this has happened now twice. They don't want it to happen again. They don't want to have the grief of having to take the action that they wanted to do again. I'm not for generating regulation. I don't need to. That's not my shtick at all. But this is a really important scheme providing important capacity and labour skills to our agricultural and regional workforces. We don't want it to fall over because of dodgy operators. So, I mean, if I can, if reference to the Local Government Association motion, which encapsulates what we've just been talking about, can be clearly referenced or incorporated, I think that would be a start, because that's their view as passed at their National Congress. Thanks, Chair.
Thanks. Senator Canavan.
Thank you, Chair. I've just got some questions on the PALM scheme. My understanding is that there's been a correction in some of the statistics for the PALM scheme. Is that correct?
Yes, Senator. So last time we were here, we talked about the fact that in insourcing the PALM scheme from a private provider to government, we inherited data, and in interrogating that data, it came to our attention that there were some flaws in the data. So last time we spoke, in June when we were before estimates, we noted that we had some constraints on what data we could reference, and that we had a process underway to cleanse the data and ensure we could accurately report. That process has now been done, and I'm very pleased that we have now got accurate information up on our website for the first time. Accurate PALM data is publicly available, and the officers at the table can give you more information about when that became available and what that data is.
Okay, well, maybe just quickly, because I wasn't here last time, was the incorrect data published, or did you hold it back because you knew there were mistakes?
I think I can help with some of that, Senator. Prior to July this year, we did not routinely publish PALM scheme data.
Right.
It was infrequently available in some fact sheets, so I couldn't say it was never actually published, but there were fact sheets that contained numbers and the like. So.
Right, so there were some potentially incorrect data published.
There would have been in the form of fact sheets or routine updates and the like. In July, we published the first outcomes of the data quality review, and then we published subsequently in September a series of time important data to attempt to provide something in the nature of a baseline for data historically, going back to when the scheme commenced in April 2022, when the Seasonal Worker Program Pacific Labour Scheme commenced.
Okay.
Sorry, Senator, can I just add, part of the assurance process we went through was as insourcing the operations of the scheme in December of last year, it became clear once we actually could get all of that data, get all of the IT systems in-house to do an assurance process, that it became clear that that data just needed that quality assurance and to be verified and accurately reflected.
So you always knew there were problems with the data?
So we didn't know that there were problems in the data, Senator. It wasn't because it was run by PLF and an outsourced company. So until we actually looked at all the data in-house and did the quality assurance piece, we wouldn't have known there was an issue.
Okay. But from July, you're confident the data's been accurate?
Yes.
Okay. Now, my understanding is that that data now shows a significant fall in the number of PALM workers engaged in agriculture. So I've got it falling from July last year around 5,000 or so, 22% fall, I think. Is that roughly correct?
So, Senator, I'll get Ms Rowe to kind of go through particular sectors, but obviously some of it will have been workers that were double counted between the short-term and the long-term worker scheme, which was one of the things that was identified in the data. But I'll get Ms Rowe to answer your specific questions.
Can I give you a really simple, as I understand it, the situation, before it was insourced, the data that was being provided was always wrong and always overstated the number of PALM workers who were in Australia. So it wasn't so much that the number went down from a higher number back then to a lower number now. It was always overstated. But now we have correct data, and my notes here tell me, for example, in September 2024, there was an increase of 4% in agriculture worker PALM workers, but the department officials will be able to give you more precise data than what I've got.
Okay. So I'm just interested to change. So what was the figure in July 23 and what's the figure today? Because I believe that relevance of July 23, that was the month before the guidelines and deed were established. So what we'll do, Senator, just because there's a bit of a risk of talking about old data and new data, what we'll do is we'll give you information that's contemporary, that's been validated by a Chief Data Officer, and I'm confident that Ms Rowan particularly can take you through that agriculture sector data.
Okay, so have you got a figure for July?
I'm not sure, Senator Canavan, I'm not sure that we actually have what was the correct number in July 23. I'm happy to be correct if I'm wrong about that.
Felicity Rowe, Acting Assistant Secretary, Palm Performance Branch. I'll just talk you through the process we went through with the data quality review, just so you understand where we've got the data points at the moment. So when we realised that the data was wrong, we paused the release of data, and as Mr Stott said, there was ad hoc release of data, and it was only a total data that was released, total worker numbers that were ever released, not disaggregated data previously. In July of this year, we released January to June 2024 data. It's the first time that we've had PALM data available publicly. And then, as Mr Stott said, in September we released the remainder of the program data from June of 2023 to December of 2023. And also we picked some data points in the past so that we could look at the trend from when the PALM, from when the new PALM visa started, which was April 2022. And so we have April 2022 data, December 2022, and then we have the full program from when the new deed and guidelines started from June 2023. That's all published and publicly available, as is a description of what we found in the data quality review, where we talk very transparently about the findings and what the differences were in the data. To your particular question, Senator, you asked what the agriculture data was in July of 2023.
Yep.
There was 21,915 workers in July of 2023 in PALM. And what was the next point you wanted, sorry?
What it is now,
what
I suppose.
What it is now. So at the end of September 2024, there were 16,705 workers.
So there has been that sort of 20 to 25% reduction in numbers over that period.
What I would add to that too, though, what we have seen, which is an interesting overlay, I think, to the data, is we've seen a difference in the composition of the employers that engage in the scheme. So we've actually seen an increase in the total number of employers who engage in PALM. But we've also, in particular, seen an increase in the number of employers that actually are engaging in agriculture, despite the numbers, total numbers going down. What that indicates to us is that while there's more employers engaging in agriculture, probably with less workers, and likely doing better workforce planning to ensure that they don't have underutilised capacity in their workforce. So we've seen quite active engagement from employers in the PALM scheme, and I can give you some figures there if you'd like that too, Senator.
Just that I've got a quote here from the Minister in February at estimates, which says, and I quote, "There has been no collapse in PALM worker numbers. It would appear for the moment at least that we're not seeing the exodus from the PALM scheme that some of these groups thought." But you're saying in agriculture, in fact, there has been a significant reduction. Has the Minister correct the record, given that? Was that based on this incorrect data at the time? Senator, the program overall grew from April 22 to September by about 18 or 19%. The number of approved employers is increased by 93 since we introduced the new deed and guidelines on 24 June last year. There's currently 31,000. I can't see that in the data you've got. Can you give me the actual numbers that back what you've just said up?
There's currently 485 approved employers within the scheme, and there are currently 31,230.
Okay, but no, this quote's about worker numbers.
Yes, so the worker numbers right now is 31,230.
That's right, but I'm just saying back in February at estimates, the Minister said there has been no collapse in PALM worker numbers. And then went on to say it would appear, at least for the moment, that we're not seeing the exodus from the PALM scheme that some of those groups thought. But, as I say, in terms of agriculture, at least we are seeing what you could say is an exodus in worker numbers.
Well, we're seeing a shift. We saw a 141% increase in long-term workers. The majority of the reductions we're discussing occur in the short-term scheme, I think.
So it's important that we have
Again, can you just give me the figures there?
Yeah,
141% increase, did you say? I've got in July, and keep in mind the time frame, I've got July long term across the whole country, not just agriculture, I've got 15,000 and it's now 16,000. Did you say 141% increase?
In long term. We'll get Ms Rowe to take you through the data.
Maybe we could just reflect on the evidence too to make sure it's all correct. It just seems to be talking in generalities without the actual data.
So if we talk...
Obviously some question marks on its accuracy. Yep.
If we talk in the longer term from April 2022 to September 2024, we've seen 19% growth, as Mr Stott said, in the scheme.
When did the scheme start?
The PALM visa started in April 2022.
Okay. Of course, you're going to see it's going to wrap up, presumably.
Yeah.
And you're coming off obviously a very low base. I mean, we could do it from March. It would be an infinite increase because it'd be zero in March, presumably, right? So that doesn't seem a very useful comparison.
That was comparing it to the previous programs that did exist prior to the PALM visa, and that was the previous SWP visa. I don't know the exact title, and then the other long-term visa. I don't know.
So it's not a zero-sum start, Senator. No. It's the combined seasonal worker program, Pacific Labour Facility, Pacific Labour Scheme.
But there clearly seems to have been a ramp up in the long-term numbers here.
That's right.
Right.
Yep.
Yeah. So I don't know if that start date's all that relevant, but certainly it's not what I'm asking about. So I'm just asking again: has the Minister corrected the record to the Senate that now that the data shows there has been a collapse, that has the Minister corrected the record, the evidence to Parliament?
I don't think that I think it might be important that Ms Rowe takes us through the data.
Well, can I
maybe
suggest...
could I just... I thought we'd already established through the data there has been a collapse. The Minister said there was no collapse. I'm just asking, has the record been corrected? That's what I'm asking.
Senator, I think it's clear...
just to be nice to have the answers relevant to the question I'm asking.
I think it's clear from the data that we have had increases in the workers coming into PALM. There may have been a change between the types of sectors and employers that they're working in with. The approved employers continues to increase. And so overall the scheme continues to increase in terms of the number of PALM workers coming into the country and working in the scheme. And we can give you the trend data on notice, but certainly at this point in time, there's over 31,000 PALM workers in the scheme.
But that's down from July 23 by 3,000, still a 10% reduction. I don't quite understand. You just told us that the scheme's still growing.
It's one of the things one of the things that's really important when we look at the PALM data is we see there are seasonal factors that influence the data. There's a lot of factors that do influence the data, and so it's not a linear growth model that you would ever expect to see in the PALM data. So
there's the workers there. I've got a graph, and I'm happy to table it. That's the this is agriculture. That's the workers, and you guys keep telling me, I don't want to make this a major issue, I'm not that worked up about it, but I start to get worked up and I feel like I'm trying to be misled. I mean, the trend line is clearly down in the number of workers over now a 15-month-odd period. That's the data from your website. But you're sitting here telling us that the scheme continues to grow. You've just said that in terms of worker numbers. How at all is that correct?
What we're saying, Senator, is that it's continued to grow in the longer term. When we look at the period that you're talking about between July 23 and September 23, if you look at July...
September 24, sorry.
Oh, September 24, sorry. July, we had some drop in August, went up again in September, it dropped again through to December, went up again in January and February, went down again in March and April, went up again in May, went up again in June, went down in July and August, and is up again in September. So that's the
There is no way you can conclude that it's growing here. When the trend line is down, I realise trend lines can have starting and end point errors, but how can you at all, with a straight face, tell us that these numbers show growth over that time period?
What we're saying, Senator, is in the
longer... The peak is in August 23, so just a month after I'm starting this series. Sorry, September 23. And it hasn't got higher than that since. And it's obviously got a seasonal element here. Yeah, but there is no way you can establish that the numbers are growing over that time frame.
So, Senator, if we take April 2022, when the new visa scheme was introduced...
Hang on. Can I just... Sorry, Chair, and I don't want to really make a point of it. I'm asking, and I've been very clear from the start, I'm asking from July 23. Is there relevance around why I'm asking for that because of the deed and guideline change? And so when I try and ask a simple question about that, I keep getting told to compare it to a previous date. I didn't think this was going to be all that hard to establish the facts, because the facts are just from your website, and they do not show growth in worker numbers from July 23. Is that wrong or right? Do your numbers, worker numbers, on your website show growth in palm workers since July 23?
The numbers show that they've gone up and down since July 2023. That's right. So if you measure between now and then,
right.
I mean, there's been months where it has been higher than July 2023 during that period too, Senator.
Right.
I think the other numbers on our website that are really important to include when we're considering the health of the PALM scheme is the engagement of employers in the PALM scheme, and we are seeing growth in those employers engaging in agriculture.
I wasn't asking about that. I wasn't asking about that. I mean, if there is a season limit, July this year was 31,950. July last year, July 23, was 34,110. So there's been almost a 10% reduction from month to month, from year to year, using July that you've just used. I'm still... Can I get a clear answer? Has there been growth in worker numbers under the PALM scheme? Yes or no?
If you're comparing July 2023 to September 2023, you would say that there's been. I mean, I wouldn't be comparing one month to another, Senator.
Look, I think your failure to answer the question speaks for itself. I mean, look, maybe you could quibble and say, you can't quite establish that there's been a reduction. Maybe. But there's no way you can say there's been growth from those numbers. And I didn't think I'd be getting worked up about this, but it gets a little bit annoying when I think there's an attempt to at the very least, be shifty about this, if not overtly mislead the Senate, because, as I say, I've already got a quote here that's clearly misleading. Now, maybe it was based on incorrect data, but that hasn't been corrected, or you can't tell me it's been corrected. And now you're trying to tell us a different story from what is shown in your actual data. So just moving on then to why this has happened. I mean, there have been, my understanding, a lot of complaints from industry about some of the restrictions on and uncertainty about the conditions on which they employ people under the scheme.
Just how much longer, because we've gone well over 15
Well, I
minutes.
didn't think it would take this long,
No,
honestly.
I thought if we got clear
answers...
I'm not harassing you, I'm just,
yes,
I'm just getting an indication.
Look, I'm probably only halfway through. I thought I'd be done in 5-10 minutes. If I got simple answers to questions, I think I would have been. But I'm in your hands. I'm happy to come back.
You just want to go for a couple of minutes, and then I'll go to Senator Allman-Payne.
Yeah, well, happy for you to cut me off whenever you like. Obviously,
I don't want to cut you off.
I want to get the answers.
But we can always come back to you, depending on which colleagues.
Yeah, that's right. I'm happy to do that. That's fine, Chair, in your hands. So, there's been some complaints, on my understanding, about some restrictions and uncertainty, especially around the applicability of the 30 hours minimum requirement. What consultation have you done with industry about these issues? And do you think they're at any way behind what is clearly a decline in agriculture numbers?
Just before you answer this, if you want to do a follow-up, then I'll go to Senator Allman-Payne, and then I'll just ask where we're at.
Well, you can go to Senator Allman-Payne now, because I was kind of moving on from the data
right, fine.
to the actual
I'm happy to
underlying
do that.
factors.
Thank you.
So, all right.
Senator Allman-Payne.
Thank you, Chair. How long have you been giving folks on each rotation?
Well, we're attempting to 15 minutes.
Okay, might need two, but I'll see how we go.
2 minutes? That's very helpful.
2 blocks, I wish. I want to go to, there was an article appeared by Joseph Brooks on the 5th of November around, I think it's titled Job Seekers Pay the Price for Latest Tech Bungle.
What publication was that in?
InnovationOz.com.
Oh, yeah. Yep.
Senator, would you mind just circulating what you're looking at to make sure that we're all looking at the same thing?
Yes.
I think I know which issue you're going to, but I don't know that we all have a copy of the document.
Do you have the bill?
Yeah, thank you. So just while they're finding that, I might give the context to it. So it's been reported that job seekers who are subject to mutual obligations received an email telling them that one of the avenues, the electronic mailbox, had been, quote, processing applications slower than usual. And the email went on to say that if job applications aren't processed by the end of a participant's reporting period, their payment could be put on hold, reduced or cancelled. And then the email went on to say participants need to check their job applications have been processed and report using a different method. I guess my first question is, what was the reason for the slowdown in relation to that method of reporting?
So, Senator, thank you. I think I'm aware of the article that you're referring to. We'll just confirm when we see it. But that goes to a system slowness in terms of processing, and I'll ask Ms. Ryan to kind of walk through what that does, and you know, it's one avenue for job seekers.
I know that. I just really want to get to the heart of why was it going slowly.
Yep.
Senator Melissa Ryan, First Assistant Secretary, Workforce Australia for Individuals Division. In terms of the slowness, I can't give you an answer to that, I'm afraid. Our IT area is investigating it. People can still submit applications, but it became apparent to us, well, our IT colleagues identified there was some slowness that was potentially putting people's recognition of them submitting their job applications potentially, you know, not being recognised in the period they should be reporting. In respect of the message that you just read out then, we've amended that message to make it clearer for people as well about what alternative methods a person can use to report their job search, including calling their provider if they're connected to an employment services provider, or if they're in our online caseload, to call our digital services contact centre to get that support. Where we identified if participants were potentially at risk of having a payment suspension, we have gone in, reviewed those records and lifted anything there that may have inadvertently caused them to have a payment suspension. So no one has had any payment suspensions applied due to the slowness of the system.
Are you able to tell us the number of people that have been impacted by that? So, for example, the number of cases that you've had to review because they would have been suspended by using that channel?
I might just check with Dr. Wright. It's not a popular, like, it's a channel that's been in operation since 2015, Senator. It's not something that is widely used by job seekers, but nonetheless, yeah, people do use as a channel, but I'm not sure if we know how many we've that are directly impacted today. I'll check with Dr. Wright.
Senator Andrew Wright, Acting Assistant Secretary, Access and Participation Branch. Because we get emails to the box rather than a job seeker with this is 20 job searches necessarily, it's difficult to break down the number of precise individuals that we've looked at. The team sort of go through and they identify job seeker reference numbers and then use that to make sure that there's no contingency, no payment suspension for that process.
Able to say then how many emails?
Senator, I can tell you that there have been in September, 8,876 people used the mailbox as their only method to report job search, and 12,731 used it as part of their...
Okay. But if we can get some more information, if you'd like, we can take it on notice to see if we can provide a bit more detail about your question, Senator.
Yeah. I guess my question around the original email is why that workaround transferred the onus onto the participants?
I think in retrospect, it wasn't a very clear message, Senator, so we've remedied that. So I read it the other day and I said that's not a particularly helpful message, and so we've added more information on there. But I think in our our effort to make sure people were not going to be impacted, we sent something out that in retrospect we should have probably taken a bit more time to probably carefully curate to improve the message so that the onus wasn't just on the individual, and that we've given them more information now. So that revised message is now in production and people are getting that now.
Because I guess, you know, people have lots of triggers in anything relating to mutual obligations. And yeah, I guess it's concerning when the onus is being put on the vulnerable person rather than the department.
No, we first became aware of it yesterday, and we've updated that message, so there's a new message going out to make sure.
Can we get a copy? I'm happy to get on notice of what that new message is, so that we can see what's going to people. Yep. Okay. I want to move on then to...
Just I'd like to set that break in one sec.
Yep.
We can also just release Comcare as well, so it won't be required.
Thank you, Chair. Just for people to be able to go.
Thank you. Thank you, Senator Allman-Payne.
Thank you, Chair. I want to move on to pay slips. Now, I know, Minister, when you first came into this portfolio, you gave a speech and you said you were concerned about this.
Yep.
And at last estimates, it was claimed that the department wasn't aware of any cases where providers were inappropriately soliciting pay slips. I can tell you that my office is still receiving complaints from people, participants who continue to be harassed by providers. And I note that documents under FOI also indicate that this is a persistent and ongoing problem. I guess I have a range of questions about this. My first one is the department aware that providers are still currently engaging in improper pay slip harassment?
Just before, sorry, Ms Rishnell, can I just say something at the outset? You're right, Senator Allman-Payne. I and my predecessor were extremely concerned about providers doing this. And as you mentioned, I think possibly the first speech I gave in this new role was to providers, and I said we would be taking action. To make very clear, participants are under no obligation to provide payslip information, and they must not be threatened or penalised in any way should they decline to supply them. Since we last discussed this, the department has begun investigating providers who've threatened to suspend or cut payments or to withhold funding out of the employment fund if participants do not comply with the demand to produce payslips by the provider. And if you're interested, I'll leave it to the department to fill you in more about that and answer your previous question.
All right, so what I might do is just step through some more granular questions, because I think you've answered my first one, Minister, which is there an investigation into this that's ongoing? Is it possible to get a report of the findings to date, or is that still in progress?
So, Senator, we're currently investigating 4 providers who've been identified through the complaints line and various mechanisms in terms of inappropriately asking for pay slips. As soon as that investigation is concluded, we expect it to be finished in November. We will provide what we can on notice in terms of anything we can do in terms of the investigation. Obviously, some of the details we may need to look at in terms of procedural fairness, but certainly outcomes of the investigations and any actions taken.
Okay.
And could I just say, Senator Allman-Payne, obviously, if your office or any other senator's office is being made aware of these issues, we'd welcome you providing that so that it can be investigated.
Yep. Has the department considered suspending the target compliance framework and payment suspensions since multiple providers are repeatedly misusing them to solicit payments?
So, Senator, in terms of broader suspension of the targeted compliance framework, obviously that's a decision for government, but one of the things that we have done now in terms of pay slips is we have a specific line in terms of the customer service line that any complaint about pay slips automatically gets referred to our complaints team to be looked at, to be investigated, to make sure that those complaints are taken seriously. We've updated guidelines for providers that makes it absolutely clear that there are consequences under the guidelines if they continue to take any of these kind of behaviours. They need to action them straight away. And in terms of any providers that have been inappropriately applying demerits or penalties
because of pay slips, we have manually gone through and looked at and removed any of those demerits. So my colleagues can tell you in more detail where we've done that, but we've absolutely made sure that any use of harassment for pay slips and the use of the targeted compliance framework and demerits is rectified and addressed.
I'm mindful of the fact that the general person out there who's on is subject to mutual obligations and is probably, which means they're on poverty payments, isn't paying attention to speeches of you or me, Minister. So I guess I'm wondering whether there's been any proactive communication with everybody engaged in the mutual obligation framework that sets out for them very clearly and proactively that they are not required to do that, and this is who you contact immediately if you are asked, because I'm very conscious of the fact that this is a very unequal power relationship, and when somebody is worried that their payment is going to stop, it puts them in a very vulnerable position, and unless there's been some proactive communication with that cohort of people, I'm not sure that they would be following what we're talking about and what the Minister's talking about. So has that happened?
So I'll go to my colleagues. Certainly we'll check about the proactive communication and the kind of messages going out to people who are subject to mutual obligations. A lot of our messaging has been very clear to providers about what they are not able to do, what they should not be doing, and what action will be taken if they continue to do that. We'll check on the proactive communication to users of the system, but certainly we've recently had some much more positive feedback in terms of people feeling like they've been heard through the complaints line, and we have tried to step up certainly our ability to use the complaints line and refer to our complaints mechanism so that people can feel heard and that their issues are taken seriously. I don't know whether my colleagues can add anything.
And Senator, just to add to that, whenever we do receive a complaint which mentions payslips, the team review the participant's record to identify if any inappropriate compliance related to payslips has been removed. If there have been any previous demerits related to that, they'll be removed. Similarly, the team do daily assurance on compliance action, and if any payslip related action is identified, we remove that as well and refer the record to our assurance team to identify if there's
is it the case that you can name the providers that have been engaging in this conduct?
So, Senator, I can't name the providers under investigation at this point in time because of procedural fairness requirements, but certainly if the investigations bear out that this has been used by those providers, then we should be able to provide those details.
Are the four providers that are being investigated the only providers about which you have received complaints in your complaints line about payslips?
I'd need to take that on notice, I think, Senator, in terms of complaints, certainly since we've reinforced the messaging, but can I take that on notice?
Yes, thank you. Noting that you've got an ongoing investigation, when that's concluded, will you publish data on the number of payslip infractions per provider?
I'll need to take that on notice, Senator.
To the department's knowledge, have any of the providers who've been put under a program assurance activity for payslip misconduct continued to engage in this conduct?
So I might turn to Mr Campbell in terms of... Mr Beasley. Oh, sorry.
Twice.
I know, I keep referring to Alistair Campbell. Please, apologies. And I should correct the record, Hansard.
He'll get back to
Please
swearing.
correct the record, Hansard. Mr Beasley. In terms of the particular actions and notices, but certainly at the time at which the assurance process has been done, one of the actions taken is a notice to produce and actions for those providers to show that they have informed their staff and basically stop that behaviour. But I might turn to Mr Beasley to explain.
Thanks, Ms Vishnu. So, yeah, look, as Ms Vishnu said, at the time that we issued notices to these providers, we gave them formal directions around needing to cease that conduct and give us a range of assurance and take a range of actions around that. So to my knowledge, since that time, we have had a provider where we've issued a formal notice to cease that conduct where we've had another instance of it occurring. We've got onto that very quickly. We've contacted that provider within 24 hours to investigate that particular complaint. That's quite a recent occurrence last week. To my knowledge, that's the only instance. I'll correct that on notice if I need to, but to my knowledge, that's the only instance we've got of that occurring.
So you're saying that there's one provider that you know of that's performed against the direction in a manner that you would consider to be less than satisfactory?
So again, I probably just need to be a bit careful and say we've had an allegation there against that provider after we've issued that direction, but we do need to investigate that to make sure that we can substantiate that allegation. And again, we got onto that really quickly within 24 hours, and that's what we're doing there.
Okay. Now, you've talked about the fact that you've put information out, you've reinforced things with providers you're investigating for, you've had to issue a notice. I guess from a broader question, is the department then considering making changes to single touch payroll or the outcome payments model in light of the fact that this continues to go on?
So in terms of changes to single touch payroll, obviously that's not an issue within the control of the department. It's obviously a matter for the Treasury. One of the things that we are looking at is how to make it easier for people to show what they're doing and how they're doing it, both for users and to make sure that we're keeping an eye on provider behaviour as well. So we are looking at how do we better verify things like outcome payments, but also make sure that users can easily and simply interact with the employment services system.
Okay. Has the department sought legal advice over any provider's payslip misconduct?
I'd need to take that on notice, I think, Senator, in terms of we're currently doing an investigation. Mr Beasley might have more information, but... So
Senator, certainly in the course of our investigations, we work with our internal legal advisors and external legal advisors. Yeah.
Okay. Can we have the full list of providers who've been put under a program assurance activity for threatening the use of the targeted compliance framework to obtain payslips?
So again, I think because of the procedural fairness point that Ms Vishnu was mentioning, I think we'd probably just at least want to take that on notice to think about what's appropriate at this point. But
notice this is people who've just been simply put under a program assurance activity, so we're asking for how many have had that.
So let us take that on notice, Senator, because often providers can be put on a program of assurance kind of, let me start again, on a program improvement plan for a range of different things, but we'll take that on notice and be clear about where it may have been as a result of payslips or inappropriate use of
I suspect my next couple of questions are probably going to be on notice ones, but I'll persist and see how I go. Can you release all the complaints that the department has received and logged on its IT system from participants about payslips since the start of Workforce Australia?
So, Senator, we'll have to take on notice since the start of Workforce Australia, but certainly between the 12th of June and the 30th of September of this year, we received 79 complaints through the phone line about requests for pay slips or employment evidence.
Okay, thank you. What is the dollar figure known to the department of monies wrongly claimed by providers due to harassment of participants for their pay slips?
So just before you answer this, Senator, on the planet, have you...
Two questions.
Two questions,
in this, and then I'll stop.
Yep, wonderful.
And then I'll wait for you to come back to me.
Senator...
that's pushing it.
I just
All right.
start by saying, so harassment and threatening to use the compliance framework to secure pay slips is unacceptable. Yeah. It doesn't mean the claims that were made were wrongfully made. So, I mean, the providers get outcome payments if they've placed people in an appropriate job. But if you're asking about the claims or the payments to which these claims might relate to, I'm not sure that that's something. I think that would require a calculation. But I'll ask Mr. Beasley whether or not he's got any reflections on whether we can help you get a sense. I think I understand what you're trying to quantify.
Yeah, I think.
But it would be wrong to say they're wrongful claims. It's not necessarily the claims that are wrongful. The conduct is most certainly wrongful.
Yes, and we're certainly hearing from some participants that they're securing work that their job service provider didn't necessarily help them secure, right? And they want payment, and therefore they're pushing them for pay slips when they're in work so that they can then claim the funds.
And Senator, we certainly do. We distinguish, and a participant would definitely distinguish between when they feel like they've been helped to get the job and when they haven't. Our outcomes payment system doesn't. Our outcomes payment system makes that payment to the providers irrespective of the contributing factors to the job being secured. It's always operated that way. You and I might have opinions about, whether that means they've worked, well, they wouldn't have worked the same for every placement fee, if you like. I guess what we would say is that a participant gets a range of assistance from a provider at any given time. Some would get a lot of help, some less help, but nevertheless it's just important to point out that the outcome payment flows irrespective of the degree of assistance provided.
Okay. So my last question then I guess kind of makes sense in that context then. Does the department ever interview participants as a quality assurance measure to ask if their provider actually got them the job or helped them to maintain it? And if so, can we have that data?
We do have quite an extensive body of work around surveys and even focus groups of our participants. I'm not sure if it goes specifically to that question, but Mr. Beasley might be able to assist.
Yeah, I mean, as the Secretary says, we've got a range of ways that we communicate and talk directly with participants. I think probably we can take that on notice and we'll come back.
Be very helpful. Yeah. I will stop there for now, Chair.
Good, thank you. Senator Canavan.
Thank you, Chair. Now, I believe we've had a document tabled, if that can be provided. So, look, I'd love to rush through these quickly if we can. I don't want to labour the points. As we were discussing, there's clearly a decline in farm workers engaged, but I'll leave that to one side. I just want to establish there's absolutely been a decline in farm workers engaged in agriculture since July 2023. Is that right? Can we agree on that? These are your own figures.
I'm sorry, Senator, I missed the question. I was just sitting down.
Okay, so can we agree there's been a decline in the number of farm workers engaged in agriculture since July 2023?
Yes, Senator, there's no mystery.
No, thank you. Great. Now, have you asked farmers why they're not using the PALM scheme as much as they were a year or so ago?
No, Senator, we haven't had that opportunity. We are in deep contact with our stakeholders routinely, but I couldn't say to you we went to the farm gate and checked. It is, though, at the same time that's occurred, and in more recent times, we're seeing significant increase in the number of agriculture sector direct employees joining the scheme. It's gone up by about 12%. So what we're seeing is a move away from the use of labour hire in the agriculture sector and a move to direct employers directly employing palm workers in the agriculture sector. And at the same time, we're seeing the percentage of workers under those direct employers increasing at the same time. The data would tell me that there are more farmers, if that's a proxy for agriculture, hiring workers directly than there's been in the scheme prior.
Right. My understanding is you've reviewed your engagement consultation arrangements recently. Have you abolished a number of advisory groups and committees?
We've taken on board feedback from stakeholders, including the agriculture sector, who told us that they were attending several committees to discuss the same things at the same time. We haven't abolished those committees at this point, but we've been talking to our stakeholders about the feedback they provided, and we've explored with them what we could start doing and what we could stop doing and what we could start doing to better hear their voices in the program.
You have collapsed 7 into 1 is my understanding. So there is no longer a separate agricultural consultative group.
We're in the process of going through that right now, Senator.
Is there any reason you said earlier you hadn't consulted farmers? I mean, if you had an agricultural consultative group established,
I think what I was trying to explain, Senator, was we haven't been to the farm gate and spoken directly to all farmers.
Okay, my question more generally, I mean, if you've spoken to farm representatives.
Absolutely, it's routine. Consultation is deeply embedded in the scheme. Yeah.
So what have they said about the reason for the reduction when you've spoken to those representative groups?
Look, I might invite Ms Lange to give us some feedback on that.
Okay.
Assistant Secretary, Stacey Lang, Assistant Secretary, Palm Operations Policy Branch. So as Mr Stott has stated, we're very much through, we're through a consultative process with key stakeholders, and Farmers Federation is one of them. At this point in time, we're engaging with them on the proposed model. It has collapsed a number of working groups, including sector committees, agriculture, meat processing and care sector committees, but we are incorporating a lot of those. So what we're doing is a bit of a refresh.
Can I just, because I know the committee's way behind time, so I don't mean to be rude or anything. I just want to know what have those farm groups told you about the decline in numbers?
I think I can help.
That's all I want to know.
I think Ms Lange was telling us about the governance and consultation.
I understand that, but I'm mindful of the committee's time because I've come in late. And
you're going on to what they've told us about those settings as we proceed.
Yeah, I mean, I'm very interested, obviously, in trying to make the system work. So have you had any feedback from those farm representative groups?
Yeah, we're in the midst of reviewing our settings now.
Well, what has that feedback been? That was my question.
Sorry, Senator, I actually haven't got the exact feedback that's been provided. What I can say, we actually have been engaging with industry groups, peak bodies, National Farmers Federation, as part of a review of the deed and guidelines settings. That's only started last month, so we've been starting to receive submissions now, and they're coming through.
It's helpful for you to know too, Senator, that when the change to the minimum hours setting in the short-term scheme came on, it was a proposal from industry that was eventually agreed by government that's in place now, and that setting is to be reviewed as part of the ongoing review that we've commenced. And we've brought on a provider to assist us with that engagement, and that right up front in the early days will be the first phase. That review will cover that key setting. The review, of course, overall will not be exclusive to that. There are many things that our stakeholders talk to us about. That is certainly key and central to that review.
And stakeholders, to your point, Senator, stakeholders have said that is a high priority for them, which is why that's the biggest priority. The first priority we're actually looking at in the review is to look at that setting.
Well, that's the feedback we've received too. My understanding is there was, as you mentioned, I think an acceptance that there'd be some flexibility about the minimum 30 hours a week, and those arrangements are in place till July next year.
That's correct. If you use the word flexibility, I think the way I'd understand that before we say yes, absolutely, is that government made a decision to extend that setting through to July.
There's an averaging; they can average it over.
The way I describe it is that there's a reconciliation period of 4 weeks, and it's to provide 120 hours or offer 120 hours over that 4-week reconciliation.
So the key question, I suppose, is I believe some farm groups want to make this permanent, and they're sort of desperately waiting just to hear about from the government, really, I suppose, ultimately. And so, what is the time frame upon responding to these requests to make that current arrangement long term?
So the review of the deed and guideline settings has been conducted in 2 phases. Phase 1, which is looking at that minimum hours setting, is reporting to government by the end of this calendar year. And phase 2 report, which is on broader settings, will report to government by mid next year.
So you'll report to government on the 30-hour issue by the end of this year?
That's right, Senator.
There's just might ask the Minister, is there a plan to make the decision by the end of the year as well in response to that feedback?
We haven't decided that yet. We'll obviously look at what the feedback is.
Okay. All right. And I suppose just finally then, the objectives of this program are to address workforce shortages. Are you confident they're being met at the moment, given this reduction in workers in agriculture?
Not to go to a matter of opinion, if we look at the data available to us, in particular with the movement towards increasing numbers of employers and increasing numbers of employers, including agriculture, directly employing their workers, I have confidence that the program's delivering the demand-driven outcome that it's designed to do. And in particular, I'd point to the reduction or the return of people on 408 visas in the scheme. There was about 4,500 of those mid-year. There's about 332 as at September. As those workers have gone off, there's continued to be demand from employers for 403 visa holders, PALM workers. That would say the information available to the department indicates a strong future for the program. So.
Okay. All right. Thank you. Thank you, Chair.
Yeah, thanks. Thanks very much. We can go back. Oh, right. Senator Allman-Payne.
Thank you. I'm
we
going to
could
try
keep
hard
it.
to go fast.
Thank you.
I'm doing my best.
You're very helpful.
I just want to say thank you for providing question on notice from the last estimates. It was SQ 24-001644 and it was related to a list of job referral tasks set in Workforce Australia provider services. My first question is, and obviously on notice, could we get an updated list of that particular quant? But in relation to the data that you did give us in the last request, just noticing that some providers were missing key information in their job referrals over 80% of the time. And if I go to the list, so for example, top of the list is APM employment services. Out of a total job referrals of 6,275, 5,215 were missing key information, and that included things like 3,010 of them not including a job description, 3,900 not including the employer contact name, 3,965 no employer contact number, and so on it goes. I do note too that someone has just tweeted that they're feeling frustrated that so much procedural fairness is being given to job service providers and the people who are participants don't feel like it's coming back their way. And I guess this is another example, right, of referrals being made with over 80% not having critical information, and it's the participants who are then having to chase and run and try and get the information they need. So I'm really keen to know what steps the department is taking to improve those rates of referrals not containing critical information.
Senator, so before we were talking about the assurance process we do on compliance action, every time there is a job referral task and there's compliance action associated with that, the team review that and remove that if there's any missing information. As I think we outlined in our question on notice response, sometimes an incomplete referral might still be enough action for a job seeker to apply for a particular job, but nonetheless our guidelines say that information must be contained. So we remove that, we go to the provider, we explain why we've removed the compliance action, we say, sort of educate them on, this is what needs to be, and have a continuing sort of back and forward as part of that process.
Maybe this is a question for the Minister. Minister, can you understand, I guess, why participants feel so frustrated that they're watching people not being able to be named? For example, if they're asking for pay slips when they shouldn't, they're under investigation, they get protected. They're seeing 80% of an error rate, they're still being protected. Can you understand why participants are feeling very frustrated and very demoralised, and in many cases extremely vulnerable, because they just see repeated exceptions being made for providers, and yet they're, one wrong thing and they get their payment taken off like that?
I can certainly understand, and I think I've said before that I understand why participants are frustrated with the current compliance framework and mutual obligations framework, and of course that's why our government has begun what will be a very extensive reform to that framework and employment services generally. I understand that people would like that to have happened already, but we're talking about a very big reform, so it does take a bit of time. I guess I disagree a little bit with what you said around providers being protected. while we might not be disclosing the names of providers who are under investigation, there are providers under investigation and there may be very serious consequences for them. So we're doing what we can without, breaching privacy, but work is occurring.
I guess in relation to this, 80% of the time a referral doesn't contain the information that it should, and they look like pretty straightforward things to me. Will this factor into any of the funding and contract decisions made by the department going forward?
So, Senator, without kind of getting into the specifics of which things will or won't be, anything that is directly related to how a provider is performing and more broadly how they're achieving outcomes can be taken into account, particularly in the context of the annual licence review that's currently underway.
Okay. I've got some questions that I might circle back to, but I'll keep going for now. Next question is just general provider questions. Are you able to, and I understand if some of this needs to be on notice, because I'm also conscious of time, wanting to know, how many Workforce Australia provider contract breaches have been investigated by the department?
I think we might need to take that on notice, Senator, to be entirely accurate.
Okay, and in relation to that, we'd like to know what were the reasons that triggered the investigation, and we'd also like to know what remedial action has been taken over provider contract breaches. Also interested to know, has the department investigated any providers for illegal conduct under the Workforce Australia contract?
I'm not aware of any illegal in terms of anything that comes up against criminal provisions, but once again, let us take that on notice to make sure. Okay. Obviously, any criminal behaviour would then be referred to relevant authorities.
Okay. Has the department sought legal advice over any suspected contract breaches, fraud or improper conduct from providers?
As Mr Beasley outlined, we regularly get legal advice both from our internal legal team and where needed to, where we go externally to get legal advice. Once again, we'll take on notice what we can disclose, but we would routinely get legal advice on any significant matter.
Okay. What early detection mechanisms are in place to catch patterns of contract failure before complaints are raised by participants or other parties?
So we have a fairly detailed assurance process that looks at provider behaviour, and particularly any provider behaviour, any action that comes up against what they're obliged to do under their deed and guidelines and in the context of their licences. So we have an assurance process. Obviously, we are strengthening the complaints mechanism and particularly the interaction between the customer service line and a newly established complaints mechanism that actually improves kind of the review of those things. But in terms of the assurance processes, I'm sure Mr Beasley could outline all of those key things, but we are monitoring those things on a regular basis. The other thing I should add is we have state offices across the country and they would routinely also do kind of live assurance testing.
Yeah, so I mean, just to build on that a little bit, we've got a whole sort of suite of things that we do in terms of detection. So we've got platform data analytics where we'll look at, say, outliers in employment funds and stuff like that, or we can review sort of text fields and so on to pick up trends and so forth. We have a tip-off line if provider staff, for example, have concerns. The complaints line for participants that Ms Vishnu mentioned. We'll undertake targeted assurance activities, so where certain things come up as themes, we'll look into those in more detail. We have the contact centre. We also have a continuous assessment of payment integrity, which is a random sample of all payments made to check that they are in order. So they're sort of the principal ways in which we'll go about detecting various breaches or possible breaches. Yeah.
Okay. Just next lot of questions, only very short, on the National Employment Services Association. Are you able to tell us how many meetings the department's had with Nessa or its representatives since May 22nd, 2022?
I think for the detail on specific meetings with Nessa, we'd need to take that on notice. Yep. We routinely meet with all peak bodies and other stakeholders. and Nessa is obviously one of the peak bodies. So
Right.
if we take that on notice...
That would be appreciated.
Thank you.
Yep. This may be a question for the department or maybe the minister. Are there any plans to increase the payments to employment services providers?
Certainly, I think I mentioned before that a number of peak bodies for providers have raised payment levels and financial viability with us, but as yet there's no plan, no decision being taken by government to alter that, none that I'm aware of anyway.
No, thanks, Minister. Senator, obviously there's an indexation that is applied to Workforce Australia providers that's due to kick in on the 1st of July 2025. Under the deed and guidelines and under the way that services operate, that indexation happens once every 3 years.
Okay.
So that's the only reference that I would make.
Has the department undertaken a financial viability assessment for Workforce Australia?
The department has undertaken some work around financial viability. I'll get Ms. Ryan to kind of explain what we've done there, and Ms. Tran. One of the things that's clear from the financial viability, the model costing was done at the start of Workforce Australia. That was provided as part of the deed and guidelines, so everyone knew kind of what the payment model would be. One of the things that we've done in response to, just some providers saying things are fairly tight under the model is we've done a financial viability assessment and had some external help to do that. And I'll ask Ms. Tran or Ms. Ryan to talk through that.
Queen Tran, Assistant Secretary of Funds and Payments Branch. Thank you for your question. In terms of financial viability, as Deputy Secretary has just mentioned, before Workforce Australia actually commenced, the department did undertake a financial viability assessment, and as you know, that's publicly available in terms of the high-level summary. Since that time, we have also in mid-April, with the help of our peak bodies, Nessa and Jobs Australia, circulated a questionnaire to providers. We received responses back in a de-identified nature around June, July. We're analysing that at the moment. That questionnaire goes to kind of costs, frontline costs, costs that are attributed across their sites, just for the department to get a better granular handle on what the cost pressures are. What I can say from the early analysis is that, similar to KPMG's analysis, caseload size continues to be a significant driver of viability, as well as outcome payments. So those things are still what we are seeing, and we expect to finalise that assessment by the end of this calendar year. And then in terms of viability and changes to the payment model, as has already been mentioned, that will be a matter for government.
You mentioned that a survey has gone out to providers. Have there been any other communications by the department with Workforce Australia providers about their financial viability?
Yeah, prior to that survey going out, we did have a number of conversations with providers, some webinars around looking at how they're currently performing in terms of outcome payments and the like, and we did provide that against the KPMG assumptions at the time. So we provided that information to providers, and on the basis of that and the feedback we received, where the cost pressures as kind of articulated from providers, that is when we then moved to a questionnaire to get a better sense, because...
Okay. Is it possible to get a copy of the questionnaire on notice?
Absolutely.
Yeah. I'm happy to stop there if you like. I've got a couple more, but I can...
Put them on notice. Or whatever you desire on notice.
I literally had... Well, could I just ask one more question then?
I mucked that up. We could just finish then, couldn't we? By all means, go ahead and have one more question.
Yeah, all right. Just in relation to those 79 complaints that we talked about earlier into the complaints line, did any of those people have their payments suspended and then reinstated?
I would have to just take that on notice, just to confirm that we definitely, where if it did relate to a payment suspension, we have been lifting those, but for completeness, I will take that on notice to give you an accurate figure, Senator.
Thank you.
Good.
Thank you.
Thanks very much. We can now complete from outcome 3.
Done on that one?
Outcome 3 is complete.
So Fair Work Ombudsman?
Yep, so...
Great.
Yep, everyone's released, so the Fair Work Ombudsman. Do you want to suspend for a moment or we're changing over?
Oh, yeah, you bloody get to go, don't you?
Senator Cash.
Thank you, and thank you, Ms.
Sorry,
Booth.
sorry. I
Yes.
should welcome Ms. Booth and your team.
Thank you, Senator.
Thank you. I was being too
Yes.
quick, off the mark. Apologies. Is there an opening statement?
No, thank you, Senator, not
Thank
on
you.
this occasion.
Thank you very much. Senator Cash.
Thank you, Ms Booth, and I know that we are short on time, so I will try and be as efficient as possible. I have a line of questioning in relation to right of entry permits in the first instance. How many right of entry permits are currently held by members of the CFMEU?
Okay. I don't have an answer to that question.
Oh, that's fine.
May, and we'll see if she does, and if not, we'll take it on notice. Of course, it's a Fair Work Commission would keep the records, but we may know the answer as well.
And that was exactly Senator Rachel Volsky, Chief Counsel, Fair Work Ombudsman. I think Ms Booth has just answered the question as I would, and that is I think the Fair Work Commission would have those numbers.
Okay. Are you aware if the CFMEU has been granted any right of entry permits since July the 1st of this year?
I don't have that knowledge in my mind. Again, Fair Work Commission grants, and I believe their website records. Ms Volsky, do we have any insight into that?
No, again, that would be a matter for the Fair Work Commission, but what I can tell you is that we have provided information to the Fair Work Commission in respect of 5 applications.
Thank you. Thank you. That was one of my questions, 5 applications. Can I confirm the current status of the FWO's application to revoke the right of entry permit for Mr Margini?
Indeed you can. In train is my general answer, and again Ms Volsky has the details of dates of hearing, so the matter is underway. Ms Volsky?
It is. So, Senator, there have been 2 conciliation conferences before the Fair Work Commission, and the matter is currently listed for hearing before Vice President Gibeon on the 21st of November. The 21st of November. And are you able to tell me, so is that one of the 5 applications? Correct. And what are the other 4 applications? That's our application. Yes, no, but 5 were ones where we provided information. Provided information? Yes. How many revocation applications do you have on foot?
I believe that's one, Mr Margini.
Just the one, the Mr Margini's?
Correct. It's not actually a revocation, it's a suspension application under Section 507.
And why is it suspension rather than revocation? Until the criminal proceedings against him have been resolved. Okay. When was the decision made by the FWO to apply for, is it the suspension of Mr Margini's right of entry permit? Yes, so it was, on the 5th of July 2024 is when we filed the application seeking to suspend his permit pending the outcome of those allegations for those charges brought against him in late 2023. Okay, so suspension rather than suspension rather than revocation because the charges have not yet been finalised. Correct. Okay, can you outline the reasoning as to why you now believe he should not hold his right, or he should be suspended, or his right of entry permit should be suspended? So, Senator, I'm mindful of this matter being before the Fair Work Commission, but obviously, as you would be aware, particularly, he has an extensive disclosed criminal history, and with these additional serious criminal charges as well, and I think, from a regulator perspective, there are questions, I guess, about the compatibility of those charges and the criminal history with the privileges that attend to the statutory right of entry. Just remind me, when you say the compatibility of the charges, what are the charges? Senator, I'm just going to check it. He was charged with attempted, so on the 18th of December 2023, charged by Western Australian Police with attempted aggravated armed robbery, deprivation of liberty, criminal damage or destruction of property, and aggravated burglary and commit offence in dwelling. Can I just confirm, is Mr Margini still able at this point in time to exercise right of entry under his permit? Yes, Senator. But to be honest, I think that would be a question probably properly to be posed to the Fair Work Commission as the, repository and holder of all things relating to permits. But I think that is right. Thank you. Regarding the listing, was it scheduled on the 30th of July 2024 on the Fair Work Commission before Deputy President Saunders? Yes, Senator, but that was the first conciliation conference. So I think I mentioned to you that there have been 2 conciliation conferences. The first was facilitated by Deputy President Saunders
on that 30th of July, and that was unsuccessful. And then there was a second conciliation that was convened on the 17th of October, again facilitated by the same Deputy President, and it was also unsuccessful.
Okay, and was that a private conciliation?
Yes, it was, Senator.
Are private conciliations recorded?
No, they're not.
They're not.
Senator, and all conciliations by virtue of the Fair Work Act are private.
Okay, but they're not recorded.
No,
Can you make a request for the private conciliation to be recorded?
No, you can't. Okay. To my knowledge, as a former member of the Fair Work Commission.
Was it Mr. was it the Fair Work Ombudsman or Mr. Margini who requested the private conciliation for the application?
Senator, that second conference occurred at the request of the administrator.
Of the administrator?
Of the CFMEU.
Of the CFMEU.
Correct.
So it wasn't requested by the Ombudsman?
No, Senator.
Right. So it wasn't Mr. Margini who requested it. It was. So make sure we're talking about the same thing. It was the Fair Work.
So the
administrator, Mr. Mark Irving. Make it easy for us, Mr. Mark Irving. So in terms of the conciliation, was that to try and get him to voluntarily give up his right of entry?
Senator, obviously taking into account that those conferences, conciliation conferences are private, I'm mindful not to traverse, into that. But obviously the purpose of a conciliation conference is to see whether the parties are able to resolve the matter without the need for it to head to an arbitrated outcome.
In terms of the process, how long is it actually going to take, given, as you said, despite the seriousness of the charges and the incompatibility with the rights and privileges under the Fair Work Act, he is still currently able to exercise his right to enter a site. It hasn't been suspended. How long does this process take?
Senator, I think that would be obviously a question better posed to the Fair Work Commission, and I know obviously the Fair Work Commission is appearing after us this afternoon, but obviously that would be on the tribunal side, so it would be, subject to those usual processes.
Okay. And so just, Ms. Booth, going back to evidence, are the conciliations always private, or do you have to request a private conciliation?
No, by virtue of the Act.
By virtue of the Act, they are private.
But sorry, I think that question is probably better posed to either the department or indeed the Fair Work Commission, because we don't have a...
That's true.
Yep.
I'm exceeding my scope, Senator, and relying upon my past knowledge.
Can I just ask, to the best of your knowledge, did the former building watchdog, the ABCC, conduct their revocation applications by private conciliation?
Senator, we don't have that information. What I would say is consistent with other subject areas within the Act. It is very often the case that there will be conciliation, whether it's industrial action, unfair dismissal, general protections, right of entry, to see if the matters can be resolved without having to head to formal arbitration or to a court.
Just in terms of Mr. Margini, according to the Fair Work Register, he received his right of entry permit on the 13th of July 2023. My understanding is that the Fair Work Ombudsman was invited to provide information at that time?
Correct.
And did you?
No, Senator, and I think we've spoken more broadly about this issue at previous hearings. Obviously, it's the Fair Work Commission who's tasked with dealing with permit application matters, and we endeavour to provide information and assistance that is uniquely within our remit, which generally is about compliance with, workplace laws, including the Fair Work Act and others. And from memory, Mr. Margini didn't have any such history. It was instead criminal a criminal history that he disclosed in his application.
Okay. And then he was charged, I think, on the 19th of December 2023. And when did you say that you made or submitted evidence?
Well, we lodged the application seeking that suspension on the 5th of July 2024.
Why did it take so long, the 7 months between the charges and the application?
So, Senator, and I might just turn to Ms Dennis to assist at what was the date of committing to trial?
The committal hearing.
It was so he was committed to stand trial on the 4th of June 2024, and we made that application on the 5th of July.
Okay. Is there a reason that you didn't make the application when he was first charged, given given quite literally the serious nature of the charges?
So, Senator, and again, I think we have traversed this in previous estimates hearings, and I think that, in relation to the application that was first made for the permit, the subsequent charges which Mr Margini is now facing, we weren't aware of those. I think we had a discussion at last estimates around the very issue that you speak of. And what I would say, I mean, our assessment of the public interest isn't a static one, and we will take on board, what is happening more broadly, what community expectations are. I think we had a conversation about that, as you said, the compatibility of very serious criminal charges with the privileges of the right of entry regime, and so a determination was made that in fact we would make that application seeking the suspension.
And that was in June though, not when he was actually charged in December?
So we made the decision. I'm not sure exactly when that decision was made. In either June or July, but we filed the application on the 5th of July 2024, seeking that suspension after
and so
he was committed to stand trial.
Are you aware if Mr Margini is still visiting building sites?
Senator, we don't have. No one's got any knowledge of that who was at the table, so I can't answer that.
Given that you are now the building watchdog, though, would it not be appropriate that you are making inquiries in relation to whether a person who has had very serious charges brought against him has now been committed to stand trial, whom you on your own evidence has said, in relation to the nature of the charges, they are incompatible with the rights and privileges that a person holds under the Fair Work Act in relation to right of entry? Do you not think that you should be seeking active information, I would almost say on a daily basis, in relation to whether or not he is going onto sites?
Senator, if I might, I think it would be good if we could take that question on notice, because it may well be that there are other officers who aren't here today who might be able to assist about what there may well have been conditions that the CFMEU at that time agreed in relation to Mr Margini, but I just can't quite recall, and that particular person I'm thinking of in the agency is not here today, so it would be better to take that on notice if I could, Senator.
And I think our evidence on the last occasion, Senator, as to the period between December and the July date, we recall Ms Carey gave evidence that in fact at that point in time, her staff were monitoring his movements.
And Ms Carey is?
Ms Carey used to be. The group, the Deputy Fair Work Ombudsman for large corporates and industrial compliance.
So who's doing that now, the monitoring?
That will be Mr.
So
Campbell.
can you tell me what process is put in place to monitor Mr Margini and whether or not he is indeed exercising right of entry onto sites?
Well, Senator, Michael Campbell, Group Manager Operations. I think I would lean to Ms Volsky's request that we take that on notice, because I don't have that answer for you now. I am aware that, I would expect that we would know if there was issues with the way Mr Margini was, or if he is, exercising his right of entry.
How would you know that?
Well, we would have contact from the employers that are involved, and most likely the representative organisations like the Master Builders Association. So if I can check that though. So if you let me take it on notice, I can find out.
Okay, thank you. Ms Booth, how many prosecutions of the CFMEU has the Fair Work Ombudsman initiated since the abolition of the Australian Building and Construction Commission?
Senator, are you talking more broadly across all of our remit, so wages and condition matters as well, so just litigations in general? So it's 21.
21.
Yes.
That you have commenced against the ABCC? Against the CFMEU?
No, in the building and construction industry.
Yep.
There's 20 litigations. A matter.
So 20, not 21?
Sorry, with the extra one being the matter in the Fair Work Commission that we've spoken of, Mr Margini, and then one matter which is 9 the Esplanade, as it's commonly known, which we commenced against the CFMEU. And I just haven't got the date.
Could I get your information on that?
22nd of October. 22nd of October.
And what's the nature of, 22nd of October, what's the nature of the action brought against them?
So, Senator, though, that is a right of entry contravention matter of section 499 and 500.
Okay, and that's and can I get you on notice to provide me with the list of what the other prosecutions are?
Yes, Senator, noting that they're related to wage underpayments.
Yep, no, that's what I'd like, exactly.
Oh, yes, of course.
I would like, exactly. Ms Booth, when did you first become aware that the CFMEU had been involved for many years in bullying, harassment, bribery, corruption, intimidation, violence, lawlessness, and had links to organised crime?
The difficulty with the question, of course, is to cast one's mind back many years about suspicions as an ordinary citizen. But in my position, it would be the Breaking Bad series that was aired by Channel 9.
And prior to that, you had no knowledge. Sorry, what was that? I can't hear.
Building Bad. I apologise for the
Building Bad.
speaking.
Building Bad.
Yeah.
As a result of becoming aware, and it was the newspapers and the as you say, the Building Bad documentary. What action did you take?
We commenced, serious observations of the situation. Mr Campbell can detail exactly in a chronological sense what we did, but we certainly, even on we conferred with the department and we began our processes once we had received a specific request from the Minister, but I'll ask Mr Campbell to
So nothing, so did you say a series of
Cash.
observations?
So just before we answer Senator Cash, once this question's answered, you're welcome to do just a quick follow-up question if you need to, but otherwise I'll transfer it.
So just to confirm your evidence, you had no idea about the issues with the CFMEU prior to the Building Bad documentary in July of this year?
Not in the sense of any actionable intelligence or complaints, no.
So in terms of any media reporting over the last decade, did you think to consider it when you became the Fair Work Ombudsman?
I think I've given evidence in this regard before, Senator, what I considered when I became the Fair Work Ombudsman, and you'll recall you asked me if I'd met Mr Smith. My intention was to support cultural change in the industry, and in the union, and that's one of the motivations around the Building and Construction Reference Group being established. I think it's fair to say that the circumstances changed once the Breaking Bad allegations had been aired, and whilst we maintain our commitment to working with the industry on cultural change, that's why Mr Campbell's operations group began to do the work that
So
they are
you
now
thought
doing.
John Setka was doing a good job, is that correct?
You're asking my opinion on an
The
individual.
Fair Work Ombudsman in relation to someone who was running the CFMEU that has been now, if it was only Breaking Bad, bullying, harassment, bribery, corruption, intimidation, violence, lawlessness, and had links to organised crime, I would hope that as a Fair Work Ombudsman you actually have an opinion.
Look, I generally have a concern about any behaviour that is is spoken about, but as Fair Work Ombudsman, I'm bound to look at the evidence and the facts, and it wasn't until we began to seek from the industry specific contact in relation to those matters that Mr Campbell's area was able to identify lines of inquiry. So
despite the successful prosecutions that were brought by the Australian Building and Construction Commission, and that is courts in over 90% of the cases, finding that the actions brought against the CFMEU for the bullying, the thuggery, the intimidation, the harassment, the lawlessness were actually indeed correct, you're now saying, as the person in charge of regulating the construction sector, that you didn't know until July of this year that there was any wrongdoing in the CFMEU, and that in relation to John Setka, is there evidence that you hadn't turned your mind to what he was doing?
Of course, I was well aware that there were multiple cases on foot, and I was supportive as the Fair Work Ombudsman in continuing to take action in relation to those cases.
This is extraordinary.
All of those cases have evidence that is actionable and able to be brought before the courts. And
I will return to this line of
that.
questioning. This is extraordinary.
Senator Freaky.
Thank you, Chair. Good afternoon, everyone.
Afternoon, Senator.
Universities have been a regulatory priority for the Fair Work Ombudsman for some years now. So what is your assessment of the situation now? Are things getting better?
Okay. We have certainly, and specifically, the numbers as of 31st of October 2024, there were 21 ongoing matters in the public domain relating to underpayments, and overall we've been in contact with 33 universities covering 34 entities. Given the number of universities, which I think is around the number 42, I don't have that in front of me, but it's in that vicinity, I'd have to say that it's getting better in the sense that we have actually been able to either reach enforceable undertakings or to see outcomes that include future-focused mechanisms to improve governance and payroll systems. So, yes, I think I would conclude that it's getting better, but there's obviously still a way to go. And, of course, nothing's static, so circumstances are changing, and we are in constant contact with the 21 that are ongoing matters.
There has been an 89% increase in casual and fixed-term employees in the tertiary sector between 2010 and 2021, and two-thirds of all employees are employed insecurely. And I think Fair Work Ombudsman has previously stated that the sector is still systemically non-compliant, and one of the reasons for that is, you say, employment of high numbers of casual workers. Have you seen any signs of this trend reducing?
I've not got data on the employment types that profile of universities. We certainly have said that there's a correlation between the underpayments that we've seen and the proportion of casual employment. I don't know whether we do have any current data on employment profile.
Given that it is a big factor,
universities.
is that something are you looking at? Given that it is a big factor and it has correlation, Is that something you intend looking at?
Look, I could take it on notice, because within the organisation there will be people who are tracking these matters, and we have a higher education reference group where these matters would be discussed. But as I sit here now, I don't have those figures.
If you could take it on notice, that'd be
Yes,
appreciated. How many of the Fair Work Ombudsman's current investigations relate to universities? So out of the total, how many? You said 21, I think, are ongoing matters?
I might ask Mr Campbell, because it's his area of responsibility.
It's 30.
So 30?
30 ongoing matters.
You have 30 ongoing matters, and 21 of those are universities.
Sorry, 30. No, we have 30 ongoing matters involving universities.
Okay, and how does that, how many overall ongoing matters do you have on other issues?
On hand at the moment, maybe. It's at varying stages of, I suppose, completion. We'd have on hand probably, 1,400 matters at the moment. Matters, but that ranges from everything from simple underpayment matters right through to more complex and significant conduct.
So 30 ongoing matters and 33 universities under investigation at the moment. Is that what you said, Ms. Booth?
There is overlap in some, because we have multiple proceedings on foot involving particular institutions.
Okay, and could you tell us which universities have multiple matters? And
the answer is yes. I can do that on notice if that's okay.
If you could,
yeah. Because if I try and do it live, I'll end up confusing us both.
If you could provide a list of the universities and how many matters each.
I'm happy to put something together on that.
Yeah. And how much has the Fair Work Ombudsman fined universities in the last 5 years because of underpayment and wage theft?
Matters before the court, I suppose, would be penalties imposed by...
I think we'd have to take that.
Yeah, sorry, if you could take that on notice as well. Yeah. And do you have an estimate of the amount of wages amount of wage theft, I'll call it, the wages stolen from universities in the period that you have been investigating matters?
I believe we can give you a figure on the recoveries that have occurred. If you
if you could give me that.
So, Senator, if it helps, from the financial year 2020-21 to 2023-24, we've recovered $148,987,005.
And can you give for the same period how much? So that was how much was stolen overall, and what part? Maybe if you could ask.
I can find a different way to answer that question.
Yeah, how much of
what's the proportion of that?
Exactly.
Total recoveries.
Exactly.
Yeah, I can take that.
Your submission to the university's accord process was pretty scathing, stating that entrenched non-compliance with workplace agreements was resulting in the systemic underpayment of casual staff. And the submission did call for an overhaul of university corporate governance. The submission also found there was failure to comply with the university's own enterprise provisions, including misclassifying duties, roles, etc., etc. The government has now announced an expert council, I think, on university governance recently. What changes would you like to see come through that process?
Senator, I don't have an opinion on that, but we have said in previous estimates that we want to see improved governance and oversight by the higher levels of the institution. We want to see systems put in place that properly track how casual staff hours are recorded and paid. I'd be repeating what was said previously. It's these types of...
Will Fair Work Ombudsman be engaging with that process of the expert council on uni governance?
Yes. I mean, we're in contact with the sector, as Ms. Booth previously testified, that we've got our own
not the
reference
sector,
group.
but this particular process. Has the government contacted you to be involved in that process, and
Is this the Accords panel review?
Sorry, the Expert Council on University Governance, which was recently announced. And since a lot of the matters of underpayment are related to governance issues, what are your thoughts on engaging with that panel? Will you be engaging with it, and how?
Would be if there was benefit for the panel for us to assist them with their processes, would say yes. I am.
That's a pretty vague answer. Like,
well, Senator, I actually don't know what you're referring to. So I'm.
Okay. Well, that's even worse, I guess, because if you are concerned about underpayment happening because of governance, there has been an announcement made by government,
Senator,
and you don't know about it. So government hasn't contacted you about that?
Is it the TESCA process that you're referring to, the Tertiary Education Qualifications?
No, I'm
Authority?
referring to the Expert Council on University Governance, which the government recently announced because of the massive issues of governance in universities. So government hasn't contacted you about that,
well,
I'm presuming.
Well, an independent expert was under the Accord panel.
I know, no, that's not it. That's not it. So I guess my question is, has the government contacted you about that? It doesn't seem like they have.
I better take it on notice,
it.
Senator, because it might be that one of my officers is working with them directly. I just personally don't know the forum that you're referring to. It's not to say that it's not happening.
Okay, sure. If you could take that on notice.
Yes, be happy to.
The government's plan to cap international student numbers is going to hit universities very hard financially, and there are estimates that 14,000 jobs could be lost. A number of universities have already announced up to 1,000 job losses because of that cap. And I guess you know that university funding has been declining over the years, government funding. So are you concerned, Fair Work Ombudsman, are you concerned that these financial pressures will have an impact on casual staff and underpayment and wage theft?
It's not a matter that's been raised with me. As I said, the Higher Education Reference Group, which is chaired by our Executive Director for one of our enforcement branches, may be discussing that. But you'd be asking me for an
This
opinion.
would be like a huge, this has like been a huge issue over the last some months, one of the biggest issues that universities are facing, and their staff are being lost. So I'm just wondering, given the connection between casual staff and underpayment, is that something that you have looked into or are you concerned about?
We certainly examine the environmental factors that sit around an organisation's capability, but it's not something that, as Fair Work Ombudsman, I have, an opinion about, because it's not within our sphere to analyse the financial capability, of organisations based on potential, changes in their market environment. But I am quite sure that it's something that the parties, that is the higher education employers and unions, will discuss at our reference group. And I've not attended one of those reference groups for a little while, so I'm not sure whether they are or they aren't. But we do have an executive director who chairs that reference group.
And I guess you would probably know about the financial pressures that universities like ANU are facing. And ANU is projecting a deficit of more than 200 million this year, as well in excess of its projected, so it is well in excess of its projected shortfall of 60 million. It says it won't be financially viable unless there is a structural intervention, including salary cuts and job losses.
These are, universities are not alone in experiencing financial pressures.
Could I complete my question, if that's all right?
Certainly.
ANU Chancellor Julie Bishop was asked by the Canberra Times whether it is fair to ask ANU staff to give up their enterprise agreement pay increase for December. And in response, she said, "It depends to whom you refer, because many members of staff have been part of the inefficiencies that the university is now seeking to address." From where I sit, it is pretty disgraceful to blame staff for their own job losses. These are decisions the executive makes. So I just want to ask you, because Fair Work Ombudsman has many times stated that these non-compliance, which are systemic, are often due to employment of casual staff and of ineffective governance as well. Do you think part of the problem we see with university underpayment is this callous attitude towards staff from executive and management?
We are certainly on the record as saying that paying attention and being conscious of the importance of paying staff correctly is an essential feature of a compliance culture, and that we've seen that lacking in the universities that we've engaged in the past, and that our enforceable undertakings are very often designed to actually address that. I would say that because our job is to enforce the law as it is, then it's not for us to get involved in a discussion about whether people should be giving up some of their rights in order to achieve other value that they might achieve in terms of future employment. We say that when the instruments are in place, they ought to be adhered to, and we're here to ensure that they are. What other discussions and considerations parties have about their futures is something for them, and I don't think it would be appropriate for the Fair Work Ombudsman to be expressing a view about it. It's not within our scope of activity.
Thank you. Thanks, Chair.
Thanks very much. Senator Brown.
Thanks, Chair. I've got a couple of questions. I just wanted to follow on about underpayments. So, how much in the construction workers' wage underpayments has the Fair Work Ombudsman recovered in the last couple of years?
Thank you. I'm going to ask
can you give it to me year by year?
Yeah, sure, Senator. Last financial year was... so 22-23 was $4,215,968.
Yep.
And 23-24 was $3,031,089.
And can you add that up for me?
Since we Senator, I'll get someone to get the calculator out, but it looks like it's about 7 million. Yeah. It's about 7,200,000.
7.2.
Yeah.
Okay. We got there together.
Yeah.
So how does that compare to the amount recovered by the former ABCC? Do you have those figures
Senator,
with you?
I don't have those details.
I might be able to help you there.
Oh, thanks,
Senator
Minister.
Brown. I can double check this, but the records I've got is that over about 5.5 years, the ABCC recovered about $5.7 million for construction workers.
So in 2 years, the Fair Work Ombudsman's recovered 7.2 million, and over 5.5 years, it's 5.7.
That's the figures
Good
I've
job.
got, yeah.
Well done. I did have a follow-up question. I do have other questions around underpayments more generally. Will I just continue?
Sure.
Sure. Can you provide the committee with information regarding penalties issued against employers for underpayments?
I believe we can, but whether we can now is another question. Okay. We certainly have a list of said penalties. Mr Campbell, do we have them with us?
Senator, I have penalties in aggregate. So last financial year was $21,234,213.
What information can you give me broken down either now or on notice?
I can definitely get you some... Well, the figure I've just given you was effectively $21 million in fines last year imposed by the courts against, effectively wrongdoers. Yeah. Now, there will be a portion of that... I'll just need to confirm that all goes to employers or whether or not there's any conduct by other parties.
Oh, right. And can you break that down by sectors? Like construction... we will be able to a certain... yes, we will. We'll find a way of doing that. And you'll have to provide that on notice, or can you do it now?
I can tell you how many litigations we commenced in the building construction sector by year, but I can't tell you the penalties for those years for those litigations.
Why don't you give me what you have, okay. Mr Campbell?
Sure. So we commenced...
If I could just ask a supplementary question, if that's okay.
Sure.
Senator Brown, can you also when you're giving that list, could you also just include the current number of investigations and allegations of misconduct within the construction industry?
We were just talking about underpayments, but
Yeah. We're just talking about underpayments at the moment, but I can come to that, Senator, as well. If you
Sorry,
wish.
I won't interfere with Senator Brown. I'll ask that question after she's finished.
Senator, I have it that we've commenced 10 litigations in the building construction sector last financial year, and in the year before that, 18.
All relating to underpayments?
There might be one or two in there that involved union conduct, but I just need to confirm that for you.
Okay, all right. Can you answer the question Senator Sheldon put to you?
Sure. Senator, would you mind
absolutely
repeating that one for me?
Can you provide the committee with an overview of the current number of investigations into allegations of misconduct within the construction industry?
Sure. Senator, can I take it from your question that you're talking about recent conduct that has been subject of...
yes, the current number.
Yeah. So we've got 42 active investigations involving industry participants in the commercial building construction sector.
Yep, 42.
42, correct.
Fantastic, all right. And just want sorry if I can just indulge Senator Brown. Just since assuming the ABCC's responsibilities for regulating the construction sector, can the Fair Work Ombudsman provide information on the number of investigations into alleged wrongdoing of the CFMEU the Fair Work Ombudsman has started?
Senator, in terms of started, I'd probably need to take that on notice, but can I give you some current... I've got some current data if you wish. We've currently got 23 investigations underway which concern conduct of CFMEU and its officials, and 19 concerning conduct by employers in the building construction commercial sector.
Right, thank you.
That's 42, isn't it?
That's correct.
So that's 23 are about officials of the union, 19 employer.
Right. Thank you, Mr Campbell. That's helpful. Sorry, Senator Brown, I'll pass back to you.
Thanks. Chair, the privileges of being chair.
Indeed.
So we were talking about underpayments, but regarding penalties issued against employers for underpayments. So how do these penalties compare to previous years? And also, can you talk to me about the committee about increase in wages recovered as well?
Yeah, Senator, as I said, I don't think we've got disaggregated figures about the building construction sector with respect to litigation penalties, but we can talk about penalties in total.
Yes,
over the last few financial years. Janine Dennis can assist us with that, if you wish.
Janine Dennis, Executive Director, Legal Enforcement. Sorry, we've just recently changed our name. In the last financial year, we got the highest penalties we've ever received, so just over $21 million in penalties that year. And just to give you some comparison, our previous highest year was in 2017-2018 when it was $7 million. You'll see an increase in the amount of penalties that we've got.
Sorry,
so
how
last
much was
financial
it
year, Sorry.
2017, 2018. What did you say it was?
So in 2017, 2018, we had 7 million. And then the year after that, 4 million or just over. 2019, 2020, 4 million again, or 4.3. Then in 2020, 21, 2.8. 21, 22, 2.6. 22, 23, 3.6. Last financial year, 21 million or 21.2.
That's a big jump.
Big jump. So last year we had some of our largest decisions come down in terms of large corporates. So against the Commonwealth Bank, we got a penalty of $10.3 million, which at the time was our highest. And this year we've had an increase as well, with the Sushi Bay proceedings getting 15.3. So as of this financial year, we're sitting on $17 million in terms of penalties.
Well done. So that's an increase in wages recovered for workers?
There is a corresponding increase, but it's worth noting that the increase in penalties is also a feature of changes to the penalty regime under the Fair Work Act, and also...
Can you talk me through those?
I'll ask Janine to do that if you... sorry, Ms Dennis?
Yes.
I'd probably say we've seen increases in the amount of penalties through legislation that's come in. So the maximum penalties that exist now under serious contraventions have increased. So that's increased the amount that we're getting in terms of penalties. So it's probably a twofold sort of issue. There's an increase in the amount of penalties that we're getting under the legislation. Then in addition to that, we've had an increase in the amount of litigations that we're running, but also the complexity of the litigations that we're running.
And what enabled you to increase the total amount of the litigations that you're running?
I think we've become more sophisticated as a regulator in terms of our litigation practice.
Okay, all right. Had you completed your response?
Oh, sorry.
No.
My apologies.
Okay, all right. If you could put some information on via question or notice around increase in wages recovered for workers, I would really appreciate that. Thank you.
Sure. Senator Payman.
Thank you, Chair. Good afternoon. I've just got a few questions that I put to the department earlier, but they said you guys are best to answer. It relates to the amendments to the Fair Work Registered Organisations Act 2009 this year, which enabled the Construction and General Division of the CFMEU to be put into administration on 23rd of August. Under Section 323HA of the Act, I was just curious to know how many complaints has the administrator received regarding the actions of members of the CFMEU?
I think, Senator Payman, that question actually should go to the Fair Work Commission, who are on next.
Okay,
and they,
I was told Ombudsman, but that's fine.
They may or may not. Feel free to contradict me, but that's,
No, that's correct.
I don't know whether they'll be able to answer that question, but they would be the people to put it to.
Senator Payman, we don't have a role in the administration formally, and so we're not in receipt of that information or reporting.
Okay, so we'll go through the one that hopefully does, because the matter was referred to the Fair Work Ombudsman. In August of this year, the ABC reported that Comanchero bikie gang members were alleged to have threatened a CFMEU delegate on a BMD building site while claiming to be directors of Host Group, which is a security provider. This matter was referred to the Fair Work Ombudsman rather than the police. Shouldn't allegations of criminal conduct be referred to the police rather than the Fair Work Ombudsman?
Senator, I'll do a couple of things. One, I think we have active inquiries into the circumstances that you're describing. So I'm limited in what I can discuss with you here, but I would say that given the conduct, I'm confident that we would have referred that matter to the police as well as conducting our own inquiries.
Okay, so
I can confirm that on notice if you like.
Yep. Yeah, that'd be great, thanks. And what actions were taken since the referral in August?
Yeah, well, my recollection is that we have an ongoing investigation, so that's that. With respect to the action by the police, I couldn't speak to what the police did. It was Queensland Police. We're talking Queensland, aren't we?
Yep.
Yes, yeah.
Anyway, I'm saying I'll take on notice, but I'm reasonably confident we referred it to the Queensland Police to make their own decision and inquiries into, as well as us commencing our own investigation.
No worries. I'll wait for the Fair Work Commissioner. Thank you.
No worries.
Senator Cash.
Thank you. Ms Booth, you were appointed to the role in September of 2023. Is that correct?
From the 1st of September 2023.
1st of September 2023. Right. But you've said that in terms of, you first became aware that the CFMEU had been involved for many years in bullying, harassment, bribery, corruption, intimidation, violence, lawlessness, and had links to organised crime effectively in July of 2024, when the Building Bad documentary...
Detailed allegations thereof, yes, Senator.
So what was that?
The detailed allegations.
The detailed allegations of thereof.
Building Bad.
So what were you aware of between your appointment and July?
So from, I guess, my previous history, I was aware that the CFMEU had a reputation for thuggery in the context of conducting industrial relations, but with no specific allegation that I was aware of. And that is why one of the first meetings that I had as Fair Work Ombudsman was with Zack Smith in his former role as National Secretary, which was to really to bring to his attention my concern about the culture of the union and my desire to take steps to support the reform of that culture, to educate.
And when did you first meet with Zack Smith?
I think I'm on the record with that. I'm not sure that I think I probably can answer that, but I will just look for my list of meetings here. I certainly have given you that information before. Let me just see here. That would have been the 4th of October 2023.
4th of October 2023. You trusted Zack Smith, did you, to improve the culture of the CFMEU?
It wasn't a question of trust, it was a question of commencing a process of engagement to bring to his attention initially my desire to be active in this area and to put to him the formation of a reference group for the employers and the unions, all unions, not just the CFMEU and the industry, to work together on the subject and also to begin to develop a body of work which is underway to document and describe appropriate behaviour in the context of a range of different industrial rights and obligations, such as right of entry.
Did Mr Smith succeed in improving the culture of the CFMEU?
Well, I think you would have to say that the Building Bad series really interrupted that process and brought to light allegations that were of much more concrete and serious nature. Obviously, a lot of them were criminal, which is outside of the jurisdiction of the Fair Work Ombudsman, but they certainly did, bring other behaviour to light. And really, where we are at the moment, where Mr Campbell has outlined with the number of investigations we've got, is now our current action in relation to those matters, which I am obviously both.
I find this quite extraordinary evidence. A, that your evidence is you only first became aware of the bullying, harassment, bribery, corruption, intimidation, violence, lawlessness, and the links with organised crime with the CFMEU in July of this year. But I'll accept that is your evidence.
I don't think that's what Ms Booth said. I think you're misrepresenting what she said.
Well, then what? Okay. Well, to be clear, what did you say, Ms Booth?
I think what I would say now is it was the allegations that I became aware of at that time. But as an industrial relations practitioner, both in private practice and as a member of the Fair Work Commission, I've certainly been aware that the way in which the CFMEU officials conducted themselves was different from other unions, and not good different.
You call it different, do you?
Well, not good different.
So basically, being organised crime is different to the way other unions conduct themselves.
So the organised crime in particular is something that I didn't have visibility of. That was through the Building Bad series.
So given that you initiated your discussion, or you had your discussions with Mr Smith at the end of 2023, I think you said it was?
On the 4th of October 2023.
4th of October 2023. And the Breaking Bad documentary showed that obviously, I will put it to you, the discussions clearly didn't work, and that you had a union that had been involved for many years in bullying, harassment, bribery, corruption, intimidation, violence, lawlessness, and had links to organised crime. How successful do you think you were in that time?
Well, I'd also remind you too that at the time on foot were a number of litigations being conducted by our legal team And so I was also aware of those as a second stream of activity. But clearly, the circumstance that we're facing today is evidence that we've not been successful to date in reforming the culture of that union, and the only thing to do is to keep moving forward to do all of us to do our part and to play that part in a way that's consistent with the specific powers or scope, if you like, of what we do. So I have a role as Fair Work Ombudsman, the Fair Work Commission has a role, the Administrator has a role, etc. And of course
I just want to go through.
Can I just say one thing? I think we should also remember, Senator Cash, that the allegations that were aired in the Building Bad series were allegations of events several years ago, while the ABCC was in operation, while the Coalition were in government, and well before Ms Booth took up this role. So I don't think any suggestion should be made that she is responsible for events that happened several years ago.
So since the allegations came to light, Ms Booth, what oversight mechanisms, if any, does the Fair Work Ombudsman have in place to track union payments or affiliations that might have links to organised crime?
Well, I'm going to turn to Mr Campbell to respond to that, but remind you that we don't have a role in criminal matters of that nature. But Mr Campbell, can you add to that?
Minister, Senator, that's not a matter within our jurisdiction.
And when you say it's not a matter within your jurisdiction, why is that?
It's not a provision of the Fair Work Act.
And that's not a power that you've been given by the Minister?
It might, Senator, because it's not within our purview, I'm not saying it doesn't exist, it may well be a power of the Commission's.
Senator, are you referring to the corrupting benefits? Are you referring to the corrupting benefits offences?
No. Well, a whole lot of allegations have been made and have been aired. You have a number of investigations in place. I now want to go through the steps or the processes and procedures and what you've actually done since the allegations have come to light. Some of the allegations are in relation to union payments or affiliations that might be indicate links to organised crime. Is the FOI doing anything to track anything like that?
I'll talk to things within my jurisdiction, Senator, and if that helps, that's good. If not, then we'll see what we can do. But we have, as I've said already, 42 active investigations in the commercial building construction sector. 23 of those go to conduct of the CFMEU or its officials. Within the jurisdiction of the Fair Work Act, the issues concern misrepresentation of workplace rights, coercion, right of entry, unlawful industrial action, and with respect to some of the employers, we've identified potential underpayment matters or breaches of enterprise agreements, because those issues are squarely within our jurisdiction. We've had matters on foot with respect to conduct of the CFMEU that predated the Building Bad expose. The matter we spoke about previously that's before the courts, number 9, the Esplanade, was a matter that was referred to us by Multiplex in December of last year, and within 12 months we've got the matter in court. So it's not for lack of will or trying, it's a matter of, part of this is work that's come to us more recently, and I expect there'll be more enforcement outcomes in the months and years to come.
So how many of the Fair Work Ombudsman investigations, and there's 42, as you said, that are active investigations, have you taken to court?
We filed one 2 weeks ago, Senator. And
you filed one, and that was in relation to?
Number 9, the Esplanade, conduct of an officer in CFMEU in WA, Mr Parker.
And what was the nature of...
Well, we allege, as I said, it's before the courts, that we allege that the permit holder allegedly hindered, obstructed or behaved improperly and allegedly failed to comply with reasonable occupational health and safety requirements when exercising a state occupational health and safety right.
So can I just confirm, in the last 2 years since the Australian Building and Construction Commission was abolished, how many actions have you filed against the CFMEU?
It's one, Senator.
Just the one?
Yes.
And this is despite everything that has been aired in relation to Building Bad. There has only been one action filed against the CFMEU now that you are the regulator of the building industry?
Well, there's some... Anyway, Senator, what I can say is it is a good thing, in my opinion, that we have more people now willing to engage with us as a regulator within that sector to bring to bear allegations and conduct of industry participants, including the CFMEU and its officials, so we can investigate them and use our enforcement powers to address the conduct. So I've said that there's 23 matters currently on foot with respect to the CFMEU and its officers. Some of those matters will inevitably track to enforcement litigation outcomes. I'm very confident of that.
I mean, bear in mind the allegations were aired in, July, and the evidence is that one piece of litigation has commenced, that 42 investigations are now underway, including 23 in relation to the CFMEU and 19 in relation to employers.
Well, that's if you accept that the allegations actually only came to light in July, which I do not, given the numerous royal commissions that have already found in relation to this matter that this behaviour has been ongoing for years and years and years. Can I just ask,
I guess that begs the question, why, if you're saying that you knew that organised crime was involved in the construction industry or the CFMEU, I guess it begs the question why you didn't do anything about that.
Well, actually it does. I don't have time to go through the fact that we actually went to a double dissolution election in relation to our commitment to cleaning up the construction industry. I was actually the relevant minister in December of 2016 that stood up 2 pieces of legislation, and if I recall, no support from the Labor Party.
Oh, okay, so it was the opposition's fault. It was the opposition's fault that the then government knew about organised crime and didn't act on it. Okay. Okay, understand.
Difficult to act on it when you actually don't have the numbers in the Senate, and you need at least an additional 10 votes that Labor never gave to us, so I constructively worked with the crossbench at the time. In fact, if I recall, Senator Watt, it was you who was personally leading the charge against the legislation.
If you want to blame others for your own failures, go right ahead.
Can I just, though, again going through, since the allegations came to light, what steps has the Fair Work Ombudsman taken to prevent CFMEU-linked officials from using their positions to bully or financially exploit contractors?
I think the answer lies in the investigations that Mr. Campbell
If you could take me through them, what steps have you put in place?
Senator, the conduct you've described there is criminal conduct.
Yes.
So we're a civil regulator.
Correct.
The jurisdiction of the Fair Work Ombudsman doesn't extend to that kind of corrupt conduct.
So you're doing nothing in relation to that?
Well, Senator, if conduct that you've described fits within our jurisdiction, we would be, but it isn't. So the coercive conduct that we've seen with respect to behaviours by CFMEU officials to contractors around bargaining, that's within our jurisdiction. That's conduct which we've seen, and that's conduct that we're investigating.
If you do come across conduct that is not within your jurisdiction, and that's obviously another discussion which we'll have shortly, what do you do with that? Do you refer it off to the police?
Yeah, it would be, if it's a criminal matter, it would be referring it to the police, and if it's something within the jurisdiction of the Commission, would refer it to them as well.
And how many referrals to the police have you made?
I'll need to take that on notice, Senator.
Have you made any?
I know that referrals have been made to the police. I don't know the nature of those referrals, to hand.
And Senator, I think one was mentioned before in relation to...
threats made to an
correct.
individual.
And Senator, obviously complementary to our role is that of the administrator that's been set up under the legislation, who obviously has not only, very broad powers to inquire, but also to refer as well.
I'm going to have to quickly change subjects because we are literally battling time, and I do want to get this in before the dinner break, but I'm happy to come back to this line of questioning after dinner. And it's just in relation to the underpayment by the department of their 201 staff dating back to 2022.
Yes, Senator.
Can you please give me an update on your investigation into the Department of Employment and Workplace Relations and the underpayment?
We've concluded that investigation, Senator.
And when did you complete it?
11th of September, Senator.
The 11th of September. And can you take me through from when the Fair Work Ombudsman was first made aware of the underpayment to the 11th of September? What was the process of the investigation?
Yes, Senator. I'm going to ask Mr Crick to give you an overview of our investigation and findings.
Thank you, Senator. Daniel Crick, Executive Director, Operations Group. Senator, the Fair Work Ombudsman was made aware of the underpayments by way of self-report from the Department of Employment and Workplace Relations, which was sent through to our corporate assurance inbox on the 9th of August 2023.
So the Secretary didn't call you to advise you that the Department of Workplace Relations had underpaid its employees?
My understanding or my recollection, Senator, is that the Chief Operating Officer telephoned the Acting Fair Work Ombudsman, Kristen Hanna, to notify her that she intended to send through formal notification of an underpayment, which she did later that same day, as I understand. But
do you know what date that was?
On the 9th of August.
Oh, so it was the 9th of August,
well,
okay.
And I can take on notice to confirm for you, Senator, but that's my understanding of how that transpired.
And I appreciate that. Thank you, Mr Crick. And then what happened?
So, Senator, after receiving the self-report from the department, I requested... So my role is Executive Director within the Operations Branch, and my branch has responsibility for oversight of self-reports of non-compliance received from employers across the economy. And so in that context, my staff and I met with the department on the 21st of August 2023.
And who did you meet with in the department?
So we met with senior representatives of the department, Senator, that included the Chief People Officer, the Assistant Secretary of Organisation Design Branch, and a Director of Human Resources Policy and Operations.
You didn't meet with the Secretary?
No, Senator.
Did you ever meet with the Secretary?
No, Senator.
Okay. Please keep going. Thank you.
Yes, Senator. At that first meeting with the department, we asked a series of questions regarding the information that had been provided to us as part of their self-report. We foreshadowed forthcoming detailed requests for information that we intended to put to them in writing, and we set out our expectations around the department's provision of regular updates to us on developments as they progress their remediation program, and including our expectation that they provide us with employee communications and other communications that were sent out in the course of their remediation. Subsequent to that, on the 1st of September, there was a telephone conversation with the department regarding the calculation of interest and the application of interest on underpayments that were in the process of being rectified. And on the 21st of September, all in 2023, Senator, we issued the department with a formal request for information, which set out in detail the evidence and the information that we wished to obtain regarding the circumstances that had been self-reported. And I can give you an example of the sorts of things that we asked for, Senator. So an update on the progress of their review and updated monetary breakdowns of payments that had been made or anticipated to be made. An update on the review of the determination, the industrial instrument in question, which the department was having undertaken by an external legal provider. Detailed information regarding the methodology used by the department to calculate the entitlements that were owed to employees. So in that regard, Senator, we asked for any business rules and assumptions which underlie the calculations that are being undertaken to determine the scope and extent of the non-compliance. We asked for information regarding the specific data sources that the department is using to inform its analysis, so whether it's extracts of the payroll system or roster information, timesheets and the like. We asked for the department's approach to data and calculations validation and testing, again to provide us with assurance of the quality of the program that was being undertaken. And we asked for any other relevant modelling or data that could inform our scrutiny of the process. We also asked for an update on any corrective or preventative actions that were being taken or implemented by the department at that point in time. Over the next 3 months, Senator, between October and December of 2023, we received a further 4 tranches of detailed information from the department in response to our various requests for information to that point in time, and made a further request for information of the department on the 13th of December 2023.
A further request for information on the 13th of December?
That's correct, Senator, yes. On the 1st of February of this year, we met with the same representatives of the department to discuss the progress of the remediation program that was underway, and to discuss some additional contraventions that had been identified as part of the broader legal review of the industrial instrument. It was relating to shift penalties and restriction allowances. We required further information from the department about those additional issues at that time.
And when did you request that?
That was at that meeting of the 1st of February 2024. There was further updates in writing, Senator, from the department in April and May of 2024. I'm sorry, I hope this is helpful. I'm going through a bit of detail here, but a further request from us on the 31st of May, and at this point we were very interested in understanding an update regarding the internal audit that had been commissioned by the department.
And can you take me through why you're interested in it?
Well, one of the things that we look to get assurance around in a self-report context, Senator, is any steps that are being taken by the entity that's reporting non-compliance to put in place measures to prevent recurrences of underpayments and to ensure that they have systems and processes, and particularly corporate governance arrangements in place, which are going to ensure their compliance into the future. And so we knew from our interactions with the department that they'd engaged an external auditor to review their general processes and controls around payroll risks, and we were very interested to understand what the reflections of the auditor were as to the effectiveness of those controls. And so that was one of the issues that we were engaging with the department on, certainly at that time and more broadly. I think, Senator, we'd gotten up to perhaps the 31st of May.
Yes.
Great, fantastic. By the 18th of June, then, there was a further request from us to the department, primarily regarding the methodologies that they'd applied for those additional 2 compliance issues they'd discovered around the shift penalties and the restriction allowance, and some further gap filling, I suppose, regarding the payroll audit information. And that final information provision was provided to us by the department on the 4th of July in 2024. By that point, Senator, we had gathered the information that we felt we needed to have access to be able to make a determination under our compliance and enforcement policy about what would be an appropriate disposition of the matter.
What does that mean, an appropriate disposition?
As in how we intended to resolve our investigation.
Right, how you intended to resolve it?
Thank you, Senator. As I think was put in evidence by officers of the department this morning, on the 11th of September, we notified the department of our decision, and the decision was in effect, Senator, to issue the department with a caution for non-compliance with the Commonwealth workplace laws in respect of the underpayments that they had self-reported to the Fair Work Ombudsman, and to provide them with the guidance and advice as to what steps we expected that they undertake to ensure their compliance with relevant workplace laws moving forwards. And at that point in time, we determined not to take any further steps in respect of the investigation.
So can I just confirm, are you able to table the letter of the 11th of September 2024 in relation to issuing the department with a caution?
Senator, I don't have a copy of the letter.
No, tabling, it's
so,
fine.
Senator, you'd know traditionally we don't publish or table investigative materials. Did the department
The department said that I needed to refer it to you.
Oh, okay. Well, we'll work it out, Senator. But if we can table it and it's appropriate, we will. But I don't think there's an issue with the department tabling it, given it's
there's a strong
letter.
public interest, obviously, in the case.
I'm not going anywhere near that, Senator. It's just more that we don't.
And workplace relations, they were found, as you say, they did underpay 201 staff. You have issued the lead department, this is the department that sets the law for the rest of Australia, with a caution, but you've also at the same time determined that you will not take any further action. So I think there is a very strong public interest in the public understanding exactly what has happened with this department. Ms Booth, were you kept appraised of the investigation into the department, given that it is the Department of Workplace Relations?
Only in the sense that I sit on the Enforcement Board, which is one of our governance bodies, and regular reports are given to that board. The particular chronicle that Mr Crick has so well set out for you is not one that I would typically know about in relation to the very many self-reports, not only in this government department but other government departments, and also many private companies. This is a very, from my observation, this is a routine approach that's been taken and a routine outcome.
I find that a little surprising, given this, you might say it was a routine approach and a routine outcome. This is the Department of Employment and Workplace Relations that writes the industrial relations laws for the rest of the country. They underpaid 201 staff. Do you have the amount of the underpayment on you?
I think Mr Crick can help you there.
We're 25 seconds off the break.
Senator, the total amount that was remediated to employees was $243,064.31. That is inclusive of interest, which was generally indexed at a rate slightly above 8%.
So 201 employees, in excess of $243,000. This is the department that literally provides the minister with draft legislation and is meant to set the example. You issued the department with a caution. What is routine about this?
Well, we have a compliance and enforcement policy that sets out clearly the factors that we take into account in matters where there has been an unintentional, inadvertent mistake made. And many corporates, many large corporates, that's why we've got a whole group responsible for large corporates. Many large corporates make these mistakes. And they're dealt with in a similar manner. So we're very consistent with the way in which we deal with these matters. But Ms Booth,
this is not any large corporate. That is my point. This is the Department of Employment and Workplace Relations. This is not just a routine matter. I'm very surprised. When was this first brought to your attention?
I'd have to take that on notice. It would have been the first enforcement board, I would think, meeting that the matter was reported, since it did commence prior to my
Could you take that on notice, please, and provide the committee with the date of that?
Yes, we can.
And then I do have a series of further questions which...
We come back.
Yep, okay.
Cool, no worries. We'll now we're suspended until 7:20. the National Centre for Vocational Education and Research aren't required?
I'm sure they'll be pleased to hear that.
They could, but they could stay and watch if they'd like.
They could. They could.
Don't feel reluctant. You are still very welcome. You are still very welcome.
As you can see, the galleries are overflowing with attendees.
I can hear the cheers in the other rooms. It's deafening.
So that, just to be clear, that means we've got Fair Work Ombudsman, Fair Work Commission, coal mining, long service leave, and Department on Skills and ASQA.
That's correct.
ASQA as well?
Yeah, ASQA, yeah.
For the moment.
I'm not going to ask any...
Sorry, Senator Roberts.
Sorry,
just...
Thank you, Chair.
Senator Roberts, my apologies. I just did it for a second occasion. My apologies. So, thanks.
We're on? We're starting?
Yes.
Okay. Thank you, Chair, and thank you for being here from the Fair Work Ombudsman. I want to congratulate and thank the Fair Work Ombudsman for responding to the Independent Workers Union of Australia request for underpayment assessment on behalf of IWUA casual miner members. I hear that the Fair Work Ombudsman is treating these requests with seriousness and professionalism, and you've set up a specific process for handling the claims. Given that the underpayment claims involve detailed investigation of documents relating to each miner's annual income, their pay rates and so on, going back as far as 2013, I appreciate that the investigations may take some time. Does the Fair Work Ombudsman have any idea of the timelines involved? And I'm not urging or wanting a fast outcome. Rather than a rush job, I prefer a thorough, high-quality investigation.
Well, thank you for the question, Senator, and the compliment. I'll ask Mr Campbell to commence, but Mr Ronson has direct knowledge of that investigation, I believe.
Yes, Senator. I don't know that we've got a time frame at this point, but I'll ask Mr Ronson to assist with an answer given his immersion in the subject.
Steve Ronson, Executive Director of Operations. Senator, we've put together an overarching project plan in response to the request to investigate the sector. In terms of preliminary findings, if this is a guide, not so much necessarily for each request for assistance or each employee, we're looking at preliminary findings by at least the middle of next year, because one of the challenges we face, of course, is as we go back to 2013, there's those records, available witnesses, and so forth.
Okay, thank you. When you said next year, I suddenly realised we're nearly at the end of the year, so thank you, that's good. I understand that the Fair Work Ombudsman investigation is subject to a 6-year time limitation. Can you advise of the specific legislation, regulation or policy that creates that 6-year time limitation?
Yeah, so that's section 544 of the Fair Work Act, but there's an important distinction to make, and this is one that we've put into our plan. That provision relates to enforceability. So if I can just take you back, if someone puts, as we've received, claims that go back to 2013, that does not prohibit us from investigating back to that period. However, if we were to find underpayment and request an employer or previous employer compensated the employee for their underpayment, we would be restricted or limited by the impact of section 544. So what that really means is, say we had to take someone to court, it would mean that at the time that we file proceedings, and I'm happy for Chief Counsel to help me here, but at the time of filing proceedings, we'd only be able to enforce an underpayment that goes back 6 years.
2018. Okay, thank you.
But it doesn't preclude us investigating historic underpayment.
Well, that's even more encouraging. Thank you so much. So, next question, is the Fair Work Ombudsman able to investigate back beyond, yes, and what would happen? Yes, you've said that. In the One Nation report that detailed coal miners' wage theft, that detailed the way the casual coal miners' underpayments have been justified by people involved, the report identified what was called legal trickery, that argued that because the coal mining award, the Black Coal Mining Industry Award, does not allow for casuals, and that a comparison to what would ordinarily be a casual rate under the award could be ignored. In assessing the claimed underpayments of the International Independent Workers Union of Australia member coal miners, what would be or is the approach of the Fair Work Ombudsman to this legal argument that claims to justify underpayments? What bearing does or would this argument have on the Fair Work Ombudsman's investigations?
So, of the requests for assistance that come from workers who are being assisted by the Independent Workers Union Australia, their argument is that the enterprise agreements are unlawful. There's various reasons they've put forward, and probably in alignment with the report you just held, that the question of whether those agreements are unlawful is outside our scope. And the Chief Counsel, I think on previous occasions, has given evidence to this committee as to why we don't go to second question, nor can we guess the enterprise agreement approval process. What is in scope, what is in jurisdiction for us, is whether there was any coercion or any breach of general protections in the making of an agreement. But as to the foundation or the status of the enterprise agreement, if it's been approved by the Fair Work Commission, we take it as approved. There's a whole range of questions that flow from that, but that's it in summary.
So it's not necessarily compliant with the law just because the Fair Work Commission approves it, but it has been approved.
Chief Counsel, I don't know whether you want to...
Look, Senator Roberts, I think we've traversed, these issues before, but it's the Fair Work Commission that approves agreements, and it's our job to apply the law to any particular case. And as Mr. Ronson said, that is exactly what we're going to do with all of those requests for assistance that have been made. Certainly there have been issues of legal complexity and really going to, which still hasn't been authoritatively determined, what actually is the effect of the Black Coal Mining Award not providing for casual employment in operational roles. And certainly there's been some commentary around that, but it hasn't been formally determined.
Okay, thank you. In undertaking the investigations, will the Fair Work Ombudsman report to the Senate on the progress of the investigations, findings and follow-up, obviously within the bounds of required confidentiality in relation to each miner?
Senator, yeah, very happy to, at these appearances, provide updates, if you like, without jeopardising the integrity of any particular investigations. So it'd be a fairly high level, but more than happy to provide updates.
Thank you. Questions to Minister Watt. When will you start, Minister, your investigation that the Senate ordered in my successful second reading amendment on 16th of May to the government's recent so-called Closing the Loopholes Fair Work Amendment Bill?
I would have to go back and take a look at that, Senator Roberts. I must admit... It was at the time Minister Burke was in the chair. OK, that's probably why I'm not familiar with it. Let me take that on notice and come back to you.
Okay. So I'm surprised that you're not aware of it, so no one in the handover made you aware of it?
Well, I don't remember anything like that in the terms you've described, but Ms Volsky might know.
Yes, so certainly Minister Watt, I think, wrote to us, it was, I think, August it was, so a couple of months ago, in relation to this, tasking us to effectively look at, investigations of underpayments in black coal mining.
Yes, I do remember that now.
Yes.
Sorry, I forgot.
Okay. So you are interested in workers?
I think my record shows I'm pretty interested in workers, including coal mining workers, Senator Roberts. But I sign a lot of letters, but I do remember that one now.
Okay, I can understand. So what's your planned format, terms of reference and scope for the investigation?
That's probably a question for the...
Yeah, so Senator, that's what I'm working on, and that's where we're developing what we're calling an overarching project plan. So currently what we've got at the moment is around 20 workers that have approached already the Fair Work Ombudsman, and obviously each of those persons will be very helpful to our investigation because we'll be able to talk to them about the sector. And if I could just give you a couple of key features of the project plan. One is to identify or map out and identify who are the key players, the key influencers. Senator, you're on the record, for example, of saying that there's 5 labour hire entities of significance that you claim warrant attention.
We think there are more, but we've only investigated 5.
Yeah. Labour hire entities will be obviously a sharp focus for this plan.
Good.
And just of the nature of the industry, there's tensions that we've already just talked about before. There's tensions between entitlements that are owed under the award with those under the enterprise agreement, so that's in scope. And then also we'll be working and talking with other regulators, for example, the Coal Long Service Leave Board, where there are mutual entities of interest, and we might be able to collaborate with that agency to enhance our capability and capacity.
So it's broad, and it's going to be...
Yeah, so there's an overarching plan that will take us around the next 18 months to deliver, but within that, we've already set up, for example, a dedicated email address for anyone in the sector to approach us. We're in communications with the Independent Workers Union. They've already started using the dedicated email address. So we're kind of active and open for business now, but there'll be other initiatives and steps we take to enhance awareness of this investigation.
Okay, I might come up with some more questions, but I put them on notice. Okay, you told us about 18 months. Okay. I referred to the letter from the Independent Workers Union Minister, Independent Workers Union of Australia, to the CFMEU Administrator in relation to the Independent Workers Union of Australia's application to the Fair Work Ombudsman for investigation. You and I were copied, as was Senator Cash, and the activities of the Fair Work Ombudsman in relation to those underpayments. The IWUA sent you a copy. Have you or do you intend to make yourself cognisant of the Fair Work Ombudsman's reviews of the underpayment assessments?
Well, certainly I will no doubt be informed of the result of the work that the Fair Work Ombudsman is doing.
Before the 18 months for the overarching inquiry?
I'm sure that Ombudsman will keep me informed of that, as they do on a range of matters.
Thank you. Have you or do you intend to make yourself cognisant with the One Nation report on this matter, specifically with a view to understanding the CFMEU's role?
I haven't read the report, but you and I have talked about this many, many times at estimates, so I think I've got a bit of an understanding of the issues that you've raised.
You've always been sceptical, but I encourage you to read the report.
I'm sure it's top quality work coming from you, Senator Roberts.
Well, we commissioned it. I didn't do it.
Oh, okay.
I just informed some parts of it.
I'm sure it would have been better if you'd written it yourself.
Have you or do you intend to investigate the historical activities of the CFMEU where the CFMEU either negotiated, oversaw, were aware of, approved, endorsed, or were a party to the agreements that are in discussion?
Look, my recollection, Senator Roberts, is that those complaints that have been made have been investigated previously, and in some cases are still being looked at, and I've got full confidence in the authorities that are looking at those matters.
Well, they haven't been investigated yet.
Well, I think there has been some work looking at the veracity of those allegations. From what I've seen, there's a different view compared to what has been put forward by those group people. I respect the fact that you believe in and support the people who've made those complaints. I guess there's a different point of view.
On notice, could I have copies of that advice, please?
I'll get you anything that we've got, yeah.
Yep, thank you. Have you or do you intend to investigate whether the CFMEU, officers of the CFMEU or persons associated with the CFMEU engaged in any collusive activity such that they conspired with other people or entities to enable the underpayment of casual labour hire coal miners?
Well, again, Senator Roberts, and we should just make the point, when you're talking about the CFMEU, you're talking about what was the mining and energy division of the CFMEU and is obviously now a separate
mining
union.
and energy union now.
Yeah. There's been a lot of discussion about the CFMEU today, and we're not talking about the construction division. Again, my understanding is that a number of those matters have been looked at already, or at least that you've had them referred to authorities, and I'd be relying on the work that's already happened there.
Could you, on notice, give us copies of what you're relying on, please?
I thought, Senator Roberts, that you had actually referred some of these matters to authorities for investigation already. If I'm right in thinking that, I'll come back to you on what's happened. If I'm not right about that, then I'd encourage you to refer those to whether it be the Fair Work Ombudsman or other groups.
The correct avenue is now being followed by the miners.
Exactly. So we'll wait and see the outcome of that.
But if you have anything on what the department has done with it, I'd like to see that.
Sure.
Thank you. Given the alleged extensive criminal activity within the CFMEU, Now, I know that was a different division, but the divisions do talk. Have you or do you intend to investigate whether any criminal activity such as bribes or other, and it seems it could not have happened without this, could have resulted from or was a feature of the CFMEU's involvement with the enterprise agreements and resulting in shameful massive underpayment of casual coal miners?
Well, I don't think anyone has ever produced any evidence of bribes or corruption involving the Mining and Energy Union or previously the Mining Division of the CFMEU. If you've got evidence of that, then I would strongly encourage you to refer that to police for investigation. But I'm not aware of any evidence.
I believe that 2 miners that I accompanied along with the barrister in my office to both the Department of Employment and Workplace Relations and also the former Minister Burke's staff have been given evidence.
Okay, well, I'll take a look at what happened with that. But as I say, if you've got evidence of someone taking a bribe or engaging in corrupt activity, then I'd strongly encourage you to take that to the police. They're the authority who can lay charges.
Do they involve the Fair Work Ombudsman as well? They'd be
I think typically
what
would happen is if we're talking about bribery and corruption and criminal offences, if they came to the attention of the Fair Work Ombudsman, they would refer them to the relevant police. The Fair Work Ombudsman has responsibility for enforcing workplace laws, so offences against the Fair Work Act, but criminal offences, whether it be bribery or any other criminal offence, that's a police matter.
Okay.
Yep.
So this is, to remind you, Senator Watt, Minister Watt, this is Australia's largest wage theft, and it's outside your legislation that's been passed since you came to office, and it's not due to a loophole. To fix the wage theft and prevent recurrence simply requires compliance with the Black Coal Mining Industry Act award. Did the government introduce the so-called closing loopholes bill to hide and bury Australia's largest wage theft case? Because there were no loopholes that enabled this. It was just straight out non-compliance with the award.
No, that's not why we introduced the law.
Okay.
We introduced the closing loopholes laws to, among other things, fix the labour hire rort that was being used by some employers.
And this is the rort, Minister Watt?
Well, what I'm saying is that the purpose of our introducing the legislation was, among other things, the same job, same pay. And as I've pointed out to you before, Senator Roberts, you didn't support that law.
Because there's no loophole. This is the cause of the underpayment. Well, this is the cause of Australia's largest wage theft.
If you didn't think that there was a loophole with coal mining labour hire workers getting underpaid, then I don't agree with you. I think that was a massive loophole that was
just non-compliance with the award. Given the extreme wealth of the CFMEU, have you or do you intend to investigate and consider whether you have at minimum a moral obligation to cause the CFMEU to financially contribute to compensation to affected coal miners who have been underpaid? Can you do that?
I'll take that on notice.
Okay. Can the CFMEU administrator do that?
No, because I wouldn't think so, because the CFMEU administrator is responsible for the construction and general division of the CFMEU, not the Mining and Energy Union, which is a standalone union these days.
Can you last question, Chair. Can you legislate to force those responsible for Australia's largest wage theft case to pay the miners what they're owed?
Well,
if the findings show that.
I guess theoretically governments can legislate on anything as long as they've got a constitutional basis for that legislation.
Oh, pleased to hear that.
You could bring in a private senator's bill. Probably shouldn't have suggested that, should I? But
thank you, Minister Watt. Thank you, Chair.
Good, thank you. Senator Cash.
No, I'll wait for the Fair Work Commission now.
Can I just really quickly, Senator Roberts, we've had a bit of a joke as we've gone along, but we obviously take any report about wage theft seriously, and all I can do is keep encouraging people like yourself. If you've got evidence of things, then there are bodies whose role it is to investigate these things, and I'd encourage you to take them forward.
Yep. Independent Workers Union of Australia is showing its mettle.
Well, they can make complaints to the Fair Work Ombudsman.
And I understand they have.
Yep. Well, we'll wait and see how that goes.
Yep. Thank you.
Good. Thanks very much. Now I can excuse the Fair Work Ombudsman. And we now go to the Fair Work Commission.
Just as fair and we work.
Furlong, and welcome. Would you like to make a opening statement?
Good evening, Chair. No, thank you.
Thank you. I might just have some questions to kick off before I hand over to those to my right. Just looking at this question about the CFMEU construction division.
Yes.
Now, as I understand, the legislation placing the CFMEU construction division into administration contains a series of very powerful anti-avoidance provisions. Can you just take me through what the role of the Fair Work Commission as a regulator and can play in respect of these provisions?
Certainly, Senator. As a result of the Administration Act, I received additional powers in relation to any conduct by any participant that may go to the avoidance of the lawful conduct or direction of the Administrator of the Construction and General Division of the CFMEU. It relates to some of the conduct that may sort of constitute unlawful or may contravene the anti-avoidance provisions. For example, could be an employee within the division leaking information to external participants, including those that may have held offices in the division for the purposes of undermining the administration. It could also be, and depending on the evidence obviously, not following a lawful direction of the administrator. It could be former officials organising activities to undermine the lawful activities of the administrator. But it could also go to the activities of third parties, including corporations, builders, or subcontractors, consultants, who, if have information available to them and they're asked to provide it to the administrator to ensure compliance, lawful compliance with the objectives of the administrator as provided by the scheme, then that could also constitute non-compliance with the anti-avoidance provisions. And there is, from my perspective, there are a civil penalty regime, but powers also rest with the administrator himself, so he can take action as well.
Mm. So, in a nutshell, I don't want to obviously correct me where I've got this wrong, or you may need to expand it. But so basically, is to monitor the potential avoidance activity, investigate complaints, and satisfy that something may constitute an avoidance, refer it to the Fair Work Ombudsman as well. Is that correct?
No, to the Fair Work Commission.
Fair Work Commission. Fair Work Commission.
Yes. Or the administrator also has powers himself to deal with these matters. In the last...
And that includes, that's a question of both individuals and also potentially even employers involved.
Absolutely.
In that avoidance.
Absolutely.
Techniques.
Yeah. As recently as I think it was Monday this week, we're in the process of preparing guidance materials for the industry. I met with one of the major builders last week to talk about some alleged conduct that I've heard in the media about the anti-avoidance provisions as well. And in addition to the guidance materials, I've also written to the ACTU, ACCI, AI Group, Master Builders Association, Civil Contractors Association and the Australian Constructors Association, whose membership are Australia's largest builders, to remind them of what my powers are and what my functions are, responsibilities are under the anti-avoidance provisions under the Administration Act.
Give me quite a good outline there. Is there some other examples, like how would, for example, has been media coverage of shadow officials, and how might that be dealt with?
It goes to the conduct of those former officials. If we were to receive information, and we've spoken to, as I said, one major builder about this already, but if we were to receive information of those former officials trying to organise or trying to undermine the activities, the lawful activities of the administrator, then we welcome any evidence, any information, any intelligence that goes to the possible contravention, and then we can exercise our powers to investigate those matters, and if we satisfy the points of proof and I receive legal advice, independent legal advice, that I have reasonable grounds at least to initiate those proceedings, then I will initiate those proceedings in the federal court.
Does that include the issue of sort of providing things like funds or assets, or what we consider as practical support to those shadow officials, and whether that be individuals or groups of individuals or employers?
We would be very interested in any of those activities, any information. We are yet to receive detailed information about non-compliance with the anti-avoidance provisions as yet.
I know you touched on this, but just so I'm clear, in the event that you receive reports suggesting removed persons are engaging in conduct that may undermine the administration, what could you do about that sort of circumstance?
Well, in those circumstances, we have invited, some of the recent media, we've invited the participants that have been reported in the media. Sorry, we've invited the employer of the participants in the meeting, and these are delegates, to provide information to us about whether or not some of their delegates their activities were in contravention of the anti-avoidance provisions. And in general terms, Senator, and one of the reasons why I wrote to the employer associations earlier this week, I also wrote to the Fair Work Ombudsman as well, and I've had recent conversations with the Administrator and his office as well about our willingness to receive this information. I've recently been giving a number of presentations, including to the membership of employer associations, and one of the things that I've been saying in one of my sort of final slides is that the behaviour or the conduct that you walk past is the behaviour that you accept. And then the conversation sort of necessarily follows that the employers and every participant in the building and construction industry has a role to play in this.
Right. You may have heard some of the evidence or some of the assertions or some of the allegations or some of the matters that have been dealt with, and that's a whole group of different categories, so I'm not trying to isolate to one. During the hearings, even again this afternoon or this evening. This question about facilitating or reports of if an employer is facilitating the activity of former CFMEU officials, and I think in the foremost of our mind, or my mind, I won't speak to anyone, half anyone else, is suggestions of people who have been involved or are involved in criminal activity. Where employers might be also facilitating, supporting, encouraging, or by support, not only by allowing it to happen. And I think that's not a passive thing. That's a proactive thing, allowing something to happen. In my mind, what could you do about that sort of situation?
Well, I could, and it goes to one of the examples in the fact sheet that we're going to be releasing, but it goes to the activities of third parties outside of the Construction General Division, including the delegates. It goes to other participants, all other participants in the building and construction industry. So if there are builders, as I said, if there are contractors, if there's sub-consultants who are participating in activity that may undermine the lawful objectives of the administrator as prescribed by the scheme, then we will investigate it and we'll use our powers to gather the evidence required to contemplate initiating civil penalty proceedings.
Is that saying it takes two to tango? Both people tangoing needs to be held to account.
Yes, and the anti-avoidance provisions go to that, and the invitation to and I'm happy to table a copy of this letter that I sent out to the Fair Work Ombudsman, as I said, the employer associations, the ACTU, for distribution through their affiliates and their membership to ensure that everyone's aware of their rights and their obligations under the anti-avoidance provisions.
And, you know, and I ask these questions in the context that, you know, this is an industry which I've asked many questions over the years since I've been in this place, and also worked in the construction industry as an official in a different union. I know how tough it is, and I've run across different characters over those years. And, you know, it's extremely important to be mindful of all the people that make up this industry, and when complaints are made, how they're dealt with, and dealt with in an appropriate fashion. I know you've touched on this, but I just want to just be really clear in my head. If you were satisfied that there were any conduct that required to investigate allegations or complaints about inappropriate activity, for example, people removed as a result of the administration. If you're satisfied that any conduct constituted avoidance conduct, what could you do to enforce the provisions of this bill? Just so I'm very clear.
Well, I would, through my delegation of powers to senior officials, specialised in investigation and operations experience, would gather evidence, and then through that process that would involve, I imagine, serving notices produced, requiring people to attend and give evidence under oath, and any other sort of operational activity that my delegates determined to be appropriate in the circumstances to hold that conduct to account.
I've got no further questions.
Thank you. I will just build.
Oh, sorry.
Very briefly, Senator Chris Enright, I'm Executive Director. To underscore the seriousness of what the General Manager is talking about is a civil penalty of $187,000 it can apply to an individual, or a civil penalty of $939,000, just under $1 million, can apply to a body corporate for those provisions, and they're the civil provisions, and there are also criminal penalties of imprisonment for up to 2 years that can be applicable, Senator, just to underscore what the General Manager is saying about how serious the matters are.
Thank you, Mr Enright.
Thank you, Chair, and thank you, Mr Furlong, for that information. Just building on the questions in relation to the use of the anti-avoidance provisions, has any regulator or person commenced any investigation or proceeding under those provisions yet?
Not that I'm aware of, Senator. Bear in mind that the administration has only been in operation for a period of about 10 weeks now.
Yep, understood. In relation to the 12 CFMEU officials who have been terminated, there are a number of reports, and they're being referred to now as the leaders in exile, and that is the 12 officials who were sacked and yet still remain operating or influential in the industry. Are you aware of those reports?
I'm aware of those reports.
Yep. So just in terms of the anti-avoidance provisions then, are you investigating those reports proactively?
We have sought, yes, we've sought, and I'll use the terminology, we have sought information from industry participants in relation to the conduct of some of those former officials, yes.
Thank you. And just in relation again to the anti-avoidance powers, under the scheme of administration, who has the capacity to bring prosecutions?
Myself.
Yes.
And the administrator.
Yourself and the administrator. Okay. Nobody else?
Not that I'm aware of.
No, that's okay. Take it on. Thank you very much. And in terms of any potential information or investigation that you're undertaking, you said you have written out to building industry participants, etc. For people to come forward, are there adequate protections in place for them so that they can provide you with the information that you are going to need? Because I understand you are going to need evidence to be able to bring forward these prosecutions. And are you satisfied that those protections are enough?
A couple of things I'd just like to touch on here. In terms of the accessibility, if you jump on the Fair Work Commission website, there's a banner up the top about making a complaint about the Construction General Division. So it is through that mechanism. There is also an info line that would be established. The administrator has also established a complaints handling function with a whistleblower function associated with it, and released policies in relation to that as well. I'll ask Mr Enright to speak to the whistleblower scheme and the protections available under that. But we, since we established our online
The online portal?
Handling. Yeah, exactly. We have received a significant number of complaints and pieces of intelligence. There's been over 700 submissions that have been made to that, and of that 700, we have referred over 230 matters to other agencies. Now,
and when you say other agencies, what does that encapsulate?
The vast majority have gone to the Fair Work Ombudsman. I'll ask Mr Enright to provide information on the other regulators and law enforcement bodies that have that were referred those matters to as well. The other thing I'd just like to mention in terms of the process and the sharing of information about complaints handling, we recently received a correspondence from the Australian Federal Police requesting our participation, or to nominate a senior official in the Commission to participate in what is called a Joint Agency Working Group, or a JORG. Now, we've nominated Mr Enright to participate in that Joint Agency Working Group, and my understanding is that group will be convened in the coming weeks.
Okay, thank you very much.
And in terms of information sharing about anti-avoidance and things of that nature, whatever contravention, whatever information about any allegation about possible contraventions of the anti-avoidance provisions, or any contraventions of the Registered Organisations Act that I'm responsible for, or the Fair Work Act that the Fair Work Ombudsman is responsible for, or the WH Act, or whatever the case may be, there will be appropriate sort of mechanisms in place for the sharing of information.
And that's what's been worked on by the moment, and that's what Mr Enright will be sitting on as the committee.
That's right. So Mr Enright can provide some information on the whistleblowing functions and protections. Mr Enright?
Thank you, Senator. So the Fair Work Registered Organisations Act has contained a extensive whistleblower scheme for a number of years now. That scheme applies to individuals, members of registered organisations, former members of registered organisations, contractors, and a range of people, provided those disclosures are made to either certain bodies, including the Fair Work Commission. So it's an extensive scheme, Senator. We've been, and I could take you to some current the current workload we have in relation to protected disclosures or whistleblower disclosures, but it provides protections to people making these disclosures, and those protections have been extended into the administrators area for people who make protections.
And that was under the scheme of administration?
Exactly, Senator, yes.
Can I just ask, and Mr Furlong, this might also go to you, in the course of the Fair Work Commission receiving reports about the CFMEU, or indeed people building industry participants, so in terms of the administration, and undertaking investigations, have you to date encountered any limitations on your powers as the General Manager under the current law to take appropriate action?
Perhaps if I give you the figures, Senator, that Mr Furlong was talking about a few moments ago, in terms of when, as soon as Mr Furlong established as the General Manager that conduit or that form on the Commission's website.
The portal? We are talking about the portal?
That portal is the form available, Senator, yes. We've received 793 responses to that dedicated portal. Of those, this is as of the 31st of October, recently. As at that time, 205 matters have been referred to the Fair Work Ombudsman for further consideration. First of all, Senator, every one of these 793, we've conducted an assessment of all of the information, and we've determined what the most appropriate action to take. So 205 have gone to the Fair Work Ombudsman, 12 matters have been referred to the Australian Federal Police, 3 matters to the Australian Competition and Consumer Commission,
Australian Competition and Communication,
the ACCC, Senator, and 1 matter to the Work Health and Safety Queensland. So, as well as that, we've engaged with other government agencies with oversight of significant projects in the industry in relation to their roles in ensuring compliance. So when we receive information that doesn't fall within what we think is a jurisdiction of a particular agency but is relevant to a participant in the industry, we've referred information to the Victorian Infrastructure Delivery Authority, the Cross River, that's in Victoria obviously, Senator, the Cross River Rail Delivery Authority in Queensland, and my computer's just gone off. And Mr. Furlong, is in his role as the General Manager, has also written to the heads of workplace safety authorities in relation to information that we've received, and has also communicated information to the Administrator.
Thank you very much for that. Just going back, Mr. Furlong, to my question, have you encountered any limitations on your powers as General Manager under the current law to take appropriate action in response to the matters that are coming to you?
As I indicated, the administration is still in its early days. So
yes, no, I understand that.
Into it, and so in that context, I would have to say that in the absence of receiving to this point in time detailed evidence that we can action on the basis, as we just discussed, that the Joint Agency Working Group has been established and these mechanisms for communicating across law enforcement and regulators is being established. It's just probably a little bit too early for me to give you any sort of any detailed response with any real substance there, Senator.
I'll have to shortly go to Senator Payman
before we go on the break. Lot, and then I'm moving on from powers.
Yeah, that's good. Yeah.
Have you made any recommendations to the Minister to alter or expand your powers?
No, but as the normal course of things, we engage closely with the department on resources and resourcing requirements and other sort of matters pertaining to my functions as the regulator of registered organisations.
And has the Minister inquired if you have all the powers you need and you believe they're adequate?
I'd need to take that on notice, and I'm not too sure what conversations I've had with officials in the organisation. But
the
in the
Minister
normal course of
sitting next to you.
In the normal course of things, it wouldn't be through a communication that I would have directly with the Minister, and I certainly can't recall any conversation that I've had with the Minister about that at this point in time, bearing in mind that the administration has only been in place for 10 weeks.
No, I understand. Minister, have you inquired with the Fair Work Commission as to whether or not they do have all the powers they need?
Again, I'll take that on notice just to check my records. I don't recall asking that, but as Mr. Furlong said, there are discussions that happen between my office, Mr. Furlong, his team, department, so I'm not sure whether anything might have been raised there.
Thank you.
Good, thanks very much. Senator Payman.
Thank you, Chair. Good evening. Let's hope fourth time lucky. My questions relate to the amendments to the Fair Work Registered Organisations Act 2009. The amendments that were made this year, which enabled the construction and general division of the CFMEU to be put into administration. Under Section 323HA of the Act, how many complaints has the Administrator received regarding the actions of the members of the CFMEU?
The Administration, and I'd like to table a report that I received from the Administrator on Monday of this week that outlines some of his activities and that of his office. If you would just persist, I'd actually like to go through a number of these activities. I'm mindful of time as well, and I'll ask for it to be tabled now, please.
Thank you.
But the report indicates the Administrator has facilitated the application of enterprise agreements to the Commission, and from our records at the Commission, we can confirm that approximately 300 applications for approval of enterprise agreements have been received since the administration commenced 10 weeks ago. We've also been advised that we can expect a further 350 applications by the end of the calendar year. This equates to approximately 7 enterprise agreement applications made for every working day since the administration commenced to the end of the year. The Administrator has advised that they've recovered $3.5 million in member funds from third parties.
So what was that, $3.5 million in
members' funds?
Members' funds.
Yep, from third parties. The report highlights the urgent need for enhanced worker safety, including the tragedy of lives lost at work in the building and construction industry. He has established a whistleblowing and complaints handling system and policy. He's initiated disciplinary, this goes to your specific question, initiated disciplinary processes, some of which have resulted in the termination of some CFMEU employees. He has commenced investigations into alleged conduct in South Australia, Queensland, New South Wales and Victoria. He has developed and released an interim menacing conduct policy, including issuing directions through his executive officers to all organisers prohibiting menacing conduct in their operations. He's also released the interim report of Jeffrey Watson SC and the Administrator's substantive response to that report. Now, these documents are available on the CFMEU's website, and the Administrator's engaged Mr. Watson SC to continue his investigations into in a number of things, including the alleged infiltration of elements of organised crime into the division. The Administrator and his staff have also communicated and met, and they continue to meet with a wide range of people across the division and the building construction industry more broadly. Now, in terms of the operations of the Administrator, the Administrator is responsible for the activities of the Construction and General Division of the CFMEU. He's operating independent of government and will make decisions as he sees fit in accordance with the laws that under the Administration Act, but also the Registered Organisation Act and all other laws that apply to the lawful conduct of that union.
So 300 applications have been received. How many investigations have been initiated since those complaints or applications were submitted? Because you did mention a few examples, but do you have a figure of how many investigations?
Just to clarify there, the number 300 is the applications that we've received, enterprise agreement applications, which is a core function of the union in representing the interests of members. So what I'm saying is that the Commission, the Fair Work Commission, has received approximately 300 applications to approve enterprise agreements.
So not complaints?
They're not complaints. And
I think your question, Senator Payman, was how many complaints had the Administrator received?
Yes.
I'm not sure that, I think the figures that Mr Furlong has given you relates to matters that the Fair Work Commission has received rather than the Administrator.
Right. So are you able to answer questions on behalf of the Administrator?
No. The Administrator is operating independently of government. And in terms of the complaints that, the number of complaints that he
But you don't represent the
received,
government as the Fair Work Commission, right?
No, I'm an independent statutory office holder.
Yeah, exactly. And so would you have oversight on the amount of complaints that the Administrator has received? I mean, you've had the report from the Administrator provided to you.
And I've tabled that, Senator.
Yeah.
My role under the Administration Act was outlined in a statement that I issued a number of weeks ago on the 3rd of October. One of the areas that it goes to is the effective implementation of the scheme, and that if I'm satisfied that there are reasonable grounds to do so, I may investigate whether the scheme is being effectively implemented. Notwithstanding that, the Administrator does not report to me, does not report to the government. He is responsible for the operations of the Construction and General Division and operates at arm's length from and is independent from the government.
Having said that, the legislation requires the Administrator to provide me with a report every 6 months that will be tabled in Parliament. So it'll be a matter for the Administrator what he includes in that report, but that's the public reporting mechanism.
And so how do we get updates from the Administrator and hold them to account in terms of how they are utilising the hard-earned members' money and funds to actually deliver the outcome that they're set up to achieve? Because if there's no oversight body, are we saying that this administration is just free to do what it wants? And we've heard earlier, we've had this discussion where the millions that are going into funding not just the salaries of some officials that I've outlined earlier, but the Administrator himself. So where is the oversight?
It's by providing, he will be providing 6 monthly reports effectively to the Parliament through me.
In addition to that, Senator, the Administrator holds all the responsibilities that the division would normally have under the Registered Organisations Act. And as the regulator of all registered organisations, that's employer associations and unions, the division is still required to meet all of their obligations under that Act.
So until we receive the 6 monthly report, we won't know how many findings of corruption or criminality that the Administrator may have found over the months of work it's doing. Is that what I'm hearing?
That's probably right, bearing in mind that we've already had last night and today a number of different authorities provide evidence on the number of allegations they're investigating, the charges they're laying. So the Administrator plays one role in this, but police matters are going to be prosecuted, or charges will be laid by the police. The AFP have given evidence on where they're up to. The Fair Work Ombudsman just gave evidence on where they're up to. The Fair Work Commission has done the same. So it's not as if it's the Administrator who is the only person who has a role in this process.
You'd think that they would have a direct role and would report back at least sooner than 6 months, because, not much movement's happening. Chair, that's all from me.
Good, thanks. We'll now go on our evening break.
Are we there already?
We're there already because we've been. Yeah, it says I need the 10 minutes. So for 10 minutes until 8:27.
8:27. Wow, that seemed to really fly.
And I'll go to Senator Roberts.
Thank you, Chair. Thank you. Thank you, Mr. Furlong, for being here again, and your staff. I'm interested in exploring the nature of labour hire arrangements and their relationship with associated awards, and also partly the CFMEU administrator. What's the total number of labour hire arrangements currently before the Commission to date?
I might start here and then ask Ms Scarlett to assist. My understanding is that to 30th September we've received 55 applications for regulated labour hire agreement orders, or authorisation orders, sorry.
So what do you mean by regulated? Does that mean?
Of that number.
No, what's the regulated refer to?
Pardon?
What does the term regulated refer to?
Well, that's the
Come
term
before you
given
guys?
under the Secure Jobs Better Pay.
Okay.
Oh, sorry, the loopholes Mark 1.
Thank you.
Changes. And in terms of the number of applications or orders that have been made, there are 11. 9 of them, I understand, are in the mining industry, and 2 are in the meat processing industry. Ms Scarlett, is anything like that?
So that number was 50. 50 how many?
55,
Thank
Senator.
you.
Senator, Catherine Scarlett, Executive Director, Legal Performance and Engagement. As Mr Furlong has said, 11 labour hire arrangement orders have been issued since the commencement of the provisions.
What sort of orders?
Regulated labour hire arrangement orders.
Thank you.
Of the 55 applications, 11 orders have been made. A number of applications have been withdrawn, and the remaining matters remain before the Commission.
Thank you. What's the breakdown of these labour hire arrangement orders for each award that would otherwise have covered the employees?
Senator,
might have to take that on notice.
Yeah, I'm not sure that we can go to the award. The regulated labour hire arrangement orders compare the apply where there is a covered employment instrument in place, such as an enterprise agreement. So there's not necessarily an assessment of the award that applies, rather whether an enterprise agreement's in place that would cover the work of the labour hire employees if they were working in the business.
The enterprise agreement would be in an industry or work site that is covered by an award, but the enterprise agreement supersedes the award, right?
That's correct, Senator.
So would there be any such sites that only have an enterprise agreement and no backup award?
Senator, I don't believe there would be, but I need to take that on notice.
If you could, please. I'd like to know the connection to the award, or to the award that would be in place if the enterprise agreement wasn't there.
I understand.
Thank you. Can you advise if there would be a general expectation that anyone working as a casual should or would receive 25% more than a full-time employee doing similar or the same work?
Senator, the regulated labour hire arrangement order provisions provide for a 25% casual loading for regulated labour hire employees.
Casuals. Okay, thank you. Can you advise if there is a specific legislation, regulation or policy that requires that a casual employee should or would receive 25% more than a full-time employee doing similar or the same work? I know it's a community expectation and it's a right almost, but is it enshrined in law or statute or policy?
Senator, I'm not aware of a specific provision in legislation that requires a 25% loading.
Are you able to check that?
Yes.
You take that on notice to check it. Is it fairly normal that awards require casual employees to receive 25% more than a full-time employee doing similar or the same work? Can you point to any award that does not require a casual employee to be paid 25% more than a full-time employee doing similar or the same work?
I can't point to an award, but happily take that on notice. There are 155 modern awards, Senator.
Yeah. So I'd like to know if that's normal.
So can I just clarify the question so we make sure that we provide you with the information that you
Thank you.
require?
Is it fairly normal that awards require casual employees to receive 25% more than a full-time employee doing similar or the same work? That's the first part.
Yes. Okay, yeah.
And the second part, can you point to any award that does not require a casual employee to be paid 25% more than a full-time employee doing similar or same work?
Happy to take a notice.
Yep. Thank you, Mr. Furlong. In applying the Better Off Overall test, the boot test, to enterprise agreement applications, would it be the normal expectation of the Fair Work Commission that in having regard to pay rates of casual workers, that casual employees should or would receive 25% more than a full-time employee doing similar or the same work?
I'll ask Mr Corcoran to assist you there, Senator.
Robert Corcoran, Acting Executive Director, Tribunal Support Branch. Senator, each application is considered on its own merits by the member. They take into account the circumstances in its entirety. It's not a line-by-line assessment that the member will make. The boot is the Better Off Overall test is a global assessment.
Global assessment. Okay. Thank you. If an award did not allow for casual employment, would this create the circumstance in which casual employees working under enterprise agreements subject to the said award would be paid less than full-time employees and or be paid a rate that would be less than a full-time employee plus 25%?
An employee wouldn't be paid, a casual employee wouldn't be paid less than a full-time employee, I wouldn't have thought, in normal circumstances.
Really? Casual employee would be paid less than a full-time?
I thought they would not have been paid less.
Oh, sorry. And it would be, they'd be paid what the full-time gets plus 25%?
Senator, I think that some of these questions, I return to the correspondence that I provided to you on the 11th of January this year regarding information published, obviously on your website, but also about relating to the Better Off Overall test and the Channel McLeod Northern District of New South Wales by Coal Mining Agreement 2015. I'm not too sure if you still have access to that correspondence.
I do, and it's sitting on my desk.
Yeah, okay. This,
with an intent to reply.
This series of questions were covered in that correspondence,
Okay.
and I'm happy to table if that would assist as well.
No, that's fine. I know exactly where it is on my desk.
Okay, thank you.
Can you envisage a circumstance in which, if a union objected to an enterprise agreement, because the pay rate of casuals would be less than that of a full-time employee plus 25%, that the Fair Work Commission would ignore the objections of the union and endorse the agreement despite the union's objections?
Do you mind if I, and as we've discussed several times, the Better Off Overall test is, as Mr Corcoran said, it's a global assessment to ensure that the employees are better off overall. It is always determined by a member of the Commission. Members, as you're aware, are independent statutory office holders who are required to ensure that in their decisions they are satisfying the obligations, the functions, prescribed content of the enterprise agreements before they can be satisfied and then ultimately approve the decision to make the agreement operational. Now, if a party is to that agreement, or someone who has an interest in that agreement, a valid interest in the agreement, is unsatisfied or has a concern with that agreement application, they can seek to have the agreement overturned through the mechanism of an appeal, and that is their right. The other thing that I'd just like to add here...
Excuse me,
Senator,
just to answer that question. Would the Commission ignore the objections in assessing the enterprise agreement? Would the Commission ignore the objections of the union as part of that? If the union, I'm not talking about passing it and then objecting, I'm talking about objecting as they're processing it.
Prior to the application being made, it would be the subject of deliberation of a member before the tribunal.
It'd be pretty unlikely though, wouldn't it?
Well, I can't speak on behalf of members and in their independent statutory decision making.
Have you ever seen a member overturn a union objection?
As we've discussed, my role is to provide administrative support to the President of the Commission to ensure...
It'd be pretty unlikely, wouldn't it?
I can't answer that, Senator.
Okay. All right, so I cut you off there.
I was just going to say that if an agreement has reached or passed its nominal expiry date, then a party to that agreement can seek to have the agreement unilaterally terminated,
Yep.
And then they will fall back to the underpinning award, or they can obviously have the right to negotiate a new enterprise agreement.
I think what I'm getting at, thank you for the extra detail. It goes beyond what I'm looking for, outside what I'm looking for. If a union, in the process of getting approval for an enterprise agreement, if a union, by the Fair Work Commission, if a union objected to an enterprise agreement because the pay rate of casuals would be less than that of a full-time employee plus 25%, then the Fair Work Commission would hardly ignore the objections of the union and endorse the agreement despite the union's objections.
It's a case-by-case basis on the information that's provided to the members in the consideration of whether or not
what would be
they
the
should approve
likelihood?
agreement applications.
What would be the have you heard of any?
As I said, Senator, it's not my role to sort of comment on cases that are determined by members of the Commission. It's my role, my responsibility to provide the President with administrative support as the General Manager to ensure that the Commission can operate effectively.
I'm not asking you for your opinion.
So I can't comment on cases that come before the Commission that I deal with.
I'm not asking you to. I'm not asking for your opinion on the member making the decision. I'm asking, would it happen? Has it happened?
I don't have any oversight of particular cases that move through the tribunal side of the
Would anyone else care to comment? It would seem to me to be almost impossible. I won't say it is impossible, but...
Senator, I would say that a member would always consider the views of the parties, but ultimately the member must be satisfied that the requirements of the Act have been
Thank you. I have some questions, I think for the Minister, and I think most of them will be pretty simple, Minister. I'd like to table this letter from the Independent Workers Union of Australia. Who do I... Thank you. It's a letter that was sent to the CFMEU Administrator, copied to you, me and Senator Cash. I think these will be fairly simple, given your background, Minister. Why is the CFMEU Administrator not here at Senate estimates?
Well, they're not a public official. I mean, if you look at I think pretty much every person who attends estimates is either a minister or a public official, public servant. The administrator is not a public servant. I mean, there's probably other reasons, but that would be one of them.
Who pays his salary?